ಮತ್ತೆ ಏನ್ ಸಮಾಚಾರ ಏನಿಲ್ಲ, ನೀನ್ ಹೇಳ್ಬೇಕು.
ಬರೋಣ ಕಡೆ ಸ್ವಲ್ಪ ಕೆಲಸ ಇತ್ತು ಅಲ್ಲಿ
ಯಾರು? ಬಿಡ
ಬಿಡ ಅದಕ್ಕೆ ಏನು ಮಾಡೋಕ್ಕಾಗಲ್ಲ. ಬರೋಕ್ಕಿಲ್ಲ ಅಲ್ಲಿ ಬಂದರು ಯಾಕೆ ಸರ್ ಸರ್ ಇರ್ಬೇಕಾದ್ರೆ ಅಲ್ಲಿ ಬರ್ತಿದ್ರ ಯಾಕೆ ಬರ್ತಿಲ್ಲ ಅದೆಲ್ಲ ಕೇಳಿದ್ದಾರೆ. ಅದಕ್ಕೆ ಬೇಡ ಹೋಗು ಆಮೇಲೆ ಮಾತಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ಕಳ್ಸಿದ್ದು.
Yeah, okay.
हाँ. Yes, please.
And move the matter yesterday or test matter.
हाँ.
Another pending matter is coming up on Monday.
But if this matter is not heard today, the present petition will be rendered effective.
ಯಾಕೆ ಬಂದಿಲ್ಲ ಅದು? Why it is not listed? It was moved yesterday. ಯಾಕೆ ಚೆಕ್ ಮಾಡ್ರಿ?
My lord, 2024.
On 16th.
Yes.
16th come.
So 2017 OS not pending matter. Petitioner is 78-year-old.
No, what is the urgency?
Stamp duty issue is already covered up matter. And the trial.
Let it come on Monday. It will come on Monday.
Madam, 230 million.
ಏನು
Application, I filed an application at 2158 million that has came to be rejected. Delivery warrant has been issued, million.
I thought through the
My lord, 24 matter, commercial court matter. It was listed on Monday. This honorable court directed to serve the copy to respondent and move again. Because the order 7 rule 11 ಮೇಲೆ Mondayನೇ ಇದೆ my lord. ಇಲ್ಲಾಂದ್ರೆ infectious ಆಗುತ್ತೆ petition. Kindly consider
I told Monday.
Monday.
One matter, my lord, by an interim order, further construction is stalled by both the courts. But anyway, I am residing there. A major portion of the building is plastered. It has become unbearable to live in. So I am only seeking interim prayer, which is not, which is now.
I tell you, it will come on Monday, Tuesday.
Monday.
Tuesday, sorry.
For the year 2009, my lord.
Yes, ma'am.
Now, portion for the argument.
Next week I'll have on date food. Suit is filed in 2017. Told.
Vacating the
Purpose of the suit.
Yes, sir.
Extension of interim order.
Then extension of interim order, yes.
vacating application I filed before this court in the month of November. It is not yet posted.
Suit is filed in which year?
The suit, it is execution. Attachment of salary warrant is issued against the Tahsildar, against which the writ petition is filed. The Tahsildar filed a memo in the execution court saying that he will obey the judgment passed by the trial court, affecting the kata in the name of the petitioners. In spite of that, they have not done so. Then the arrest warrant is issued and salary warrant is issued.
It's not one matter for admission.
For Tuesday, please.
2019 suit, my lord, partition suit. Amendment application is filed saying that to include the plaintiff as amendment application.
To
Now
include
there is
the-
a stay, my lord. Now the respondent,
Let it
respondent
come
is
after vacation.
85-year-old.
ಏನ್ ಮಾಡಕ್ಕಾಗ? Let it come after vacation.
It's a commercial execution matter. On Tuesday, it is posted for hearing on order 21 rule 37 38 for the civil imprisonment of JDR. my lord. And Tuesday,
I told, yes. Already, order is passed.
no, my lord, it was posted for hearing on that IM. my lord.
Oh, what is challenged then?
Huh?
What have you challenged?
Civil imprisonment ಗೆ
Order ಆಗಿದ್ಯಾ ಆಗ್ಲೇ?
no, ಇಲ್ಲ ಮಳೆ.
ಹಾ.
Tuesday ಅದನ್ನ hearing ಗೆ post ಹಾಕೊಂಡಿದೆ, ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾರೆ ಅಂತ.
ಅದಕ್ಕೆ
ಅವತ್ತು
what have you challenged in the petition?
ಆ,
Writ petition ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದೀರಾ?
ಅದಷ್ಟು stay the
What have you challenged in the writ petition? Writ petition ಏನ್ ರಿಲೀಫ್ ಕೇಳಿದ್ಯಪ್ಪ?
execution the 134 by 24 ಅದು stay entire.
ಸ್ವಲ್ಪ ನೋಡ್ಕೊಂಡು ಹೇಳಿ ಕ್ಲೀನ್ ಸಬ್ಮಿಷನ್.
My lord, this writ petition filed in 22, my lord. There is a application filed by them to recall the DW1. They have been disallowed. That's why I filed the writ petition. It is a senior citizen, lady, widow.
Suit is filed in which year?
Which is 21.
ಬರುತ್ತೆ ಮತ್ತೆ, yes.
It is filed in 2013.
ಅದೇ told 2013.
The injunction order is acting against me, Your Honor.
Ah.
Suit is of the year 2022. I am stopped from constructing the wall. I have already expended the.
I told, yes.
Judgment in 1812, sir. Judgment posted in 1812. The
Suit
process
is
of
filed for
failed.
Suit is posted for judgment.
Yes, sir. The process is failed, sir.
Huh?
The suit process is failed, sir. So need agents.
ಏನಂತೆ? ಮೈಕ್ ಯೂಸ್ ಮಾಡಿ. ಮೈಕ್ ಯೂಸ್ ಮಾಡಿ ಧೈರ್ಯವಾಗಿ ಹೇಳಿ, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. ಟೇಕ್ ಯುವರ್ ಟೈಮ್.
Judgment has posted in 12.
ಎಲ್ಲರೂ ನಿಮ್ ತರನೇ ಶುರು ಮಾಡಿರೋದು. ನಿಧಾನಕ್ಕೆ ಹೇಳಿ, ಏನ್ ತಪ್ಪಾದ್ರೆ ಏನ್ ತಪ್ಪಾಗಲ್ಲ. Suit is posted for judgment
Yes, sir.
on 18
The
December.
process is
What
failed.
do you want? ಏನ್ ಬೇಕು?
Urgency ಇದೆ, sir. Need, the process is failed, sir.
ಏನ್ ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
Suit file.
ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ರಿಜೆಕ್ಟ್ ಆಗಿ ಏನ್ ತೊಂದರೆ ಆಗಿದೆಯಾ? ಗಾಬರಿ ಆಗ್ಬೇಡಿ. ಗಾಬರಿ ಆಗ್ಬೇಡಿ, ನಿಧಾನ ಕೇಳಿ. I told, yes. ಅದು ಫೈಲ್ ಓದ್ಕೊಂಬರ್ಬೇಕಮ್ಮ. ಫೈಲ್ ಓದ್ಕೊಂಬರ್ಬೇಕು.
ಇವತ್ತು ಡೇಟ್
ಹಾ?
ಇವತ್ತು ಡೇಟ್ ಕೊಟ್ಟಿದ್ರಿ ತಾವು ಎಸ್ಟರ್ಡೇ ಇತ್ತು.
ಯಾಕೆ
ಆದ್ರೆ
ಬಂದಿಲ್ಲ
ಬರ್ಲಿಲ್ಲ.
ನೋಡು. Suit is? Told again 2004 suit. Yes.
My lords, 2015 suit for partition, my lords. Amendment application allow agide, my lords. They are seeking to delete defendant number 9 and 10 on grounds of compromise with the plaintiff. We have challenged we have raised objections. Our objections have not been considered. We have challenged the allowing of the application.
Yeah, I told, yes. Date. Suit is filed in which year? Let it come. So all right, mister, you can move it after vacation. Yes, next.
ಇಲ್ಲ ಸರಿ ಮೇಲೆ ಮೇ ಸಬ್ಮಿಟ್ ರಿಪೀಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು IA 1 ಫೈಲ್ ಮಾಡಿರೋದು ನಾವು ಸೀಕಿಂಗ್ ಕ್ವಶನ್ಸ್ ಅರೈಸಿಂಗ್ ಬಿಟ್ವೀನ್ ದಿ ಪಾರ್ಟೀಸ್ ಅದ್ರ ಮೇಲೆ ಡಿಸೈಡ್ ಮಾಡಿ ಅಂತ IA ಹಾಕೊಂಡಿದ್ದೀವಿ ನಾವು. ಅದು ರಿಜೆಕ್ಟ್ ಆಗಿದೆ. ಅದ್ರ ಮೇಲೆ
ಆಯ್ತು. ಅದಿನ್ನ ವೆಕೇಶನ್ ಬರ್ಬೋದಲ್ಲ, ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಬರ್ಬೋದು ತಾನೆ.
IA DHR ಫೈಲ್ ಮಾಡಿರೋದು
ಡಿಸೈಡ್ ಮಾಡಿಲ್ಲ ಅದಿನ್ನ.
ಇಲ್ಲ, ಅದು ಟ್ಯೂಸ್ಡೇಗೆ ಹಿಯರಿಂಗ್ ಹಾಕೊಂಡಿದ್ದಾರೆ.
ಅದಾದ್ಮೇಲೆ ಬರ್ಬೋದಲ್ಲ. You can come later.
Next week any date.
You can come after vacation. Yes, next.
Adjournments phase wise list number 1.
Criminal petition ಮೇಲೆ.
Criminal petition.
ಅರ್ಲಿಯರ್ ಕೇಸಲ್ಲಿ ಇದೇ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಸೈಡ್ ಆಯ್ತು, ಮೆರಿಟ್ ಮೇಲೆ ಡಿಸೈಡ್ ಆಗಿಲ್ಲ.
My lord, this is a fresh matter, my lord.
If it's a fresh matter, hand over the memo. Yes, next.
Adjournments phase wise list number 1, page number 13, serial number 56 to 58.
Serial number 1, sir.
Page number 14, serial number 59 to 67. Page number 15, serial number 58 to 71. Page number 16, serial number 72 to 74. Page number 17, serial number 75. Page number 18, serial number 76 to 78. Page number 19, serial number 79 to 83. Page number 20, serial number 84 to 89.
Serial number 84, I am appearing for the respond number 9. While objection, week's time may be granted. Other side is intimated.
Learn counsel for the respondents 1, 2, 3.
9, sir.
Respond number 9, 6 time.
For the application to objections, trial court. ಈಗ objections.
ಆಯ್ತು, ಇವಾಗ you are not objected before the trial court.
I filed my objections, man. I'm the necessary, I'm the absolute owner of the property.
Sir, but you did not object before the trial court.
Anyhow, I filed my objection.
List after vacation, interim order granted rejection to the next.
My lord, serial number 88. Serial number 88, my lord. Appearing for the petition, my lord. My lord, prays for a week's time.
Petition, learn counsel for petition 6 time, list after vacation.
My lord, serial number 1. Kindly have it on Monday.
Page number 21, serial number 90 to 95. Page number 22, serial number 96 to 103.
Lord, 96, my lord. A week time may be given. I have informed other side.
Learn counsel for the petition 6 time, list after summer, winter vacation.
Page
101. Naveed Ahmad. Learn counsel for the petition 6 time. Our other side intimate ಮಾಡಬೇಕು. List after winter vacation. Yes, interim order granted as extend to the next.
Page number 23, serial number 106 to 104 to 109. Page number 24, serial number 110 to 117.
My lord, serial number 116, my lord. Next week.
List after vacation.
Interim order.
Interim order extend to the next day.
Page number
Serial number 114, my lord. Respondent number 1 and 2. 2 weeks time.
Ajay Kumar. BV Ramu. Learn counsel for the response 1 and 2 6. Ajay Kumar ತಿಳಿಸಬೇಕು. 6 time, list after winter vacation. Interim order ಇದೆ ನೋಡಿ, check ಮಾಡಿ. Yes.
Page number 25, serial number 118.
Correct.
List number 1 for non-compliance office objection first time, serial number 1 to 10.
I have serial number.
ಆಯ್ತು, ಒಂದು ಕರೀರಿ number 1.
Serial number 1. Abhiraj B.
I have for respondent, my lord.
1 week time is granted to.
I appear for the petitioners in this case, my lord. Well, objections have been complied, my lord.
Learn counsel for the petition.
They have not served the copy, my lord.
Plaintiff number 2 is not made as a party in the petition to be clarified. If you want to clarify, you clarify. 1 week time is granted to do the needful.
My lord, date may be fixed, my lord, maybe taken next
you
week, my
please
lord,
complete it, Mr.
Thursday, my lord.
Complete.
Serial number 2, Ravindra
Lord, I
BS.
appear
Yes,
for
ma'am.
petition, my lord. I have complied with the office objection. Only point is, my
The
lord.
learned counsel for the petition submits that office objection is complete. Office directed to check, verify
My lord, short
and list
point is
for
involved, my lord.
preliminary hearing on yavat week,
Next week, my lord.
next week.
My lord, next Thursday, my lord.
Next.
Serial number 3,
Appear for the
Shruti
petition.
SP.
Your lordship,
Let me-
only one, two office objections were there.
Huh?
Repeated the,
Jurisdiction to be stated correctly, double pagination to be removed, all advocate to accept the wakalat.
more.
Madi-
Monday, your lordship,
Vinay, ನಾನು
ಅಲ್ಲ.
without asking a question, ನಾನು interim order ಕೊಡ್ತಾ ಇದ್ದೆ, but ಲಾಯರ್ಗಳು ಕಂಪ್ಲೈ ಮಾಡ್ತಿರ್ಲಿಲ್ಲ, ನಾನು ಏನ್ ಮಾಡಿ? And every day it used to be listed for complaints,
Yes.
complaints.
your lordship,
Therefore, I will not grant, I will not take it up unless you come.
your lordship, Monday ನೇ ಕಂಪ್ಲೈ ಮಾಡ್ತೀನಿ, Monday ಒಳಗೆ.
Whenever you want to
Any
come.
next
Serial
week,
number 4, Sidmalappa
Learned
PM.
counsel for the petition seeks 2 days time to comply. Office objections. If office objections are complied, list for preliminary hearing. Yes.
Serial number 4, Sidmalappa PM.
Learned counsel for the petition undertakes to comply during the course of the day. If office objections are complied, list for preliminary hearing. Yes.
Serial number 5, Rakshit
The
R.
2002 matter, the amendment.
Comply
application-
ಮಾಡಿ first, comply ಮಾಡಿ.
The complaint, Tuesday post ಆದ್ರೆ.
Comply ಮಾಡಿ
Today
post ಆಗುತ್ತೆ.
complaint.
ನೀವು comply ಮಾಡಿ. Yes,
Serial number 5, Rakshit R.
For petition, my lordship.
1 week,
1 week, please.
1 week,
Serial number 6, Ambaji Rao Najre.
1 week.
Next week, any date, ma'am?
ಮಾಡಿ comply ಮಾಡಿ. 1 week,
Serial number 7, Shantraj KG.
1 week.
Serial number 8,
That I will comply during the course of the day.
Learned counsel for the petitioner undertakes to comply during the course of the day. If office objections are complied, list for preliminary hearing immediately. Yeah.
serial number 9,
Comply ಮಾಡಿ, comply ಮಾಡಿ immediately ಅಂತ ಹೇಳಿದಿನಲ್ಲ.
Light copy ತೆಗೆದು ಹಿಂದ್ಗಡೆ ಮುಂದ್ಗಡೆ ಹಾಕದಷ್ಟೇ.
ಅದನ್ನೇ ಮಾಡ್ಬಿಟ್ಟಿದ್ರೆ ಆಗಿರೋದು, why did you allow the matter to be listed? ಬಂದಿರೋದು ಕೋರ್ಟ್ ಮುಂದೆ.
Record ಮಾಡಿ ಕಾಲ್ ದಿವಸ ಮಾಡಿ.
1 week. SP Prakash, 1 week.
SV Prakash.
No.
Just a voice number change.
3 days time is sought to comply the office objections. If office objections are complied, list immediately for
Monday.
preliminary hearing.
Monday.
Comply ಮಾಡಿ, move ಮಾಡಿ.
ಈಗಲೇ
10, Bhargav G.
permitted.
Lordships are.
One week.
Respondent, your lordship, they have already initiated execution proceedings with respect to the interim order passed by the commercial court. Your lordships may have the matter at end of the list. During the course of the day, I'll comply.
There are 8 office objections. I believe.
They've asked for a certificate of incorporation that I can produce it today.
Use ಮಾಡಿ.
End of
We'll
the
take
list,
it
your
up tomorrow then, sorry, Monday.
Tuesday, your lordship. Monday won't be Tuesday. Serial number 10.
Then don't execute it until then if you want.
Tuesday.
ಅಲ್ಲಿವರೆಗೆ ಮಾಡಲ್ವಾ?
ಏನು?
You undertake
ಅಲ್ಲ,
not.
deposit ಮಾಡ್ಬೇಕು.
May-
ಅಷ್ಟೇ
may-
rent
may
ಅವ್ರು
one
ಏನಿಲ್ಲ.
submission, your
You have to
lordship.
Deposit the rent ಅಷ್ಟೇ ಇರೋದು.
The rent I have also deposit. I have this receipts for all the rents that, your lordship, let there be a peremptory order. By Tuesday, I'll comply. ಅದೇನೇ ಇದು peremptory order ಇರಲಿ,
Right,
automatically the interim order may be vacated on Tuesday.
List for, the learned counsel for the petitioner seeks time to comply office objections. List on Tuesday if office objections are complied. Yes.
Serial number non-compliant second time, serial number 11, Vivek
For
R.
the petitioner, Millets, this is coming, I've already complied with the objections for the first time, Millets. I have moved this matter. There are 2 objections which have been raised, Millets. One is with
There's
regard
some
to
partition deed to be produced.
partnership registration. I already have the partnership registration
You can
certificate,
have
Millets.
it in your hand, but you should produce it.
I will furnish it, Millets. If a date
2
may be
days.
fixed, Millets, in the next
2
week,
days, 2 days time is
the-
granted to come. See, we have got only 5 more days.
indeed, Millets.
therefore-
Because the matter has been filed in March of
ಬೇಗ move ಮಾಡಿ, ಬೇಗ
2024,
ಇದ್
Millets.
ಮಾಡ್ಕೊಳ್ಳಿ. Comply ಮಾಡಿ,
Um,
complete as early as possible and move it.
Indeed, Millets. Sometime in the next week, if it may be fixed, Millets, it will be.
1 week, 3 days time is granted to do the needful. If office objections are complied, list for preliminary hearing immediately.
Serial
Much
number
obliged,
12,
Millets.
Vivek
Much
S.
obliged. Millets.
My lords, in this matter, we have filed a few documents along with a memo, my lords. That's the only office objection. And IA to be filed instead of memo, that's the office objection raised, my lords. All those documents are part of trial court record only, my lords.
Rank of parties, prayer to be more clear, documents furnished and annexed
No,
to
objections
marked
which
as
raised
serious.
initially were cleared, my lords.
This learned counsel for the petition seeks 2 days time to comply the office objections.
Lords, the matter may be
List,
taken up on Tuesday.
list
my lords.
immediately after complaints of
Matter
office.
was listed before trial court on 19th, my lords.
ನೀವು move ಮಾಡಿ, comply ಮಾಡಿ, move ಮಾಡಿ. Yes, next.
Serial number 13, Bharat Gowda BR.
For petitioner, my lords, all the office objection have been complied, my lords.
Yeah,
In the trial,
yeah.
in the first time itself,
Huh?
it has been cleared, my lord.
ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ. Yes.
My lords, during the, I have cleared the office objection, my
Why
lords.
don't you look into the file?
My lords,
The court officer says
Court-
that there.
at least course of the day, my lords, can list it on Monday.
The petition undertakes to comply the office objections during the course of the day. List
Lords-
immediately after complaints of office objections. A list for preliminary hearing immediately after complaints of
Non-compliance, third time, serial number 14, V Anand.
1 week.
Serial number 15, sixth time, office
Yes,
objection.
I am for the petitioner here, Mela, office objection which is complied, only the highlighter removed. Highlighter removed through whitener, Mela, overall that objection, Mela.
ಯಾವುದು?
Annexure C ಅಲ್ಲಿ ಒಂದೇ ಒಂದು ಲೈನ್ ಅಲ್ಲಿ ಹೈಲೈಟರ್ ಅಂತ ಇತ್ತು. ಸೊ ಅದನ್ನ ವೈಟ್ನರ್ ಮೂಲಕ ರಿಮೂವ್ ಮಾಡಿದೀನಿ.
Office objections.
Annexure C ಮೇಲೆ ಅದು.
Office objections are overruled. ಏನ್ ಕೇಸ್ ಇದು?
Melod, it is the case, Melod, section 92 of CPC application is rejected by the district sessions Shumoga, Melod.
ಏನ್ ಅರ್ಜೆನ್ಸಿ ಏನಿದೆ ಹೇಳಿ ಹೋಗಿ. 92 ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ. ಏನ್ ಆಕಾಶ ಬಿದ್ದೋಗುತ್ತೆ ಹೇಳಿ.
Like it's filed in
Just after vacation. Yes.
for preliminary hearing, Melod.
Obviously for preliminary hearing.
Melod,
For preliminary hearing.
much.
For orders matter, serial number 16, Manjunath G.
ಏನು? A2 of 24 ಏನಕ್ಕೆ? Recalling ಆ? There is no representation for the petitioner. One week time is granted to do the needful. Yes.
Serial number 17, V Vishwanath.
Disposed of matter like na. There is no representation for the petitioner.
Serial number 18, R Chandrana.
It is list after vacation. Start Chandrana.
We are for the respondents. We are exploring the possibility of settlement. This is
Last time ಅದನ್ನೇ ಹೇಳಿದ್ರು ಸ್ವಾಮಿ, 2 times ಅದನ್ನೇ ಹೇಳಿದ್ರು ಮತ್ತೆ
ಏನ್
ಬಂದೇ ಇಲ್ಲ.
ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಇದೇನು what is maintainability? ಏನು?
Maintainability. Yes, my lord.
Yeah, what is the impugned order?
difference between the.
ಇಲ್ಲ ಇಲ್ಲ.
Regarding rent.
Yes, there is a judgment.
What is the
Landlord
impugned?
tenant.
Decree, my lord, decree.
Please
ಆಮೇಲೆ
wait. Please wait.
Decree has been passed without recording any evidence. He filed an application for payment of arrears of rent. On that application itself, decree has been passed. Now we are exploring the possibility of settlement. Kindly have it after 4 weeks.
But ಇದು last time ಬಂದಿತ್ತಲ್ಲ
Also,
Yes, sir.
ಬಂದಿತ್ತು,
Yes.
time ತಗೊಂಡಿದ್ದೀನಿ, ಪಾಪ ಅವ್ರು ನಮಗೆ ಕೋಪರೇಟ್ ಮಾಡಿ.
September ಅಲ್ಲಿ ಬಂದಿತ್ತು ಇವಾಗಲೇ.
Also,
ಬಟ್ ಇಷ್ಟು
Kindly
ದಿನ
have it.
ಇಟ್ಕೊಳಕ್ ಆಗಲ್ವಲ್ಲ.
second week of January acts.
Where is the impugned order?
Serial number 20.
Hmm?
19, 17, my lord. Serial number 17.
Landlord tenant. According to us, we have paid the amount. According to him, we are still in due.
The defense is struck off.
Also,
Yes, my lord.
But
thereafter, no evidence has been recorded.
Recorded, my lord. Evidence is recorded. Plenty of evidence is recorded. ಮಾಡಿದಾರೆ, record ಮಾಡಿದಾರೆ. Yes.
ಅಲ್ಲಿ ರೆಕಾರ್ಡ್ ಯಾಕೆ ಮಾಡ್ಬೇಕು? ನೀವು ಬಾಡಿಗೆ ಕೊಡದೇ ಇದ್ರೆ then why should your defense be allowed to be investigated?
According to us, we have
Not
cleared,
paid the rent, you are not entitled to
Yes.
any.
we have cleared the dues. According to him, we are in arrears. He has already vacated the premises. Now the decree has been passed for payment.
Sir, equity will be worked out only when you behave equitably.
House.
If you don't behave equitably, where's the question of the courts extending protection to you?
We are trying to settle the matter. If not,
Next week ಒಳಗೆ ಏನೋ ಹೇಳಿ settlement.
Yes,
week ನಲ್ಲಿ ಆಗಲ್ಲ.
Next-
Okay,
next-
after vacation,
ಆಗದೇ ಇದ್ರೆ don't worry, we'll decide. the
after
case.
vacation. Next week.
Deposit ಮಾಡಿ, make some deposit.
I am making efforts. Once he had come, my learned friend was not there.
You make a tentative deposit of 50,000. What is the rent
37,200, son.
per month?
Yes, my lord.
37,000?
There is an agreement, my lord. Yes.
ಎಷ್ಟು ನಿಮ್ ಪ್ರಕಾರ ಎಷ್ಟು ಕೊಡ್ಬೇಕು?
25 lakhs is due is.
ಎಷ್ಟು ಕೊಡ್ತೀರಿ? Deposit at least 20 lakhs or 15 lakhs.
So my client has vacated the premises and is not employed. I am not able to.
That is not the
We will get
issue.
him under.
Yeah, after vacation, as a last chance.
Agbo.
The Land Council.
Kindly
or the
fix the date.
petitioner submits that the petition is working out a settlement with the respondent and therefore prays time to explore a settlement. Hence, list immediately after vacation, hence list on yavat ಬೇಕು?
First week, end. Order directly open agutte.
ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ?
5, 6, any day.
8th January, yes.
Oblige.
Serial number 19, Murthy K.
I appear for petition.
Non-furnishing of address of R3 by council for R1 and R2.
Lord, on last date of hearing, my lord, 29/11, the service to R3 held sufficient in view of service in another matter, my lord. 19.2.
Notice to respondent number 3 was held sufficient in terms of the order dated 29/11/2024. Hence, office is directed to show the name of respondent number 3 as served in the cause list. List on yavat ಬೇಕು?
January, my lord.
List immediately after vacation.
Interim order.
Interim order granted earlier is extended till the next
In
date.
both the matters.
Serial number 20, Gururaj R.
List after service of notice to respondent number 3.
One submission.
It
is plaintiff's writ petition.
Respondent number 3 necessary na?
Andre, other defendants are on record.
ಮತ್ತೆ ಬೇಕಲ್ಲ?
From the
ಅವ್ರು notice serve ಮಾಡಿದಂಗೆ ಹೆಂಗ್?
amendment application to change the age, ಅಷ್ಟೇ. That application has been rejected on the ground that.
ಎಲ್ಲಿದೆ application?
Page 52 is the order.
Where is the application?
Application, my lord, at page 39.
This application is rejected.
Rejected.
What is the stage of the suit?
Argument C portion. Okay, order 6, rule 17, proviso, it's not. Other card produce ಮಾಡಿದೆ.
ಸರ್ವ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದ್ಬಿಡಿ ಅತ್ತ ಹೆಂಗ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ವಿ.
ಸಲ ಆಯ್ತು ಇಬ್ರಿಗೆ ಸರ್ವ್ ಆಗಿದೆ, ಅವ್ರು ತಗೊಳ್ತಾರೆ.
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3 ಯಾರು?
One of the defendants.
One of the defendants, obviously.
Brother of my lord, number 1.
Son of late Naranappa.
ಒಟ್ಟಿಗೆ ರಿಟನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ದಾರೆ.
ಬರ್ಕೊಳ್ಳಿ. The respondent number 3 is the brother of the respondent number 2. And the son of the respondent number 1. All the respondents had filed a common written statement before the trial court. Full stop. In this writ petition, respondents 1 and 2 are served. And therefore, the respondent number 3 is deemed to be served. Full stop. Next para. This order sheet al madi. The plaintiff in OS number so and so is before this court challenging an order dated so and so by which an application filed by her and order 6 rule 17 of CPC was rejected. Yeah, what was the suit about?
Suit was, my lord, for permanent injunction.
But age then, what is the significance of age?
ಅಂದ್ರೆ ಅವ್ರದ್ದು ಗ್ರಾಂಟ್ ಇದೆ. ಗ್ರಾಂಟ್ ಗ್ರಾಂಟ್ ಅನ್ನ ಅವರು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
Who is disputing? You are claiming under a grant.
Yes.
Will cross examination ಎಲ್ಲಿದೆ ಅದು?
Papers.
What do they state in the written statement about your age? Created, concocted, fabricated document.
ಅಂತ ಅವ್ರದ್ದು ಕೇಸ್.
It's better that we hear the other side. List on date.
We will serve the learned advocate.
List on date.
Yes, 9th January. January.
Hmm.
9th January. Serial number 21.
Service to my lord advocate also we will make.
It is open for the petitioner to serve the learned counsel who represented the respondent number 3 before the trial court.
Please.
Yes.
Serial number 21, Latif B.
Appearing for a petitioner, my lord.
Hmm.
My lord, kindly issue hang summons to the respondent number.
R3 is a necessary party.
What, my lord?
R3 or Beka.
Yes, my lord.
Yes, my lord, andre ಏನು ನೋಡಿದಿರ ಫೈಲ್ ನಾ?
Yes, my lord.
R3 ಯಾರು?
Savitramma.
Savitramma ಸರಿನಪ್ಪ. Defendant number 3. What is the application filed?
Sir, application filed under
Line is
under
rejected.
Order 26 Rule 9 of CPC, my lord. The
1
application,
week time is granted to do the needful. In addition, the learned counsel for the petition is permitted to take out hand summons to the respondent number 3. Yes, next.
Serial number 20.
obliged, my lord.
Padmanabha R.
Appear for some of the, in some of the matters, I appear for petitioner. My lords, kindly grant me 1 week's time, my lord, after vacation. We are also engaging services of senior counsel, my lord. Idu mediation gu hoytu.
Learned counsel for the petitioner in serial number 22 to 22.5 seeks time.
8.
My lords, I'm for petitioner in 2 of the matters, and in rest of the matters, I'm the respondent, my
ಏನು
lords.
Are you ready?
Lords, I'm ready, but
Last time now ready be our time ತೊಗೊಂಡ್ರು. ಇವಾಗ senior engage ಮಾಡಿ.
no, my lords, these are club matters, around 8 to 9 matters are there, my lords. If my lords kindly, if they are not ready today, my lords, if
Immediately after
Monday,
vacation. Immediately
Monday or Tuesday, my lords.
ಅಲ್ಲ ಈ ವಾರ ಬೇಡ ಸ್ವಾಮಿ, next week. I am also engaging a senior counsel.
Lords, this matter, there is a dispute.
Yes,
This matters pertain to registration of under the Karnataka Registration of
After
Societies Act.
vacation. Let it come after vacation.
Lords, there is
Fixed
little
time,
urgency, my
after
lords.
vacation. Interim order granted is
Earlier, at least on
last
Wednesday.
2 years it is pending.
No, my lords, it came up for hearing for several
Take your
times.
time, my lord.
We
Wait.
did not take time, my lords, actually. We did not take time, my lords. It came up for hearing several times. But my lord, unfortunately, most of the times it did not reach, and some point of time, my lords, the matter could not be taken up because of the
ಆಯ್ತು ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
Wednesday, Thursday, my lords.
We are almost on the verge of vacation. Wednesday, Thursday ಏನಾಗುತ್ತೆ? Other matters will have to be taken up. Urgent ಇರೋದು ಯಾವ್ದಾದ್ರು ತಗೋಬೇಕು. ಅದ್ ಬಿಟ್ಟು ಇದು ಹಳೆಯ ಕೇಸ್ಗಳು ಯಾಕೆ ತಗೋ? If it can wait for a few more days, let it come after vacation. The last 1 week is only meant for very urgent matters.
I agree, my lords, but
ಮತ್ತೆ
there is
ಇದನ್ನ-
little urgency in the matter because they are collecting funds from the parents and they are not utilizing this for the benefit of the institutions, my lord. They are misusing these funds, my lords, from the past.
This
And we
time-
have filing we
this
have filed
immediately is-
applications, my lord.
Immediately after winter vacation.
Serial number 23, Lord Mariappa.
Lord Mariappa. 1 week time is granted to do the needful. Interim order is noted. Interim order granted is extended to the next date. If process is not paid within 1 week, interim order granted on so and so shall stand automatically dissolved. Yes.
Serial number 24.
Rectification of.
Appearing for the respondents in this case.
Suit is filed in which year? Suit is filed in which year?
2021, my lords. My lords, I request a short accommodation, my senior colleagues' inconvenience. We haven't also filed an application, my lords. Kindly hearing.
List after vacation. The learned counsel for the respondent seeks time list after winter vacation.
Serial
Much
number
obliged.
25, Om Prakash BV.
1 week. Process, Mr. ಎಲ್ಲಿ ಓಂ ಪ್ರಕಾಶ್ ನೀವು ಇದ್ರೆ ಅವ್ರಿರಲ್ಲ, ಅವ್ರಿದ್ರೆ ನೀವಿರಲ್ಲ. ಹೇಳಿಪ್ಪ, please argue. Suit is filed in 97.
97.
ಹೇಳಿ ಏನ್ ಕೇಸ್? What is the case?
They want to produce the witness want to produce the.
Who are you?
I am the plaintiff
The
petitioner.
plaintiff. What is the suit for?
Suit for declaration that the defendants have no authority to interfere in association college. Well, the association
Declaring the defendants have no authority to interfere the affairs and manage of so and so. And the plaintiff continue to secretary, restrain the sponsor. Yes.
the petitioner is an association has established a college in Tumkur in 1973.
all of a sudden in 1997, the defendant 1 and 2 started that government has taken over the college and writer wrote a letter to the principal and obey their orders. And immediately the writ petition came to be filed for procurement of the government order. In the writ petition, Malad annexure A, they said the government is not at all interfering. Only the individual government officials and in the individual capacity they are interfering. And the court gave us a liberty to file a civil suit. The suit is filed in the name of an individual person, Srimati K. Ramaya and Srimati Meenakshi. And the evidence
Who has
of
given you the permission? Who gave you the permission to file a civil suit?
Honorable High Court, my lord.
Illide?
Annexure A, page 16.
Second response. Which file? Yes.
My lord, in the course of the suit, the plaintiff has completed his evidence. Defendant also has completed their evidence. My lord, the dependent witness has come and filed an application to mark the documents which has been left out by the defendant, one Srimati Meenakshi and Ramaya. My lord, that is impermissible in law. The person who has filed
Where is the application?
application, page
That was
19, annexure B.
Defense 1, 2, and 4 respectfully pray to permit the defense to mark the xerox.
This application is a fraudulent application. They are not a defendant. Defendant has not at all filed an application. It is one Shri S. Sampangi who files an application. He is not a defendant on record. And he has not filed return statement also. Now Xerox copies is already rejected by court several times. And now, my lord, this person.
Affidavit, please read the affidavit.
Yes, Sampangi, a son of late Subraya, age 82, residing at 156, Kanta Nivasa, first block, third phase, Thursday, Banishankari, Bangalore, do hereby swear me affirm and state and as follows. I submitted, I was the ex officio president of the defendant federation during 1996-98, retired from the service in the month of August 1999 on attaining superannuation. I deposed that in year 1997, plaintiff filed the above suit against defendant federation. A detailed WS is filed along with the WS. Certain copies of documents were also filed in support of the government to prove the case of defendant. I submit that out of total document furnished, only certain documents were marked as exhibit on D1 to D20. Few of them are left out. The left out documents are Xerox copies. Such copies are not marked. Hence, I pray the Honorable Court to mark all such.
Suit al defend number 1 to 3 ಮಾತ್ರ ಅಲ್ವಾ ಇರೋದು?
ಇವರು impleading applicants ಇವರಲ್ಲ.
ಯಾರು?
4, 5 and 6.
ಎಲ್ಲಿದೆ ಅದು? ಇಂಪ್ಲೀಡ್ ಆಗಿದಾರಾ?
ಆಗಿದ್ದಾರೆ.
ಮತ್ತೆ ಎಲ್ಲಿ ಅಮೆಂಡೆಡ್ ಪ್ಲೇಂಟ್ ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ?
ಕೋರ್ಟ್ ಅವ್ರು ಮಾಡಿಲ್ಲ. ಕೋರ್ಟ್ ಅವ್ರು ಮಾಡಿಲ್ಲ.
ಅಮೆಂಡ್ ಆಗಿಲ್ಲ.
ಅವ್ರು ಕೋರ್ಟ್ ಅವ್ರು ಅಮೆಂಡ್ ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ ಯಾರು ಅಮೆಂಡ್ ನೀವು ತಾನೇ ಮಾಡ್ಬೇಕಾಗಿರೋದು?
ಅಲ್ಲ ಕರೆಕ್ಟ್. ಅವ್ರಿಗೆ ಆಫೀಸಿಗೆ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟರು, ಆಫೀಸ್ ಅವ್ರು ಮಾಡಿಲ್ಲ.
ಮಿಸ್ಟರ್, once the application is allowed, who has to amend it? You have to amend it.
ಅಲ್ಲ ಅದು ಕೋರ್ಟ್ ಅವರು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟರು, ಆಫೀಸೇ ಮಾಡಿ ಅಂತ. ನಮಗ್ ಮಾಡಕ್ ಬಿಡ್ಲಿಲ್ಲ. ಅದಕ್ಕೆ
ಮಾಡ್ಲಿಲ್ಲ, ಅದಕ್ಕೆ ಕೋರ್ಟ್ ಅವ್ರ ಆಫೀಸಿಗೆ ಮಾಡಕ್ ಹೇಳಿದ್ರು. Who is this respondent number 4, 5, 6 ಯಾರು?
4 is Hemalata and 5 is principal Sukanya and 6 first 5 ಮಾತ್ರ ಇರೋದು.
4 ಯಾರು?
4 Hemalata.
Hemalata is the principal of that college.
Who is this
been
Sampangi?
allowed. My lord.
Who is this Sampangi?
Sampangi is a third party.
Ex officio president of the federation.
ಒಂದ್ಸತಿ ಮುಗಿದಾದ್ಮೇಲೆ ಆಯ್ತಲ್ಲ, how can you swear to an affidavit?
ಈಗ ಆ ಟೈಮ್ ನಲ್ಲಿ ಅವರೇ ಚಾರ್ಜ್ ತಗೊಂಡಿರೋದು, ಅವರೇ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿರೋದು, ಅವ್ರಿಗೆ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿದ್ರು.
How that man is retired and gone.
Yes.
So how can you come and swear to an affidavit? How can you file an affidavit is what I am asking.
Those documents are already marked, my lord. They wanted to identify those documents.
ಸಂಪಂಗಿಗೆ ಏನು ಅಧಿಕಾರ ಇದೆ ಬಂದು affidavit file ಮಾಡಿ? Who is he Sampangi? Is he a party to the suit?
No, earlier he was the, when it was filed.
He is retired and gone.
Yes, my.
Retire ಆದ್ಮೇಲೆ ತಿರ್ಗಿ ಹೆಂಗ್ affidavit ಹಾಕ್ತಾರೆ ಇವರು?
Certain documents ಅವ್ರಿಗೆ ಚಾರ್ಜ್ ಕೊಟ್ಟಿರೋದ್ರಿಂದ ಐಡೆಂಟಿಫೈ ಮಾಡೋದಕ್ಕೆ ಬೇಕಾಗುತ್ತೆ ಅಂತ ನಾವು ತಗೊಂಡಿದ್ವಿ.
Whatever it is.
Yes, my.
He is not a defendant in the suit.
Yes.
How can somebody come and swear to an affidavit?
When the suit was filed, Sampangi was the ex-officio president. My lord. 97 nil.
Who is the president now?
President is ex-officio, director of public instruction is the president.
Right. So who is that person now?
Now, some very new person has come now.
ಅವ್ರ ಕಡೆಯಿಂದ ಹಾಕ್ಸ್ಬೇಕಲ್ವಾ? See, this is not documents produced by Sampangi out of his pocket.
Yes, ma'am.
It is official records produced before the court. If Sampangi is retired, the person who is the incumbent, he has to swear to an affidavit. How can a retired officer swear to some affidavit in the civil proceedings?
Maybe permitted to file.
Hmm?
Maybe permit us to implead them and have to get it done.
Implead them, but
A witness, as a
present
witness,
incumbent,
yes, through witness I can write, present person. ex-officio
present
president.
incumbent of the respondent number 1.
Yes,
Let him swear to an affidavit.
yes. Well, I wanted to show the documents, what has been filed. There is all
Exactly.
journals and
We can't allow Tom, Dick and Harry to come into the suit.
Yes,
Once he is retired, he is gone.
yes, ma'am.
He becomes a functus officio. Where's the question of he again coming and swearing to an affidavit once he is retired from service?
My lord, one submission, my lord. I don't want to go ahead with these documents are not at all required very much. Maybe I am withdrawing all those documents, not at all required.
Then we'll dispose of this.
If we
petition.
dispose with the directions, this 97 matter, one way or the other, they
You
are,
will not insist upon these documents.
yes, I am not going to insist on those documents. My lord, one more thing, my lord.
Bande. The plaintiffs number 2. Who are you? Tippaya. Who are you?
Plaintiff number 2, president of the association.
Plaintiff number 2 in OS number 8054 of 1997 on the file of so-and-so. He is before this court challenging the correctness of an order dated 20th of February 2024, by which it allowed IA 3 of 24 and permitted the defendants 1, 2 and 4 to mark photocopies of records that were filed along with the written statement. Next para. And this petition was listed for orders regarding orders, comma, the learned counsel for the respondent number 1 submits that the respondent number 1 would not press for marking the documents.
Through DW4, my lord.
Huh?
Through DW4, Sampangi.
You said you will not even press any of these documents.
Yes, my lord.
Would not press for marking any of the documents as sought for in IA 3 of 24. He, however, prays that suitable directions be issued to the trial court to dispose of the suit as early as possible. Next para. In view of the contention of the learned counsel for the respondent number 1 that he would not press IA 3 of 24, comma, it is unnecessary to go into the questions raised in this writ petition. Hence, a writ petition is allowed and the impugned order passed by the trial court is set aside. The application filed by the defendants 1, 2 and 4 in IA 3 of 24 is dismissed as not pressed. Next para. Since the suit is filed in the year 1997, comma, the trial court is requested to expedite the suit as early as possible, at any rate within a period of 6 months.
Before that, this court already given in 22, disposed the matter in 1 year. Still is prolonging. My lord, the representing the persons.
6 months in view of the.
One more thing I wanted to clear it. In between, number 3, dependent number 3 is the ex-principal of the college now. When she was in service, she has been impleaded. The honorable trial court has been passed an order. Intentionally, they have not amended the plaintiff. One more thing, sir. Again, R3 is the wife of the petitioner now. has been implemented. Opposite side, they are claiming, so Karnataka state.
Whatever it is, you establish all those things in trial, in Madam Maito.
It should
Within a
be-
period of 6 months from the date of receipt of a copy of this order. Full stop. It is seen that this court in WP number
28571.
28571 of
22.
2022 had directed the trial court to
That repetition, no, I will come back. Citations also filed.
2 years ಕೊಟ್ಟಿದ್ದು 1 year time ಕೊಟ್ಟಿದ್ದು ಯಾವ petition ಅಲ್ಲಿ
ಅದರಲ್ಲಿ ತಾವು ಮಾಡಿರೋದು.
2857 of 2022.
Yes.
This court had directed the trial court to dispose of the suit within 1 year.
2015, that petition filed by him only. Between us.
ಯಾವ petition ಅಂತ ಹೇಳಿ ಸರ್.
ಒಂದು ನಿಮಿಷ. ಇದೆ ಕೊಡಿ. Citation. Two 2015 GMCPC.
2015, this court had directed the trial court to dispose of the suit within 1 year. However, the same is not done. Therefore, the trial court shall endeavor to take up the suit on day-to-day basis and ensure that the suit is disposed of as early as possible, at any rate within 6 months from the date of receipt of a copy of this order. Yes.
Published.
Number 26, Pradeep Kumar RH.
We
can maybe granted to needful time.
The respondent is a necessary party.
He is a necessary party.
Which
because
time is
the-
granted to do the needful. In addition, learned counsel for the petition is granted to serve the learned counsel who represented the respondent number 5
Second
before the
respondent
trial
is
court.
also dead. Second respondent. is
One
also-
of the respondent number 2 weeks time is granted to take steps in respect of the deceased respondent number 2.
I may be extended.
ಯಾವುದು? Sorry. Yes, next.
I may be extended.
Interim order is extended to the next.
Serial number 27, Shankar Narayan Bhatt.
R2 to R6.
R2 and 6, my lord. Others serve agide, sir. Kindly grant 1 week time, my lord. I take it.
1 week time is granted.
By
to
way of
take-
paper publication.
Why paper publication?
Our intentionally avoid the.
You serve it on the advocate.
Illa, trial court ಅಲ್ಲಿ ಯಾರು ಇಲ್ಲ sir.
ಯಾರು ಇಲ್ವಾ? 1 week time is granted to take to furnish fresh process and other requisites to issue notice to respondent number 2 and 5. 2 and 6,
Yes.
2 and 6.
Yes.
Serial number 28.
List after service of notice to the respondent.
I'll undertake to file wakalat for respondent number 5 and 6, madam.
Mr.
Bharat K.
Mr. Bharat K undertakes to file wakalat for respondents 1 to
Respond 5 and 6.
5 and 6. List after service of notice to the other respondents.
Petitioner may be directed to serve a copy, madam.
Copy ಕೊಡಿ.
ಕೊಟ್ಟಿಲ್ಲ, ಬರೀ petition ಮಾತ್ರ ಕಳಿಸಿದ್ದಾರೆ.
The entire file we have served, my lord.
ಇನ್ನೊಂದು ಕೊಡಕ್ಕಾದ್ರೆ ಕೊಡಿ.
Please, my lord.
ಆಗದೆ ಇದ್ರೆ ಕೊಡಿ,
ಕೊಡ್ತೀನಿ.
ನಾನೇ ಕೊಡ್ತೀನಿ.
ಕೊಡ್ತೀನಿ.
Yes. Interim order ಇದೆಯಾ? Interim order
order.
extend to the next.
Please.
Serial number 29, Girish Kumar R.
For petitioner, my lordships, kindly pray for short accommodation. Matter between.
K.S. Ganesh. There is no representation for the respondent number 1. Learned counsel for the petition seeks time. List after invocation. Manu Kulkarni.
30, Manu Prabhakar Kulkarni.
Petitioner, my lord.
Ah,
R3, the trial court lawyer has retired, my lord, so I'm not able to serve him. It is await
Pardon?
notice. The trial court lawyer, my lord, has filed a memo of retirement, so I'm unable to serve him.
Take out notice then. List after service of notice to respondent number 3. Interim order granted early is extended till the next day.
Obliged.
Serial number 31, Archana KM.
Appearing for the petition, your lordship.
But I'm the advocate for the trial court, my lord. I'm the advocate for the trial court. My name may be added to the cost list.
What is your name?
Dhanush M.
Dhanush M. Mr. Dhanush M undertakes to appear for the respondent number
One respondent.
Only one respondent.
to the respondent. Officer directed to show his name in the cause list. List after winter vacation. Is
Your
there any?
Lordship, yeah, there's no interim order, Your Lordship. Your Lordship is for defendant evidence in commercial court. The case is being taken up around 2 times every week.
Anyway, it will come immediately after vacation. Yes, next.
Yes.
Serial number 32.
Parasmal, yes.
Interim order to be extended.
Yes, madam. R1 to R5, are they necessary parties?
My lord, in fact, they are sons of Lakshmi Devama. They had a firm earlier. They used to get the rent in the name of Lakshmi Devama and sons. But now after the death of Lakshmi Devama, that has been dissolved. And now it is Krishnamurti to whose share the present shop has
There-
come to, and he's
R1 to R5 are not necessary
not
parties.
necessary.
It is up to, I have no.
The learned counsel for the respondent number 6 submits that
Let them give it in writing
respondents
before the
1
court below
to
that.
5 are not necessary parties. In view of the dissolution,
The firm andre just to receive the rents, they were receiving it as in the name of Lakshmi Devama and sons and Tai Maklu Togota Idru Swami.
Because there is.
Now
no
it has
such-
fallen to the portion of Krishnamurti here, and I mean respondent number 6, and he's taking the rent.
No such application has been filed before the court below that they
yeah,
are.
madam, I thought respond.
My lord, it is we who are contesting in
Respondent
the trial court.
Submits that.
No such application has been filed with the court below. They are the parties in the
He
court. below.
submits that the respondent number 1 was constituted only for the purpose of receiving rent, and that the respondent number 1 is dissolved. And the property question is allotted to the share of the respondent number 6.
Yes, respondent number 6 here.
Stop. She therefore contends that it is the respondent number 6 alone who would henceforth be pursuing this writ petition. Full stop. In view of the aforesaid submission, comma, notice to respondent number 1 to 5 is unnecessary. Nonetheless, since notice is already issued,
My lord, I have not
Respondents.
received the copy. I just came to know that this.
nonetheless, since notice is issued to the respondents 1 to 5, list this petition immediately after winter vacation.
I have also not received the copy of the petition.
Please furnish a copy. What about this deposit?
It has been deposited, your lordship. I will file a
The
memo.
learned counsel for the petitioner submits that in compliance with the order dated 21/11/2024, the petitioner has deposited 50% of the rent at the rate of 9,600 per month from the date of decree till date.
My lord, there is another writ between the same parties in respect of the same property.
List this petition along with WP number.
WP 8961 of 2024.
So on so. Yes, after vacation.
Interim order. to be
8961 of 2020.
Interim order granted earlier.
Serial number 33, Pramod Gowda, DP.
Petitioner in this matter, my lord.
Beka,
Respond number 3, my lord, in this matter. I am for the respond number 3,
what about 1 and 2?
1 and 2.
1
Serve
and
the notice to the council on record.
Mr.
Case Devraj,
Mr. K.S. Devraj undertakes to appear for respond number 3.
3, my lord.
Office is directed to print his name in the cause list. List after service of notice to respond number 1, 2, and 4. After vacation. Yes.
That kindly date may be fixed.
34,
Move ಮಾಡ್ಕೊಳ್ಳಿ ಆ judge ಮುಂದೆ.
Purna Prasad KR.
List 1 week time is granted to do the need. Purna Prasad,
Yes, my lord.
1 week time is granted to do the need.
Interim order. may be
Order is
extended.
extended to the next date of hearing. It is made clear that if the process is not paid within 1 week, the interim order granted on so and so date shall stand dissolved automatically. Yes,
35, GM Sumitra.
1 week time is granted to do the need.
Appearing for 1 and 2.
My lord, petitioner has deposited 25 lakhs before the court.
Mr.
today.
BP Mahesha, P Mahesh,
P. Mahesha.
P Mahesha.
I'm
Mahesha.
Sir,
submitting
P
the-
Mahesha undertakes to appear for the respondents 1 and 2. Stop. The learned counsel for the petitioner submits that as per the order dated 14/11/24, a sum of rupees 25 lakhs is already deposited.
Today.
My lords, my instruction is it's not been deposited. Just now the matters got.
Lawyer says. he
Could
can-
it kindly be taken up on Monday, my lords? We will get the order updated.
This is however disputed by the learned counsel for the respondent number 5.
My lords, let it
Yes.
not be recorded because I don't want to dispute my learned friend. Let it be on Monday. my
Well,
lords.
you say that it's not
My
deposited.
lords, my instructions, but I don't want to
Counsel
dispute
for
my
the
learned friend.
respondent number 5 seeks time to ascertain the said
Yes,
fact.
yes.
List on
The memo.
Monday.
Monday.
I'm filing a memo by the.
ಆಯ್ತ್ ಬಿಡಿ ಏನ್ ಹೇಳಿದ್ರಲ್ಲ ಸಾಕು ಅವ್ರು ಕೊಟ್ಬಿಡಿ ಕಾಪಿ ಕೊಡಿ.
Please.
Grateful.
Yes, next.
36, Annaya CV.
My
List
lord,
after service of
interim-
notice
my
to
lord,
respondent number 4.
Interim order may be extended.
Interim order is extended on earlier case.
Number 37.
My lord, I appear for the respondent number 1 to 3 in serial number 36.
The order dated 14/11/24 is extended till the next date. Annaya,
Per the apply.
Lord, I appear for the respondent. Lord, respondent number 4, my lord, is none other than the borrower. They are all relatives, my lord. And my lord, kindly direct the petitioner, my lord, to give me a fresh set of writ petition because most of the pages, my lord, which are relevant are missing.
I'll furnish.
is it deliberate or
ಇಲ್ಲ ಇಲ್ಲ ಇದು ಅದು
ಬೇಕು ಅಂತ ಮಾಡಿರೋದಾ ಅಥವಾ
ಇಲ್ಲ ಆ ತರ ಇಲ್ಲ ಇಂಪಾರ್ಟೆಂಟ್ ಪಾಯಿಂಟ್ಸ್ ಇಲ್ಲ ಮಿಡ್ಲ್ ಅಲ್ಲಿ RTC ಹಾಕಿದೀವಿ
ಅಲ್ರಿ
ಆಧಾರ್ ಕಾರ್ಡ್
ಅರ್ಧಂಬರ್ಧ ರಿಟ್ ಪಿಟಿಷನ್ ಕೊಟ್ಟಿರೋದು ಬೇಕು ಅಂತ
ಇದೆ.
ಅಥವಾ
ವೆರಿಫೈ ಮಾಡಿ
ಅಕಸ್ಮಾತ್ ಆಗಿ ಆಗಿರೋದು ಆಕಸ್ಮಿಕ
ಅದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್
Let him serve one more set, my lord. Your lordship may have it after vacation. In fact, respondent number 4, my lord.
Learned counsel for the petitioners directed to serve a complete set of the writ petitions. Learned counsel for the response 1 to 3.
Obliged.
Immediately after winter vacation.
Please.
Interim order.
Interim order granted early is extended to the next date.
Number 38, Dhruva M. Patavari.
37 is mine.
37 in it.
37.
37, 38 ಕೊಟ್ಟಿದ್ರಲ್ಲಿ. Sandhya Prabhu.
Please, my lord.
Yes.
My lord, order was dated 2011, my lord. I was given with the time to make a payment by 4 weeks, my lord. It ends on 17th, my lord.
Yeah?
Ends on 17th. Time ಇದೆ ಸು. ಅದು process ಕಟ್ಟಿದ್ದೇವೆ. 2011 was ordered now. 4 weeks time ಅಲ್ಲಿ ಕೂಡ 623 ಕಟ್ಲಿಕ್ಕೆ ಹೇಳಿದ್ದೇವೆ.
Why is it listed today?
No idea.
List after service of notice to respondent. You are not complied the office objection.
My lord,
Madam, because of people like you, you are not entertaining the request of other lawyers.
my lord, I'll comply.
So complaints ಮಾಡಿದ್ರೆ ನಾವು interim order ಕೊಡ್ತೀವಿ. But you don't comply.
My lord, ಇದರಲ್ಲಿ ಸರ್ಟಿಫೈಡ್ ಕಾಪೀಸ್ ಅಪ್ಲೈ ಮಾಡ್ಲಿಕ್ಕೆ ಮಂಗಳೂರಲ್ಲಿ ಹೇಳಿದ್ದೇನೆ.
that
ಅವ್ರು
is not
ಕೊಡ್ಬೇಕು
the
ಸಮಯ
issue.
ಬರ್ಬೇಕಷ್ಟೇ. I'll comply within a week, my lord.
This is 1 month almost. You've taken 1 month, you are not complied.
Within a week, I'll comply. I'll comply. It may be direction also.
Comply ಮಾಡಿ ಇವತ್ತು ಮಾಡಿ.
Dispensation ಹಾಕಿದ್ದೇನೆ ಸ್ವಾಮಿ.
You please
dispensation
comply it,
application
whatever, madam, please comply it today.
Please,
Pass over.
please.
ನಿಮ್ಮಂತವರಿಂದನೇ ಬೇರೆಯವ್ರಿಗೆ ತೊಂದರೆ ಆಗ್ತಾ ಇದೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಸರ್ಟಿಫೈಡ್ ಕಾಪೀಸ್ ಗಳಿಗೆ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ. ಈಗ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತೀನಿ. ಏನೇ ಉಳಿದಿದ್ದನ್ನೆಲ್ಲ ನಾನು ಇವಾಗ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತೇನೆ.
Because of people like you, other lawyers are getting affected. Order ತಗೊಳ್ತೀರಾ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಲ್ಲ.
No, my lord, I apologize, my lord. I'll comply, my lord.
Keep your apologies to yourself. Please do the work.
I'll comply, my lord.
Yes, next.
Serial number 38, Dhruva M. Patavari.
All office objections are complied here.
Annexure E. Copies produced.
There's one clarification.
Ah.
They had asked for impugned order A, annexure A, to be certified copy. The entire order sheet is
Certified
present at
copy.
page 78. So that is produced for the sake of convenience. I've made it as annexure A.
The office objections at serial number 1 and 2 are overruled. Are there any other office objections?
No other office
Yes,
objection.
what is the case?
Your Honor, we'll take page 25 of the petition, Your Honor. Normally, if an arbitrator is to be appointed, a notice is sent, and if the arbitrator is not decided, then a section 11 application is filed before the High Court.
What is it, page 25?
Page 25, a trial court
Hmm.
in an OS. And section 11 application is filed before the trial court to appoint an arbitrator. And this is somewhere in Hukeri, a district in near Belgaum. This, I'll just read out, Your Honor. And I am placed ex parte in this OS. Heard the counsel for the plaintiff on IA number 1. It is seen that there is a proviso of arbitration in the purchase order of the plaintiff, company for the supply of sanitary napkins with the defendant. In view of the arbitration proviso, I am of the considered opinion that it is absolutely necessary for refer the matter to arbitration for disposing the dispute.
Named arbitrator in the agreement?
No. Now, Your Honor, will go to the annexure C, Your Honor, at page 28, the arbitration clause. The clause says that, only the courts in Trivandrum.
No, that's okay. Is this arbitrator a named arbitrator?
No, not named arbitrator at all.
Where is that clause?
Page 28, clause 5, Your Honor. Down. Clause 5. If any dispute arises between HLL and super threads in connection with or
emergent
relating
notice.
to the purchase order,
Issue emergent notice. In addition, learned counsel for the petition is directed to serve the learned counsel who represented the respondent before the trial court. Interim stay of the impugned order till the next date of hearing.
Your Honor,
What
let there
is
be
that?
stay of, at page 88, Your Honor, the execution court has a attachment, ordered for attachment of
But
movables.
what about this order? Page 25, that is not challenged?
Page 25, Your Honor, he appoints an arbitrator. It is as if, I cannot go to a tahsildar and ask for an.
Correct. Have you challenged this order?
No,
You have participated in the arbitration?
no.
Then what happened later?
The arbitration is done in complete secrecy. No proper notice. What is the proceeding? And in fact, Your Honor will go directly to the arbitral award at page 61. This is a case in which the court and the arbitrator simultaneously conduct proceedings. That means the plaint is taken in the court, the evidence is taken by the arbitrator. I mean, the evidence is outsourced to the arbitrator, and then the arbitrator prepares an award. At page 61, the arbitrator passes an award on 20th July. Then the court takes it up and it says, this is the judgment for this particular OS. And it is done completely ex parte, in complete secrecy.
What is the order at annexure A?
Annexure A is, Your Honor, I challenged the, in the execution petition, under section 47, I said that, the award is lacking inherent jurisdiction. The Supreme Court in its wisdom says that, any award or any decree which is lacking inherent jurisdiction can be challenged at any point in time, even in the execution proceedings. The execution court says that, you cannot, whatever is passed by the trial court, the section 11 appointment by the trial court is valid.
No, please wait. Right or wrong, your party in some proceedings in the OS, the court has directed appointment of some arbitrator, maybe that is without jurisdiction.
Yes.
You allowed it to remain.
No, I'd filed an objection. As a courtesy, this is at page page 53, Your Honor. Annexure F1. The arbitrator, and this is the only one time that the arbitrator sends a notice. Apart from that, there's no correspondence between the parties. The arbitrator says that, I have been appointed as the arbitrator. Please come on 25/2/2017. Then, Your Honor, at page 55. Sorry, this is not.
There's somebody called Hal Bavi. Who is the arbitrator appointed?
A. Bolgundi. He is an advocate in the Belgaum trial court. Your Honor, page 48. Annexure E1. I. Shri A.B. Bolgundi. He's the one who is appointed. He says that, IA number 1 was allowed by the civil court in Hukeri. I've been appointed as the arbitrator. Please come and file whatever you have on 25/2/2017.
Then what happened thereafter?
Now, page 50, Your Honor. Page 50. I filed the application saying that, you do not have jurisdiction.
What happened thereafter?
No correspondence after that. I presume that, because there's no correspondence, the arbitration ceased to operate. There's absolutely complete silence. And then in the year 2023-24, they file an execution. In fact, Your Honor, at page.
When was the arbitrator award served on you?
It was never served on me.
How did you get it?
In the execution proceeding, I applied for the certified copy.
Then should you not challenge this award then?
I am not required to challenge this award.
Yes.
I did not challenge it, and I'm not required to challenge also.
Yes.
Because the case is this. If somebody goes to the police station and the police appoints an arbitrator, I only have the courtesy to tell them that, you do not have jurisdiction in this matter. Now, I cannot lead evidence, or for that matter, somebody goes to the tahsildar.
Right or wrong, there's a decree. Right or wrong, there's a decree.
The decree is.
Which you are a party.
I am only made a party, but no notice. I am placed ex parte.
Party.
No notice of any sort is given, Your Honor. I am placed ex parte.
Put a notice calling upon you to appear before him. It may not be a correct procedure. The procedure may be faulty.
Yes.
The arbitrator really may not have the power to enter reference, no dispute. But an award is passed against you, right or wrong. That award should it not be set aside?
Your Honor, the submission is this. I'll take Your Honor to page.
Can the executing court go behind the award and say that the arbitrator
Yes.
did not have power?
I have judgments, Your Honor. I will just produce two judgments. The court says the execution court cannot go behind the decree. At no point in time it can go behind the decree, adjudicate on the merits of the case. No, but only and only if there's inherent lack of jurisdiction. The decree is passed without jurisdiction. That means to say some XYZ has passed some award. It is stamped and it is placed before the execution court. Does not mandate the execution court to execute as per the thing. It has to see only one thing, whether that person had jurisdiction to pass that award. That's it. It cannot go into the merits, what evidence or was it seen, was it appreciated? No. But if it finds that, you know, the person who passed the award, let's say I go to my neighbor and my neighbor appoints some driver as the arbitrator. Arbitrator in 2 days passes an award. It's stamped and it comes to the execution court. Execution court, if I file an application saying that, look, there's an arbitration clause, only courts in Kerala has jurisdiction. And, you know, if there's no notice of arbitration, there's nothing of any sort. Arbitrator is not appointed in accordance to law. As Section 11 of the Act mandates, only the High Court can take it under CMP and appoint an arbitrator. This is not followed. Any Tom, Dick and Harry cannot pass an award. That award can be challenged in Section 47. Apart from that, the court cannot, execution court cannot.
Point to put.
The first judgment. First judgment is from the Karnataka High Court itself. It's a very similar situation. Somebody had gone to a court in Davangere, filed a Section 11 application, seeking for the appointment of arbitrator before the trial court.
Yes.
I'll take Your Honor straight to paragraph number 8 at page 2, Your Honor. It says, from a bare perusal of the above provision, it is very clear that the petition can be filed only before the High Court. Therefore, the petition.
I'm saying that I accept your contention.
Now I'll go to the
The
next.
way in which the arbitrator was appointed
Yes.
is not in accordance with the provisions of the Act of 1996. No dispute.
Yes.
The senior civil judge could not have appointed any arbitrator. No dispute.
Yes.
But you were confronted with that order. Did you
Yes.
challenge it? You allowed this arbitrator to enter reference. You filed some application before the arbitrator. You did not follow it up.
I followed it up. I have letters to follow.
Award came to be passed in your absence. Correct. Thereafter, when it came for execution, you filed a preliminary objections.
Yes.
Whether the executing court can go behind the award and say
Yes.
that the arbitrator did not have power to enter reference.
Yes. I'll just take Your Honor to page 4 of the citations. 2013-10 SEC, page 136.
Yes.
I'll just read head note B, then I'll go to paragraph 9. Courts, tribunals, and judiciary jurisdiction. Held jurisdiction of court/forum cannot be conferred by consent of parties or acquiescence or waiver. Hence, merely because a state had not objected to the maintainability of consumer complaint in regard to a pure civil dispute did not mean the consumer court thereby stood clothed with the power to entertain complaints regarding service matters against the state. If a court having no jurisdiction over a matter passes a decree, it would amount to nullity. That means it is no order under law. Estoppel, acquiescence, or waiver. Acquiescence, that is, jurisdiction cannot be conferred upon a court or tribunal by way of acquiescence or waiver if it otherwise does not have jurisdiction. Now, this is a case in which the employee of a government servant had a dispute with retirement pension. He went to the consumer court. The consumer court appreciated and passed some order. Being aggrieved by the order, he went ahead and went to the commissioner and then ultimately went to the Supreme Court. The Supreme Court says that the other side, the state argues that, you know, just because I did not take objection does not mean the consumer court is clothed with the jurisdiction, which it doesn't have. Now, the consumer police cannot decide on title disputes. It's only the city civil court. A consumer court cannot decide on certain aspects. Now, just because it is done so, and I haven't challenged it, my waiver or my acquiescence will not make that particular order valid under law. Now, I'll take your honor to page 9 of this judgment.
Yes.
All or till paragraph 8, all the rival submissions of the learned counsels are taken. Paragraph number 9. Indisputably, it is a settled legal proposition that conferment of jurisdiction is a legislative function and it can neither be conferred with the consent of the parties nor by a superior court. And if the court passes a decree having no jurisdiction over the matter, it would amount to nullity as the matter goes to the root of the cause. Now, this is something which goes to the root of the matter. Now, Your Honor, further, such an issue can be raised at any stage of the proceedings. Now, the next judgment, I will show Your Honor that any stage of the proceedings means even in the execution court.
No doubt. No doubt. Now, the arbitrator is appointed by some court. Maybe the procedure of appointment is not correct. The procedure of appointment is not correct.
That goes to the root of the matter, Your Honor.
Correct. So therefore, the procedure has to be set at naught. The procedure of appointing the arbitrator may not be correct because it is under section 11. It is only the High Court which can do it. Correct. Now, this civil court has passed some order appointing somebody as arbitrator.
Yes.
Now, the arbitrator has passed an award. So, assuming that the arbitrator has got power under the agreement to enter reference, then you cannot say that he is done without jurisdiction. So, far as the appointment procedure is concerned, that is correct.
Yes.
But the arbitrator has got jurisdiction because he has been appointed by the court.
No, by which court is
By
the
which
important.
court, then you have to challenge that order.
In fact, Your Honor, I'll
You
just
have to
give a
challenge that order.
hypothetical scenario here.
Matter requires consideration. Take out notice, issue an emergent notice.
Your Honor, I have one interim prayer which I request Your Honor.
If you want an interim prayer, you may have to deposit some money then.
Your Honor, there's one last submission I will make. This is a case in which the respondent is to pay me 1,63,000. In fact, considering the amount is so small, in my commercial wisdom, I did not litigate it. On the other hand, he's produced fraudulent documents and obtained an order for 9 lakhs. Under no circumstances I'm supposed to do it.
If you want to stay, you have to deposit.
I'm ready and willing to deposit, Your Honor, if that is the case.
50%. Barcode.
Your Honor,
Further proceedings.
I will make one submission. Just one submission. I will leave this matter aside. If somebody appoints an arbitrator just like that.
But it's not just like that. You are a party
just
to
like
that
that, Your Honor.
proceedings. You are a party to that proceedings.
I am not a
But
party to the proceedings.
You are
in
a party
itself.
to the proceeding before the civil court when an arbitrator was wrongly appointed.
I had no notice of this, Your Honor.
Sure. You're not a party in the suit.
Your Honor, it was an ex parte. I was made a party, but no notice was given, and then I was made ex parte.
Were you a party in the suit or not?
In paper, yes, Your Honor.
Well, notice was not served on you in the suit?
No.
In the suit?
No.
In the suit, you are not served?
I will have to clarify on that, Your Honor. But as far as I am as far as the instructions from the
Were you served with the notice in the suit or not?
my instructions are that all of this happened in secrecy, Your Honor.
If you want a stay, then you have to deposit. You can't get an order for stay in this proceeding without you challenging the order of the arbitrator, award of the arbitrator. If you want stay, you have to deposit.
Just take Your Honor to one
I have
last,
no further
one
arguments.
last judgment, Your Honor.
Yes,
One
but
last judgment of.
issue emergent notice.
When I
In
pray for
addition, the
the
learned
interim
counsel for the
stay of-
petitioner
I will
is
deposit
permitted to
as this court guides me.
interim stay of the impugned proceeding subject to the petitioner depositing 50% of the award of the arbitrator. However, the amount deposited shall not be released until further orders from the court. Yes. Remember?
Petitioner, only question is not the GPA, my lord, I'm producing the GPA, not the urgency is this, suit for partition. I seek, my lord, an injunction application, my lord, seeking not to alienate. My suit, my lord, petitions are 3 daughters. The respondents, my lord, my father, mother, and my brother. Kindly, my lord, kindly come to page
Suit
one.
is for what? Suit is for partition.
Suit for partition.
Hmm.
ನಾನು ತಂದೆ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕ್ತಾರೆ ಪೇಜ್ 107 ಮಾಡಿ ಮೆಜೆಸ್ಟ್ ಡಬ್ಲ್ಯೂ ರಾಜ್ ಮಾಡಿ ಒಂದು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಫೈಲ್ಡ್ ಬೈ ಮೈ ಫಾದರ್ ನೋಡಿ ಈ ಪೇಜ್ 108 ಮಾಡಿ ರೆಲೆವೆಂಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ 108 para 6 may I read below. It is submitted that the averments made in paragraph number 8 regarding each of the plaintiffs being gifted one apartment each in number 20 so and so is true and correct. However, the further averment that the defined number 1 has denied the right of plaintiff over the joint family property is not correct. It is submitted defined number 1 has always treated all his children as equal and always intends to equally distribute all joint family properties among all co-partners. The averments in paragraph number 9 are admitted to the extent that it is true and correct that all suit scheduled properties are ancestral joint family properties, and in that capacity, inures a right to all the co-partners to take a share in the same. However, as stated above, the defined number 1 has never denied the rights of plaintiffs over suit scheduled property. He admits, my lord, virtually my case.
Yes.
During the pendency, my lord, my brother, my lord, gets gifted, my lord, executed over all the properties, my lord, at ink page number, my lord, your lordships will find, my lord, page 46. He1, my lord, executes a gifted, my lord, my father, my lord, has undergone a brain surgery. ಆಸ್ಪತ್ರೆ ಕರ್ಕೊಂಡು ಹೋಗ್ತೀನಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು he my lord gets a gifted executed at ink page 46. During the pendency of the suit. Immediately, my lord, then I rush to the my lord trial court at ink page, my lord, 117. Lord, I advance the case. Seek, my lord, for an order of temporary injunction not to alienate. But so that my brother, my lord, does not further alienate the property. 117, my lord, the lordship gets.
Yes.
But the case is taken on today's board on the application filed by counsel for plaintiff. Shri PS advocate filed NOC for Vakalan, same is accepted. Shri MK filed NOC for D1 and same is accepted. Advocate for plaintiff filed memo along with 3 documents which are, my lord, the gift deeds. Heard the counsel and plaintiff on IA number 1, which is, my lord, the injunction IA. D3 and counsel called out absent. This is, my lord, my brother. Call on for hearing. My lord, from there on, my lord, they are dragging on the matter. Advocate of plaintiff and defendants 1 and 3 present. Counsel for D1 press time. Call on for hearing. My lord, on the next date also, my lord. I have argued, my lord, thrice before the trial court. Advocate for D3 files IA along with WS. Advocate for plaintiff time for objection. Counsel for plaintiff opposes grant of time. However, in the interest of justice, time is granted to submit arguments on IA number 1.
So whatever you sought for, direction to dispose of.
Please, my lord. My lord, Monday, my lord, my brother set down, my lord, the property for registration. I'm only seeking, my lord, status quo. Let him not, my lord, further create, my lord, any.
What is there to show that he set down for registration on Monday?
My lord, yesterday morning, my lord, they have visited, my lord, the property. They set down, my lord, on Monday, my lord, registration. I have in fact requested the trial court on several occasions not to dispose of. Father, my lord, admits my case.
Yes.
I'm only seeking, my lord, to prevent multiplicity, my lord. These people are, my lord, 2 of them, my lord, are widows, having great difficulty. I am saying, my lord, let him maintain status quo. You've admitted my case. The brother, my lord, during the pendency, my lord, gets a gifted executed. Father says, my lord, I have never gifted, my lord, the property and is taken advantage. Kindly see, my lord, the return statement my father files. He says, my trouble, my lord, 1 paragraph, 109, my lord. 109, my lord. My lord, carries over from the last page. These defendants hereby specifically state that all items of suit scheduled properties are ancestral joint family properties and all the children are entitled to an equal share. 109, not at the top.
Yes.
All the items of suit scheduled properties are ancestral joint family properties and all the children are entitled to an equal share. Furthermore, the contention of defendant number 3, that is, my lord, my brother, that this defendant number 1 has executed a gift deed in favor of defendant number 3 are all false and denied. Defendant number 1 is a senior citizen and has recently undergone a surgery in his brain after suffering a fall in his house.
Issue emergent notice. In addition, learned counsel for the petitioner is directed to serve the learned counsel who represents the respondent number 3 before the trial court. Notice to response 1 and 2 is dispensed. With the next date of hearing, the respondent number 3 is restrained from alienating, encumbering or transferring any portion of the suit scheduled properties. Yes, list immediately after winter vacation. Please comply order 39 rule 3A.
Please, sir, come.
The learned counsel for the petitioners is directed to comply order 39 rule 3A.
And place on record, my lord, the GPM, not the.
Yes, mailed on the record. The learned counsel for the petitioners placed on record a copy of the power of attorney. What is this GPA?
Lord, plaintiff number 3, my lord, is given petitioner number 3, my lord, is given a GPA to petitioner number for signing in the Vakala.
Yes. The same is taken on record. Yes.
Grateful.
Serial number 40, P. Nataraju.
Officer Dekshan ಏನಂದ್ರೆ I am not a party to the impugned order. Impugned order is the compromise decree. The first respondent has entered into a compromise with the second respondent.
Take out notice,
ಅದೇ ಇದ್ರಲ್ಲಿ connected matter interim order ಕೊಟ್ಟಿದ್ದೀವಿ.
issue emergent notice.
Same 13 months. Interim order.
Ilamba?
Connected matter.
ಆಯ್ತು ಬಿಡಿ, list this petition along with WP numbers.
What is the subject matter?
But ಕಾಂಪ್ರಮೈಸ್ ಆಗಿ ಸ್ಟೇ ಆಗಿದೆಯಲ್ಲ ಒಂದ್ರಲ್ಲಿ.
ಬೇರೆ ಬೇರೆ ಪ್ರಾಪರ್ petitioners ಬೇರೆ ಬೇರೆ.
Till the next state of hearing, comma, the response are restrained from alienating, encumbering or transferring any portion of the properties which are the subject matter of the compromise petition in OS number so and so.
65. OS number melody.
This petition along with WP number so and so. Yes, next.
13th. Connected matter 13.
30.
113. 13 ಹೋಗಿದೆ 13 1.
ಅದೇ ಡ್ಯೂರಿಂಗ್ ದ ಕೋರ್ಸ್ ಆಫ್ ದ ಡೇ ಅಂತ ನಾವು ಮಾಡ್ಕೊಂಡಿದಿರಲ್ಲ ಅದ.
ಹೌದು ಅದೇನೆ.
ಭಾರತಿ ಗೌಡ.
ಇಲ್ಲ.
ಯಾವ್ದು 13?
ಅಲ್ಲಲ್ಲ 13 ಅಲ್ಲ 13ಕ್ಕೆ ಹೋಗಿದೆ 13ಕ್ಕೆ ಡೇಟ್ ಕೊಡಿ.
Okay, next. The office objections are overruled by accepting the submission of the learned counsel for the petitioner. Next.
Number 41, Annaya
CV Annaya, maintainability. Here, what is the order challenge?
13,000.
7 to 11 men.
33,000.
ಮತ್ತೆ ಎಲ್ಲೋ CRP ಹಾಕ್ಬೇಕಲ್ಲ. ರಿಜೆಕ್ಟ್ ಆಗಿದೆ 7 to 11. but CRP ಹಾಕ್ಬೇಕಲ್ಲ. ಬರ್ಕೊಳ್ಳಿ. The petitioner has challenged an order passed on an application filed under order 7 to 11A and D of CPC. The office has raised an objection that a writ petition under Article 227 is not maintainable and the appropriate remedy is to file a revision petition under Section 115 of CPC. Next para, a perusal of the impugned order shows that the same is passed on an application filed by the petitioner under Order 7 to 11A and D. Full stop. In that way of the matter, comma, a revision petition is allowed maintainable against the impugned order and not a writ petition under Article 227 of the Constitution of India. Hence, the office objection regarding maintainability is upheld. The petition is dismissed as not maintainable. Office is directed to return the certified copy of the impugned order to the learned counsel for the petitioner after retaining a photocopy. The time consumed in pursuing this petition shall be deducted while calculating the limitation applicable to a revision petition. Yes.
Number 42, Yetnal Parsappa Gurappa.
Please, my lordship. I appearing for the petitioner in this case, my lordship. A week time may be granted, my lordship.
What is it? What is the question regarding maintainability? What is the order challenge?
Order 39, rule 1 and 2, my lordship. Our senior counsel is out of location, my lordship.
File an appeal.
A short documentation. My lordship, short documentation may be given.
Time, Mr.
Lordship, 3 days, my lordship.
No. The petitioner has challenged an order passed on an application.
Lordship, kindly pass over the matter, my lordship.
Of CPC. Full stop. The office has raised an objection that the appropriate remedy is to file an appeal under Order 43, Rule 1R of CPC.
My lordship, please, my lordship, kindly pass over the matter, my lordship.
An appeal is provided. A perusal of the
Lordship,
impugned order.
hearing on maintainability, my lordship, I produced some documents, my lordship, some judgments, my lordship.
Yes, Barkul.
Kindly pass over, my lordship.
Please don't interfere, Mr. Madam Aito. A perusal of the impugned order shows that the same was passed on an application filed by the petitioner under Order 39, Rule 192 of CPC. Therefore, the appropriate remedy for the appellant petitioner is to file an appeal under Order 43, Rule 1R. Hence, the office objection raised regarding maintainability of this writ petition is upheld. The writ petition is dismissed as not maintainable. However, the certified copy of the impugned order is ordered to be returned to the learned counsel for the petitioner. The petitioner is at liberty to file an appeal in accordance with law. The time consumed in pursuing this petition shall be deducted while calculating the limitation applicable to an appeal. Yes, next.
Number 43, Vijay Kumar K.
Court fee paid, my lord, in the
Learned counsel for the petitioner submit that the court fee is paid. Yes. Yes.
Impugned order, my lord, is plaintiff filed under IA under Order 18, Rule 3 application to lead.
There is some caveat petition. Parties tally, but prayer does not tally. Hence, caveat petition is not put up.
IA, my lord, is.
There's
page
some
57.
caveat petition, please check it, mister. Thursday, they have caveat petition. 16967 of 24. Thursday, Passover. MM Swami.
Serial number 44, Swami MM. He's been paid.
Learned counsel for the petition submits that the court fee is paid.
Defendant's petition. The suit is for specific.
Office is directed to check and verify. Yes.
Defendant's petition.
Suit is for specific performance.
Specific performance.
Ah.
Agreement alleged to have been entered into my lord on 7/1/2009. He files a suit after lapse of 5 years.
Ah.
Lord, in fact, he examines itself and closes his evidence. And later, my lord, the defendant, in fact, DW1 was examined and closed her side. She was, in fact, my lord, cross-examined till June 2024. Later, my lord, she closed her side. And my lord, the matter was posted for arguments. Lord, at that time, in fact, she filed an application seeking permission to examine 2 more witnesses. This application was filed for reopening and also seeking permission to examine these 2 witnesses who are necessary.
Who are those 2 witnesses?
Lord, they are the witnesses. In fact, Lord, they have already entered into agreement, similar kind of agreements with the plaintiff. And in fact, the habit of the plaintiff is not lend money.
Where have you stated in your written statement?
No, written statement, in fact, Lord, we have said that
that you have taken some loan or something like that.
Loan antane heli. But para 10 may kindly.
Para?
10. Taking undue advantage of the helpless at the instant where plaintiff husband got created a document styled as agreement. So the agreement is also that is going to assist the defendants in raising loan, and therefore proper documentation has to be done in this respect. This is in fact, my lord, that there are several persons, my lord, who have entered into agreement only for the purpose of taking loan, and later, my lord, after receipt of the loan along with interest, he cancels those agreements. In this regard, in fact, my lord, I wanted to, I've already produced these agreements in my evidence, and my lord, with regard to proof.
How much according to was the loan that you raised?
9 lakhs.
9 lakhs was the loan that you raised.
The land.
No. How much money was the loan that you raised from the plaintiff?
Paid.
2 lakhs. You have repaid it.
No, it has not been repaid.
Then why don't you deposit that money? You don't even repay the money, you don't even execute the.
Repayment, yes, repayment has not been done because 3 months is the time fixed under the agreement.
Sir,
And
ದುಡ್ಡು
5 years,
ಎಷ್ಟು ತಗೊಂಡ್ರಿ?
5 years.
Plaintiff got created a sale agreement and
Yes.
shown to have paid some 2 lakhs advance for sale consideration. How much was the money that you raised as loan?
2 lakhs, in fact.
Then you show, what is there to show that you repaid the 2 lakhs?
No, I have not repaid.
Then you deposit.
Because 3 months time, in fact, is fixed under the agreement.
Whatever it is,
After 5 years.
If you want to,
After 5 years, he files a suit.
that's okay. Either you repay the money to him,
Yes,
ಇಲ್ಲ
sir,
deposit ಮಾಡಿ 2 lakhs.
We shall deposit this.
Or could issue emergent notice. In addition, learned counsel for the petition is directed to serve the learned counsel for the respondent before the trial court. In view of the peculiar defense taken by the defendant, that defendant number 1, defendant number 1, that she did not execute the agreement of sale in favor of the plaintiff, but the plaintiff had created a document to seem as if the suit property was agreed to be sold to him. She also contended that she had raised a sum of rupees 2 lakhs as loan from the plaintiff And in order to secure the said loan, the plaintiff had created the agreement mentioned above. Full stop. In that view of the matter, comma, the defendant number 1 is directed to deposit a sum of rupees 2 lakhs before the trial court within 4 weeks. Yes. Failing which, comma, within 4 weeks, full stop, interim stay of further proceedings before the trial court. It is made clear that if the amount of rupees 2 lakhs is not deposited, comma, the interim order granted today shall stand vacated automatically. Yes.
For hearing on IS serial number 45, RB Sadasivappa.
I'm open for appellant malad. Yanwas yoka 2 file malad. Yanwas yoka 2 file malad. RP Somchekar malad. Malad, modification order.
I appeal for the respondent, my lord. Copy of the application has not been served to me, my lord.
Yes, serve ಮಾಡಿಲ್ಲ copy.
No, Martha.
Learn counsel for
Tuesday malad. Tuesday.
learn counsel for the petitioner is directed to serve a copy of the IA 1/24 to the learned counsel for the respondent list after winter vacation.
Malad 2 star Wednesday malad. Lower court ಅಲ್ಲಿ ಇದಾಗಿದೆ ಸ್ವಾಮಿ ಕಾಪಿ ಶುರು ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ.
Tuesday ಹಾಕಕ್ಕಾಗಲ್ಲ.
ಮೇಡಮ್ ಮಾಡಿಫಿಕೇಶನ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಕರೆಕ್ಷನ್ ಇದೆ ಇಲ್ಲ ಅಂತೇಳಿ ಲೋವರ್ ಕೋರ್ಟ್ ಇದು ಮಾಡಿದೆ ಸರ್ ಟ್ಯೂಸ್ಡೇ ಆರ್ ವೆಡ್ನೆಸ್ಡೇ ಮೇಡಮ್ 20 ಇಲ್ಲ 19.
My lord, I'm not in town next week, my lord. Kindly have it after vacation, my lord.
Madam, don't take any precipitative action. If you want time after vacation, don't take any precipitative.
No, my lord, I am the landlord. He is in possession. I will not take any action. I don't know what is, your lordship has directed him to pay damages. He is paying it in court. That is the order passed by your lordship.
I do not know what is the order, but he says there's some urgency. You say you're not in town for the next week.
Matter is posted for cross-examination of PW1, my lord. That is all.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಮಾಡಿಫಿಕೇಶನ್ ಸೀನಿಯರ್ ಇಲ್ಲ ಸ್ವಾಮಿ.
Tuesday ಯಾಕಕ್ಕೆ ಏನಕ್ಕೆ urgency?
ಅಲ್ಲ ಮೇಡಮ್ ಯಾಕೆ ಸೀನಿಯರ್ ಇಲ್ಲ 2 ಸ್ಟಾರ್ ವೆಡ್ನೆಸ್ಡೇ ಮೇಡಮ್.
Tuesday ಏನಕ್ಕೆ ಬೇಕು urgent?
ಅಲ್ಲ ಅಲ್ಲಿ ಲೋವರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಹಾಕಿಲ್ಲ ಅಂತ ಹೇಳಿ ಅವರು ಇದನ್ನ ಕೇಳ್ತಾರೆ.
ಆಯ್ತು Tuesday ಒಳಗೆ ತಗೊಳ್ದಿದ್ರೆ ಏನಾಗುತ್ತೆ ಕೇಸು?
2 ಸ್ಟಾರ್ ವೆಡ್ನೆಸ್ಡೇ
ಏನಾಗುತ್ತೆ ಹೇಳಿ Tuesday ಒಳಗೆ ತಗೊಳ್ದಿದ್ರೆ ಏನಾಗುತ್ತೆ ಹೇಳಿ?
ಅಲ್ಲ ಅದನ್ನ ಆರ್ಡರ್
list after winter vacation. Yes.
Serial number 46, Girish Pardare.
Appear for the petitioners in this case.
Yeah, 1/24 for vacation.
Suit for partition, my lords, is filed. I filed an application now under order 39 to 1 and 2, my lords, which comes to be rejected by the trial court. With order at annexure D, my lords, page 37. I challenge it before the district court, my lords, which also comes to be dismissed.
Yes.
That order is challenged before this honorable court, my lords. There is an order granted.
Suit is for partition.
Partition, my lords, on separate point.
What is the nature of injunction sought for?
Not to alienate the property.
Why does the trial court refuse injunction?
My lords, the trial court, my lords, says that whether the properties are available for partition or not is a matter of trial and it cannot be adjudicated. at the time of
Para
considering-
14 minutes. Para 14, page 51, the finding of the trial court.
Let him argue.
Please, sorry, I apologize.
It cannot be considered at the time of the consideration of the application, my lords. The reasoning is at paragraph 12, page 49. This order was challenged before the appellate
Please
court.
read, what is the reasoning?
My lords, kindly come to page 49, my lords. On perusal of the documents produced by either parties, it is not in dispute regarding the relationship of plaintiffs and defendants with deceased Dode Gowda. Whether suit scheduled properties are already got partition between family of the plaintiff defendant 1 to 4 with family of defendant 5 to 11 or same or available for partition among them is a factual controversy cannot be dwelled into at this stage as holding a mini trial while deciding an application under order 13 rule 1 and CPC is completely forbidden. Then the court extracts the principles, my lords. Then at para 14, page 51. After weighing the versions of both the parties in the light of the relevant records placed before the court, it is found at this stage that the case of the plaintiff is clouded and the materials produced are not sufficient to remove the cloud, as it is specifically averred that except survey number 50 measuring 1 acre and survey number 74 measuring 27 guntas, no partition effected in respect of other properties. On the contrary, defendant 5, 6 and 11 have placed sale deed in respect of survey number 64/4 and 64/11 of the Antanamaki executed by his sisters, defendant 2 and 3. On careful observation of the pleadings with documents of either side, it is true at this juncture the plaintiff has not included the property standing in his father, defendant 1 to 4, and in respect of properties alienated by them.
When the plaintiff has failed to disclose the relevant facts and documents, it is difficult to grant the equitable remedy of injunction when the case itself is doubtful. Hence, I am of the opinion the plaintiff has failed to prove his case, that he is having prima facie case at this stage. When the plaintiff has failed to prove prima facie case under the circumstances, the question of consideration of balance of convenience or either.
Now, how can you selectively proceed?
Sorry, my lord.
How can you selectively proceed for partition?
Not selectively, my lords. What had happened, my lords, there was a partial partition between all the parties, where two survey numbers, my lords, was partitioned. Thereafter, my lords, the remaining properties remained intact. Now, my lords may kindly see the written statement. I'll show one document, registered sale agreement, which they have executed in respect of item number 3. My lords may kindly come to the written statement, which is at Annexure B, my lords, filed by the respondents. Defendant 5, 6, and 10. Page Annexure B, page 28, my lords. The relevant para is, my lords, at page 30, paragraph number 7.
Yes. Their written statement is filed by whom?
By defendant number 5, 6, and 10, the respondents were contesting before this court, my lords.
5, 6, and 10.
10. Now, my lords may kindly see para 7, my lords. ಪ್ರತಿವಾದಿ 5 ಅವರು ಇಲ್ಲಿ ಮನವಿ ಮಾಡಿರುವಂತೆ ವಾದಿಯು ಈ ದಾವೆಯಲ್ಲಿ ನಮೂದಿಸಿರುವ ದಾವಾ ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತುಗಳೇ ಅಲ್ಲದೆ ಚಿಕ್ಕಮಗಳೂರು ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ದಂಡನಮಕ್ಕಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 50ರಲ್ಲಿ ಸುಮಾರು 1 ಎಕರೆ. My lords may kindly note this next point, my lords. ಸರ್ವೆ ನಂಬರ್ 11/2ರಲ್ಲಿ ಸುಮಾರು 30 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣದ ಜಮೀನನ್ನು ಹೊಂದಿರುತ್ತಾರೆ. ಈ ಸೇಸ್ plaintiff owns this property. ಸದರಿ ಜಮೀನು ವಾದಿಯ ಸಹೋದರ ಹಾಗೂ 4ನೇ ಪ್ರತಿವಾದಿ ಡಿ.ಎನ್. ರಾಜಶೇಖರ್ ಇವರಿಗೆ ಚಿಕ್ಕ ಗೋಪಾಲ್ ಬಿನ್ ಕಾಳೇಗೌಡ ಎನ್ನುವರಿಗೆ ಮಾರಾಟ ಮಾಡಿರುತ್ತಾರೆ. ಸದರಿ ವಿಚಾರವನ್ನು ವಾದಿಯು ತನ್ನ ವಾದ ಪತ್ರದಲ್ಲಿ ನಮೂದಿಸಿರುವುದಿಲ್ಲ. Rest of it is not relevant, my lords. They say 11/2 of 30 guntas was owned by plaintiffs. They have sold it to somebody. My lords may kindly come to Annexure F, page 86.
Page
86, my lords. A registered sale agreement is executed by defendant 5, 10, 8, 9, and 11, my lords, in respect of the very same property which they say is owned by the plaintiff. My lords will find the schedule at page 96.
It is executed by the defendants 5.
My lords, first person, my lords, at page 86. Sri Manjegowda is defendant number 5. Then serial number 4, Sri Kumaraswamy is defendant number 10. The next page, my lords, serial number 7, Sri Puneet is defendant number 8. Srimati Shobha is defendant number 9, and serial number 9, Pushpalata is defendant number 11. They say it is my property. I make it as item number 3 before the trial court. They execute a registered document.
What about the other properties that stand in the name of your father?
My lords, my lords may kindly come to the reasoning given by the first appellate court, my lords. At the page 84, my lords, the conclusion part. Paragraph 19. Sorry, paragraph 29, my lords, page 84. As stated, supra, plaintiff has failed to establish all the suit scheduled properties or ancestral properties of the plaintiff and defendant, except suit item 2, 6, and 7. Further, it is established that suit item number 3 is granted in favor of Ajay Gowda under the Karnataka Land Reforms Act. Whether it is granted during the jointness of Ajay Gowda and Nanjunda Swamy is a matter of trial. Only on this score, plaintiff cannot claim injunction because he has failed to establish all the suit scheduled properties or joint family properties. My contention before my lords is this. Trial court admits, my lords, 2, 6, 7, and item number 3, my lords, are joint family properties. Admittedly, defendants, my lords, before trial court say it is plaintiff's property in the written statement, but they go and execute a registered sale agreement. If there is no injunction which protects me, my lords, there is a registered agreement, my lords. Immediately after dismissal of this petition, they'll sell the property.
Yes.
That is my case before this.
No, but whether this item number 11/2 is also suit property.
Please, my lords, item number 3, my lords. My lords will find it at page 26, serial number 3.
Yes, Mr.
Lords, may I take your lordships to para 8 and 9 of the written statement, which my learned friend didn't continue reading it. Page 31, lords, para 8. ಪ್ರತಿವಾದಿ 5 ಅವರು ಇಲ್ಲಿ ಮುಂದುವರೆದು ಹೇಳಿರುವಂತೆ ವಾದಿ ಮತ್ತು ಪ್ರತಿವಾದಿಯು ಕುಟುಂಬಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ಸರ್ವೆ ನಂಬರ್ 74/4 ಅಲ್ಲಿ 0.08 ಗುಂಟಾಸ್ ವಿಸ್ತೀರ್ಣ ಹಾಗೂ ಸರ್ವೆ ನಂಬರ್ 74/5 ಡ್ಯಾಶ್ ಗುಂಟ ವಿಸ್ತೀರ್ಣ ಜಮೀನನ್ನು ನೋಂದಣಿ ಸಂಖ್ಯೆ ಸೋಣಿಸೋ ದಿನಾಂಕ 15/12/14 ದೊಡ್ಡಪ್ಪ ಗೌಡ ಬಿನ್ ಲೇಟ್ ಚಿಕ್ಕೇಗೌಡ ಎನ್ನುವರಿಗೆ ಶುದ್ಧ ಕ್ರಯಕ್ಕೆ ನೋಂದಾಯಿಸಿಕೊಟ್ಟಿದ್ದು, ಈ ರೀತಿ ವಾದಿಯು ಸದರಿ ಸರ್ವೆ ನಂಬರ್ 50, ಸರ್ವೆ ನಂಬರ್ 64, ಸರ್ವೆ ನಂಬರ್ 74 ಜಮೀನನ್ನು ಈ ವಾದ ಪತ್ರದಲ್ಲಿ ನಮೂದಿಸಿರುವುದಿಲ್ಲ. ಉದ್ದೇಶಪೂರ್ವಕವಾಗಿಯೇ ಖರೀದಿದಾರನು ಕೂಡ ದಾವೆಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಅವಶ್ಯಕ ಪಕ್ಷಗಾರನಾಗಿ ಮಾಡಿರುವುದಿಲ್ಲ. ಈ ಎಲ್ಲಾ ವ್ಯವಹಾರಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ವಾದಿ ಮತ್ತು ಪ್ರತಿವಾದಿ 1 ರಿಂದ 4 ಅವರು ಅವಶ್ಯಕ ಪಕ್ಷಗಾರರಾಗಿದ್ದು ಕ್ರಯಪತ್ರವನ್ನು ನೋಂದಾಯಿಸಿಕೊಟ್ಟಿರುತ್ತಾರೆ. ದೆನ್ ಪ್ಯಾರಾ 9 ನೋಟ್ಸ್ ಇಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ಪ್ರತಿವಾದಿ 5 ಅವರು ಇಲ್ಲಿ ಮನವಿ ಮಾಡಿರುವಂತೆ ವಾದಿ ಮತ್ತು ಪ್ರತಿವಾದಿ 5 ರಿಂದ 11 ರವರ ಕುಟುಂಬ ಸದಸ್ಯರ ನಡುವೆ ಈಗಾಗಲೇ ಹಲವಾರು ನೋಂದಾಯಿತ ವಿಭಾಗ ಪತ್ರಗಳು ಮತ್ತು ಜುಬಾನೆ ಯಾನ ಪಾಲುಪಾರಿಕತ್ತು ಪತ್ರಗಳು ದಿನಾಂಕ 31/12/2012 ರಂದು ಆಗಿದ್ದು, ಈ ರೀತಿ ವಾದಿ ಮತ್ತು ಪ್ರತಿವಾದಿ ಕುಟುಂಬ ಸದಸ್ಯರ ನಡುವೆ ಆಗಿರುವ ಎಲ್ಲಾ ದಾಖಲಾತಿಗಳಿಗೆ ವಾದಿ ಹಾಗೂ ಪ್ರತಿವಾದಿ 1 ರಿಂದ 4 ರವರು ಪಕ್ಷಗಾರಕ್ಕಾಗಿ ಸಹಿ ಹಾಕಿದ್ದು, ಇದರ ಆಧಾರದ ಮೇಲೆ ತಮ್ಮ ಹೆಸರಿಗೆ ದಾವಾ ಸ್ವತ್ತುಗಳು ಹಕ್ಕು ವರ್ಗಾವಣೆ ಕೂಡ ಮಾಡಿಕೊಂಡಿದ್ದು, ಈ ಕಾರಣದಿಂದ ವಾದಿ ಮತ್ತು ಪ್ರತಿವಾದಿ ಕುಟುಂಬ ಸದಸ್ಯರ ನಡುವೆ ಪಾಲು ವಿಭಾಗವಾಗಬೇಕಾಗಿರುವ ಯಾವುದೇ ಸ್ವತ್ತು ಉಳಿವಿರುವುದಿಲ್ಲ. And there are other properties also.
Where is that partition deed? ನೋಂದಾಯಿತ ವಿಭಾಗ ಪತ್ರಗಳು ಅದೆಲ್ಲ ಎಲ್ಲಿದೆ?
But the documents are not placed.
Well, you should be having those documents.
But my lord, the first applied court goes into each one of the scheduled property at para 12 at page number 71, commencing at para 12 at page 71. The first applied goes into the aspect of each one of the scheduled property to arrive at a finding whether it still constitute a joint family property or not, but later or not.
Without you producing the partition deed, you come to page number 70.
70, my lords.
In the middle, you say, in the middle of that page number 70, the appellate court says it is specifically stated among plaintiff and defendant several registered partition, oral partition, and memorandum of partition dated 31/12/2012 had taken place. To the said document, plaintiff and defendants 1 to 4 have put their signatures. On the basis of said documents, revenue records mutated into their respective shares. No property is left for partition. Plaintiff has not included property standing in his name to be sued purposely. Under notarized partition dated 25/97, property bearing number so and so was allotted to the father of plaintiff and remaining property allotted to so and so. That property so and so is standing in Ranjit Swami is not included. Hereafter, deal with the documents referring to each of the properties mentioned in the schedule. Illi the partition nimdu. Where are those documents? Without the producing those documents, how can
That was produced before the trial court note, that is not placed before lordship notes. That,
produce those documents? Produce those documents.
It was placed by them before the
I
trial
can
court.
produce Martin, I will. But
Counsel
those
for
they
the
are witness.
respondent is directed to produce the documents that were produced along before the trial court in support of the objections filed to the application for interim injunction. List on
Tuesday or Wednesday notes.
Tuesday, yes,
Wednesday.
whichever date you want.
Wednesday.
Wednesday.
Interim order may kindly be.
Interim order, say after vacation ತಗೋಬೋದಲ್ಲ.
Lordship has already seen, if lordship have to be satisfied with the documents, my lord, that will suffice.
No, they have executed registered document.
So this interim order is there since the last 6 months.
Lords, we tried,
So let it come after vacation.
I will take a chance on Wednesday notes.
Wednesday is only meant for urgent matters, Mr. Sarvana.
Please, my lords.
If you move the matter, I will not take up any
Thank you,
matter.
sir. Please, my lords.
List after vacation.
Immediately.
Interim order granted early. is executed
Immediately
on-
after vacation.
Immediately after.
Serial number 47, Mamta C. Kulkarni.
Here, Lingaraj. Yes.
Sufficient.
Assist the honorable court. Small notes are prepared and with the documents. The documents are all available in the file in the court below. So I'm not producing any new document. Copies served on my learned advocate on 29/11 itself. If your lordship permits, I'll file it here.
Good, good. Yes.
Perhaps the argument will be reduced if it is perused. Permit me to read it. Petitioner is the beneficiary of acquisition of various extents of land situated in Satagalhalli, Kasba Hobbli, Mysore Taluk. The land in survey number 21/1 and 21/2 measured 2 acres 36 guntas. In survey number 21/1 and 2, 2 acres, 28 guntas in survey number. In all 5 acres, 24 guntas was the land acquired for the benefit to the petitioner society under plain notification. So 4-1 dated so and so, so on. It's common ground that the above extents of land were acquired from Mr. MP Dasappa. Well, I request now your lordship kind attention to the document which you have filed, Ilman. Please turn to page 7 of the present today's submissions that I have given. Kindly turn to page 7. Please reach serial number
12 and 13.
Serial number next page by 8, serial number 12, 11 and 12. My lord would notice the name of the owner is MP Dasappa. This is followed by the final notification also. And if your lordship turns to page 9, the possession is taken on 7/1/1998. Award is passed on 8/3/93.
Yes.
But if your lordship will notice the provisions of section 12(1) of the Land Acquisition Act, from the date of service, within 3 months, he has to file an application to the Land Acquisition Officer under protest and seek reference. The outer limit, if it has to come to under 83B, is 3 years. This is the law declared in State of Karnataka versus Lakshuman 2006. But Dasappa did not come to the court and did not seek any enhancement. In the year 1998, date readily not available. An application is filed on the basis that entry is changed in my favor, the present respondents. Your lordship may ask, who are these present respondents? They were the mortgagors. Mortgagors had not retained possession, had surrendered possession to the mortgagee Dasappa.
Yes.
Encumbrance certificate showed Dasappa's name. And the inquiry was held by issuing notice to 4161 and 5A inquiry as well as 9 inquiry were made when hearing the Dasappa. At that time, he did not raise any objection. But in the year 1998,
Dasappa is the mortgagee.
Mortgagee in possession. That the mortgage deed is here. Kindly turn to mortgage deed, page 13. Well, 1 minute, sir. Right? Page 13. The subparagraph 3. Mysore Taluk Kasba Hovli Hanchya Dakale Hosa Hundi Atwa Hosa Thatgali Damada Patel Baswegouda or Makro Mote Patel Mallegoudro. The names are important. Your Hendati Sumar Ipate Roshida Putmadama, Dito Gramadeli Patel Mallegoudra Maklu, Ivate Roshida Puriputtamadapa, Matiure Chikamalaya. These are the persons who had mortgaged the property. These are not the persons who are coming before the court now. This will have to be observed by my lord. The mortgagors in this document, registered document, are different from the present applicants who are claiming interest in the property.
Yes.
My lord, the essential point is, if they were not served with notice under section 4161 or the other related sections, can they assume a right and seek reference? But they sought reference and this honorable court in the petition was filed saying that we were not made parties to the land acquisition proceedings, and the learned single judge chose not to interfere, and it was dismissed. The matter was taken up in appeal. Honorable division bench, consisting of the honorable chief justice and the companion judge, set aside the order of the learned single judge, remitted the matter to the reference court to implead us and start proceedings. We raised the objection saying 2 objections. One is they were not persons interested. If they had interested, it comes under, my lord would recall, section 30 is a specific provision under the Land Acquisition Act, which would resolve the dispute between the mortgager and mortgagee, apportionment of the compensation. They chose not to avail the section 30 proceeding.
Yes.
But my lord, the essential thing is today the situation is this. This honorable court has directed us to file our appeal. We have filed the appeal. They have filed the appeal, and these 2 appeals, the sets of appeals are clubbed and they are pending before the London District Judge, the first appellate court. The humble submission I make to the Honorable Court is, if your Lordship were to pronounce either in favor of the petitioner or against the petitioner, that would seriously affect the pending proceedings before that. Instead of hearing this matter on merits, could your Lord please notice my submission at the end of my notes. Page 5.
Yes.
Bottom two paragraphs. All these facts are in dispute, and the issue of entitlement of compensation is pending consideration in LAC appeals presented by the beneficiary pursuant to the and in terms of the direction granted by the WP number so and so. Said appeals are clubbed with appeals filed by respondents. All the said appeals are set down for hearing on merit before the Honorable District Judge Mysore. Since the claimants respondent object to passing of any order of execution of the stay order, the present petitions are filed and interim orders obtained. This is submission. Any order that may be passed by this Honorable Court on the same set of facts would influence the proceedings in appeals and counter appeals referred to above pending before the Principal District Judge Mysore. Honorable Court may consider as to whether the parties must abide by the decision of the Honorable District Judge instead of inviting an order.
What is challenged here? What is challenged in this petition?
Okay.
What is challenged in this petition?
I'm sorry, Milord, I didn't
On
hear
the
this.
execution.
The execution, they did not grant an order of stay. They said, you can't, I have filed an appeal saying that want of liability. You can't pre-decide the matter and grant. This Honorable Court entertained the petition and granted an order of stay. The question is, within 3 months before the commencement of summer vacation, the appeal should be disposed of. If that is, otherwise, we have
My respectful submission, my lord, the acquisition of the year 1990. The respondents have appeared before the land acquisition officer and they received the compensation. My lord, kindly come to annexure R2, my lord. R2. This is the order of the Tahsildar, my lord, restoring the revenue entries in favor of respondent,
Supreme Petition,
who is the legal heirs of Patel Mallegowda. My lord, wherein the Tahsildar, my lord, on detailed consideration, page number 63, my lord, in objection, my lord. My lord, on considering the discharge of mortgage.
Please read the order passed by this court. Really, where is the order passed by this court?
My lord, this court, my lord, kindly, my lord.
Where is the order passed by this court?
Remanding the matter.
My lord, there is no remand, my lord. What happened, my lord? This court dismissed their appeal.
The first two.
Dismissed.
Why don't somebody produce it before the...
That was produced, my lord. This court dismissed the appeal. My lord, I made submission, my lord. I filed appeal for before district court for announcement, my lord.
Honorable Chief Justice and Justice Bopana, I have passed this order.
My lord, after that order, my lord.
Why don't you allow me to understand the case?
Please, my lord, please.
I understand his anxiety. So many years are over and he has not received money. But he has to receive from Dasappa, not me.
I only submission.
This Budhavana, the present petitioner is the appellant.
Remand order admele.
Please wait. So what was challenged in WP number 25480?
The same survey numbers will my lord would find in paragraph 1.
My lord, in that case, my lord, what happened, my lord? Without making the beneficiary as a party, my lord, LAC case had been proceeded, my lord. Therefore, the beneficiary had approached this honorable court. Finally, division bench remanded the matter. Thereafter, my lord, LAC case had been proceeded. In LAC case, my lord, I produced the annexure R1 is the LAC order, my lord. Wherein, my lord?
Please wait, let me understand this order.
Copy beka? Idea.
Indra, you should understand that the judge is new to the case. A judge is always new to the case.
Please, my lord.
You are old to the case.
Sorry.
You know the facts. I do not know the facts.
I'm sorry.
So you should educate me about the facts.
Please.
You're jumping to the next point without even me understanding.
Please, ma'am.
So what was the finding in the division bench?
my lord, So in 2009, he gets the communication that the amount of earnings from some other source. Then he files the application, my lord. They kindly turn to paragraph 4. A perusal of the impugned
Yeah,
order.
the amount is not dispersed to the.
The amount is disbursed to Dasappa. Dasappa has
No, no,
entered satisfaction.
No, amount is dispersed to.
The essential point is this. He gets the revenue entry altered without discharging the mortgage. Encumbrance certificate even now says mortgage is subsisting.
Amount.
Without dispute ಮಾಡ್ತಾರೆ. My lord, the question is whether revenue entry can be taken note of, which has come into existence after the 4-1 notification. Honorable Supreme Court has said this is the decision.
No, ultimately, it is the land loser who has to get the compensation.
Yes.
That is the law.
Okay, there are two disputes. One is Dasappa was the person interested. He did not claim. Number two, they got a revenue entry without discharging the mortgage debt, without going to section 30 proceedings. He has instituted proceedings. Present proceedings are the basis of the revenue entry, transferring the discharge of the mortgage and transferring it to his name. The question is this, this is decided by the Honorable
Please tell us, when was the compensation released to Dasappa?
No, compensation is not released to Dasappa.
Please wait.
Dasappa ಅವರು compensation ಕೊಟ್ಟಿಲ್ಲ. It's a finding of.
ಅವ್ರು ಹೇಳ್ತಿದಾರೆ ಕೊಟ್ಟಿದೀವಿ ಅಂತ ನೀವು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿದ ಅವ್ರು ಹೇಳ್ತಿದಾರೆ ಕೊಟ್ಟಿದೀವಿ ಅಂತ. Let him say when the amount was released.
Let them show, man. Let them show.
That is in the LAC proceedings. That's the
please make a pointed reference as to when the amount of compensation was released to Dasappa.
95. In 95.
For a moment, man.
95 in favor of Dasappa.
Mr. Lingraj, please sit down. Please sit down unless you want to go outside. ಇಲ್ಲ urgency ಇದೆಯಾ ನಿಮಗೆಲ್ಲ ಹೋಗೋದಕ್ಕೆ?
ಇಲ್ಲ man.
ಕೂತ್ಕೊಳ್ಳಿ ಮತ್ತೆ.
Please, man.
Please sit down. I'll hear you. Without hearing you, I'll not pass any orders. Rest be assured.
Wanted it to be a little more peaceful. I'm sorry, I'm disturbing the Honorable Court.
Court proceedings should not.
Yes, he's an youngster. Compared to me, he's an youngster. Please ignore it. Please ignore it. Let's proceed with the matter.
Lingraj is a good friend of mine. That's a different thing. But court proceedings, it should be calm and peaceful so that we can understand. If you go on intervening, I mean, you're only wasting time, Aste.
Yes. On his behalf, I seek an apology. And
not necessary.
Please. Yes. The essential point is this: whether the mortgage are under the acquisition proceedings or under the exhibit mortgage deed are one and the same. That is one issue. The reason I submitted is the names appellant in the notification is Dasappa. 41, 61, 51, 5A, 9 proceedings, and the award. All of them are in favor of Dasappa. Now, if he has got, Dasappa is none other than the mortgagee with possession. If he has got some interest in the compensation amount by reason of his status as a mortgagor, he has a remedy under section 30 of the Land Acquisition Act, not under section 18. Well, he keeps quiet, allows events to occur in the meanwhile. The events that have occurred are that compensation is paid to Dasappa and he has not made any claim to the compensation. Yes. The situation is whether he has a right to seek the filed application 18.3b. I pointed out that 30 is the relevant provision. 18.3b, the rigor of law is the state of Karnataka versus Lakshman. 3 years, 3 months from the date of the award or the service of it. 893 is the award passed. He should have filed an application, assuming that he had some interest in the property. Without getting it resolved under section 30, he cannot come, is the submission I make. But assuming that he has come to the court, he should have come within 3 years from the date of the award, 96. He files an application. His kata is restored to his name in the year 1998.
Yes.
Without, we are not interested in that. Only thing is, whether the restoration of the kata would give him the right is the question. This question arose for consideration in the Supreme Court in the Karnataka case only, Bangalore refinery case. I have made that decision available to your Lordship. Would your Lordship please ಅಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ ತಮಗೆ ಈಗ ಈಗ ತಗೊಂಡು.
Yes.
Kindly go to paragraph 6. The short question which is posed for consideration of this court is whether respondent number 1 MRPL, who is simply an allotee of the land by KIDB after the acquisition of the land under section 28 of the KIDB 1966, which was for the benefit to the Karnataka Industrial Area Development Board, can be said to be a person interested under the provisions of KIDB Act 1966, and therefore was a proper party in the reference proceedings initiated in the original proceeding. While answering the aforesaid issue or question, it is required to be noted that in the present case, the land has been acquired under the provisions of KIDB Act 66 and the notification has been issued under section 28(1). The land has been acquired by the state government for KIDB under 3 different notifications. After the lands were acquired under the respondent MRPL, had been allotted lands acquired as per agreements between KIDB and MRPL. The present is not an acquisition under the provisions of the Land Acquisition Act, and therefore, as such, neither section 50 of the Land Acquisition Act nor any other provisions of the Land Acquisition Act shall be applicable with respect to the lands acquired under the provisions of KIDB Act 1966. Taking into consideration the aforesaid factual aspects, the impugned judgment and order passed by the High Court, in which it was heavily relied on upon the decision court in the case of UP Evas Nigam, the Himalayan trails and they are required to be considered. At the outset, it is required to be noted that as such, the issue involved in the present appeal in respect of the acquisitions under KIDB Act 96 and the right of the subsequent allotee to and the right of the subsequent allotee to participate in the reference proceeding, and whether the subsequent allotee can be said to be a person interested under the provisions of KIDB Act, is no longer res integra, while deciding the acquisition of the very KIDB Act and the right of subsequent allotee who has been allotted by land in KIDB in the proceeding. Pirappa Hanumanta Prasad, after distinguishing the decision of this court in the case of UP Evas Nigam, tells it is specifically observed by held the court that an allotee of company cannot be said to be a beneficiary of a person interested, entitled for hearing. I stop here. This is law declared and this is approved by this decision. Now he is a person who has got the name entered in the revenue records, and by reason of that, he says, I'm a person interested. That is subsequent to 401 notification. For our subsequent, the person who gets the entry in the name is not a person interested in the law declared. Well, I'm assuming for a while that on an equity grounds, I am the beneficiary. I have been acquired, I have been given the benefit of the land. The mortgagee in possession has been paid compensation, assuming that he has some right, some amount is because my lord would recall under section 4, person interested is not defined under the act by reason of deduction of law by the honorable court. We have come to read this situation, namely mortgagor and mortgagee both are interested. That's the position. Though he has not canvassed it, I'm making a statement because I have a duty to tell the position of law. Mortgagor and mortgagee both are interested. Now, he makes a claim that I'm interested in section 30. Well, I'm agreeable. He assuming that he is not interested in section 18 proceedings. And my lord would remember paragraph 5 of the Lakshman case. If a man has not sought enhancement of compensation, he has not approached the reference court, he should not be said that he has lost the right. Some amount has to be paid, market value nalli apportionment ಮಾಡ್ಕೊಡು. Well, these are the things I can canvas before the.
What now? The proceedings before the reference court is still alive.
The same alive and it's listed next week only. All the time ಸೊಮ್ಮತಿಗೆ ತಾವು ಒಂದು ಫೈಂಡಿಂಗ್ ಕೊಟ್ರೆ ಇದರ್ ನನ್ನ ಪರವಾಗಿ ಅಥವಾ ನನ್ನ ವಿರೋಧವಾಗಿ ಅಫೆಕ್ಟ್ ಆಗುತ್ತೆ, ಅದು ಬೇಡ. ತಾವು ಈಗ ನಾವು ವರ್ಷನ್ is this, he is a person whose name is not found in any of the notifications.
Yes.
ಅವ್ರು ತೊಂದರೆ ಮಾಡೋದು ಬೇಡ. The matter to be heard within 6 months, 3 months, 4 months, or 1 week. I have no objection. I am ready.
My respectful submission is that, my lord, insofar as MP Dasappa is concerned, my lord, he never came before land acquisition officer for claiming compensation. My lord, the respondents have discharged the mortgage. After discharge of mortgage, my lord, the Tahsildar, by considering the discharge challan, my lord, he passed the order restoring the revenue entries in favor of Patel Mallegoda. Way back in the year 1990 itself, when once the revenue entries have been restored in favor of the original landowner, my lord, then there is no question of role of MP Dasappa in the case, my lord. My lord, further, my lord, insofar as order of division bench, my lord, beneficiary is not made as a party in earlier reference court, was challenged before this court by the beneficiary. The division bench had remanded the matter and directed the reference court to give me opportunity. My lord, after affording opportunity, my lord, on 15 September 2012, as per annexure R1, the reference court, on detail considering the redemption of mortgage, the order of Tahsildar, has came to a conclusion that the respondents, the claimants are legally entitled. My lord, before reference court, the beneficiary has raised the ground of fraud, has claimed that they are not the owner, they are claimed that mortgage is not redeemed.
R1, is there any appeal filed against R1?
My lord, R1 what happened, my lord? Again, they filed the writ petition. My lord, in 2 years back, my lord.
Appeal is filed and pending.
For a moment. Writ petition had been filed. The writ petition had pending before this court for more than 10 years. Finally, in the year 2022, what happened, my lord? Matter is taken for final hearing. Before that, my lord, against for enhancement, my lord, the claimants have filed appeal before district court, my lord. I brought to the knowledge of the court while dismissing the writ petition. I filed the appeal before reference court. Direct to just I brought to the knowledge of the court, my lord. Regarding that submission, my lord, their case was dismissed. Nam case na bega dispose madlike direction kotru. My lord, when once this court, my lord, came to an opinion that, my lord, the order passed by the reference court is justifiable, it's considerable.
Where is the order passed in against R1?
My lord, against R1 mel writ petition file madi, they produced it, my lord, in writ petition, my lord. Writ petition will produce madidar. Now the appeals are pending before reference court. My only thing is, my lord, before district court, ನನಗೆ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಟ್ಟಿಲ್ಲ. ರೆಫರೆನ್ಸ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಆಗಿದೆ ಅದನ್ನ ಪರಿಹಾರ ಕೊಡ್ಲಿ ಅಂತ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಕೋರ್ಟ್ ಅಪ್ರೋಚ್ ಮಾಡಿದೆ. ಎಕ್ಸಿಕ್ಯೂಷನ್ ಕೋರ್ಟ್ ಅವ್ರಿಗೆ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ತು ಕೊಡಿ ಅಂತ, ಅದನ್ನ ಬಂದು ಇಲ್ಲಿ ಸ್ಟೇ ಮಾಡಿಸಿದ್ದಾರೆ. ದಟ್ ಇಸ್ ದ ಮ್ಯಾಟರ್ ಮೇಲೆ.
ನೋಡಿ ಎಷ್ಟು ಚೆನ್ನಾಗಿದೆ ಇವಾಗ ಅನ್ಒಬ್ಸ್ಟ್ರಕ್ಟೆಡ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದಕ್ಕೆ.
ಪ್ಲೀಸ್ ಮೇಲೆ
ಎಷ್ಟು ಕ್ಲೀನ್ ಆಗಿ ಕನ್ವೆ ಮಾಡಿದ್ರಿ, ಹೌದಾ ಇಲ್ವೋ?
ಪ್ಲೀಸ್ ಮೇಲೆ
ಅದೇ ತರ ನೀವು ಅವ್ರಿಗೂ ಬಿಡ್ಬೇಕು ತಾನೆ.
ಅಪಾರ್ಟ್ ಫ್ರಮ್ ದಟ್ ಮೇಲೆ
ಅಲ್ರಿ, ಎಷ್ಟು ಕ್ಲೀನ್ ಆಗಿ ಕನ್ವೆ ಮಾಡಿದ್ರ ವಿತೌಟ್ ಎನಿ ಒಬ್ಸ್ಟ್ರಕ್ಷನ್ ಫ್ರಮ್ ದ ಅದರ್ ಸೈಡ್.
ಪ್ಲೀಸ್
ಯು ಆರ್ ಏಬಲ್ ಟು ಕನ್ವೆ. ಸಪೋಸ್ ಇಫ್ ಯು ಹ್ಯಾಡ್ ಒಬ್ಸ್ಟ್ರಕ್ಟೆಡ್,
ಒಂದು ಫಾಲ್ಸ್ ಸಬ್ಮಿಷನ್ ಆಯ್ತು, ಅದಕ್ಕೆ
you will get an opportunity. Please. Why don't you wait? Please. Why don't lawyers learn is what I'm asking. You might have put in 30 years of standing at the bar. Still you're like a youngster. Tuck anta egar bidtira. Yaake egirtira anta? What makes you think that the court will decide the petition without hearing you? You will get your opportunity. Why do you jump?
Sorry.
No, all lawyers have this habit. ಎಲ್ಲ ಲಾಯರ್ಗೂ ಇದೇ ಹ್ಯಾಬಿಟ್ ಅಪ್ಪ. ಟಕ್ ಅಂತ ಎದ್ಬಿಡೋದು. And nobody takes you seriously if you do this. I'm telling you honestly. You should have some charisma. You should have move yourself majestically. Taka ಅಂತ ಎದ್ದೇಳ್ತಾ ಇದ್ರೆ nobody will care you. Nobody will take you serious. I'm honestly telling you.
Please.
If you want to be taken seriously, move like an elephant. Move like an elephant, elegantly, charismatically. 5 ನಿಮಿಷಕ್ಕೆ ಎಗರ್ತಾ ಇದ್ರೆ nobody takes you seriously. Yes.
For a moment, one submission. Insofar as payment of, for a moment, insofar as payment of compensation is concerned, the respondents, the claimants have received the compensation. The Dasappa has never approached the LAC before land acquisition office for compensation.
Why don't you make a statement when Dasappa received the compensation?
No, he has not brought in records, but the records are
You make a statement when Dasapa received it.
official records say award is passed in his favor,
It's
Dasapa.
okay.
And the amount is paid to Dasapa. Is the what?
Make a
Kindly-
statement.
1 minute, please, 1 minute. Kindly turn to page 29 of the present writ records. Against the award passed by the land acquisition officer. I don't know. So one set of advocates have filed a writ petition here, and it was pending for 10 years. Kindly turn to Annexure B, page 29. This order is passed by this honorable court on 2nd November 2022. Kindly turn to paragraph 4. After arguing the matter for some time, the learned counsel for the petitioner seeks permission to withdraw the petitioner, reserving liberty in favor of the petitioner to approach the appellate court under section 54 of the Land Acquisition Act. Learned counsel for respondent number 2 to 4 submits that they aggrieved by the judgment and award, irrespective of respective claimants have preferred LEC number 2 for enhancement. The said submissions are placed on record. The petition is disposed of as withdrawn, reserving liberty in favor of the petitioner to prefer an appeal against the impugned judgment and award. If such an appeal is preferred within a period of 4 weeks from today, the same shall be entitled to the benefit of section 40. This is granted, and now 4 appeals, their appeals and our appeals, they are all clubbed together.
So what have you challenged?
We have challenged here the execution court did not grant stay, saying that no, I will not grant stay. Against that, the present writ petition is filed under GMCPC.
What have you challenged in the appeals that were filed?
In the entitlement, the mortgages are different. Secondly, on the date of 4/1, as I submitted earlier, the name of the Dasapa is shown, to whom the award is passed.
So you have to make a specific statement that Dasapa received the compensation.
That's what the record would say. I wouldn't.
ಅದು ನೀವ್ ಹೇಳ್ಬೇಕು. No, if you want to sustain your claim or dispute the entitlement of the respondents, you should make a statement that I have paid the compensation to Dasapa.
Without instructions, please.
ಅದನ್ನ ಹೇಳ್ಬೇಕಲ್ಲ ಮತ್ತೆ.
No, I will go by record.
With kind permission.
If I am convinced that the payment is not made to Dasapa, I will be the first person to submit. 2, if they are entitled to amount, I submitted. Krishna, the Lakshman's case, paragraph 5 says they are entitled to some amount. Let them get it. At Tamatra Kelbeko, Nanata Kelbar.
Correct, but he says that compensation was not received by Dasapa, it was received by them.
He has not produced
If that
any
is
document.
so, if that is so, then 18 reference is maintainable. If they have received the compensation, then 18 reference is maintainable.
I'll go to the next step. 18 application is maintainable. There's an award. Now that award, against that award, I filed the writ. The court has asked me to convert into appeal. Appeals are entertained. None of these orders are challenged by the other side. Therefore, the appeals are pending against the award, very award.
Produce Modi, make a statement as to when Dasapa received.
In page number 28 of the LIC order, my lord, there's
Page
a clear
number?
statement.
Annexure R1.
R1 ನಲ್ಲಿ internal page 34, my lord, page 34.
Yes.
In after line number 13, my lord.
Page number?
Line 13, my lord. ಅಲ್ಲಿಂದ ಹೇಳ್ತಾರೆ. On perusal of order sheet of the land acquisition officer, disclose the fact that.
Page number 34,
Page number 34, my lord. Internal page 28 of the LIC order. Line 13, my lord. 12 notice.
Perusal of the order sheet to the land acquisition officer.
The perusal of the order sheet of the land acquisition officer disclosed the fact that the claimant have received the compensation on 18/10/1996 and 24/10/1996. The counsel for the respondent number 2 has placed reliance on the application dated so and so. Dasapa is not enrolled. He never come before the court.
Why don't you deposit the
I'll answer that question.
Just, the
I'll take
enhanced
the sentence. The counsel for response has placed reliance on the application date so and so. Compensation 1810 for claimants have received anta. The normal parlance is the claimant is the person against whom the acquisition procedure are laid and received. Claimant is Dasapa.
ಇದರಲ್ಲಿ ಯಾರು claimants?
Claimant in this case, my lord.
ಅಲ್ಲ ಇದು ನಮಗೆ
The respondents.
No.
ಬಸವರಾಜಪ್ಪ, ನಂಜಪ್ಪ.
ಬಸವರಾಜಪ್ಪ.
ಮಲ್ಲೇಶ್.
No. The claimant ಅಂದ್ರೆ ಇಲ್ಲಿ in section 12(2) notice. Here there is no record of the fact that 12(2) notice is served on them. They got the revenue entry entered in their favor in the 1998.
Yes.
96 is the earlier award. All this fact finding exercise is being carried on there.
Then you have to deposit the amount. Alva.
Please, my lord, I am with the honorable court. It has to be done. It has to be. Well, 1, 2 is if possible. Please
No,
keep the
please,
file
you
here.
do one thing, you please deposit the amount pending consideration of the appeals.
That is, now the question is, Dasappa is paid, excluding that I'll deposit. Whatever it is.
Dasapam kotte illa anta heltare. They say that they-
Miller, there are
whatever is the order passed by the.
in adversarial proceedings, if both of us submit the same, there's no issue at all between us.
Where is
There's
the,
an issue
where
because
is,
we are disputing
where
the
is the
facts.
award passed under section 18?
18.
Elli order. Award elli.
ಅದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಮೇಲೆ ಅವಾರ್ಡ್ ನೋಟಿಸ್.
ನಿಮ್ಮ ಹತ್ರ ಇದ್ರೆ ಕಾಪಿ ಇದ್ರೆ ಕೊಡಿ. Some 95 lakhs, 95 lakhs, huh?
ಪ್ಲೀಸ್ ಮೇಲೆ ಅಷ್ಟು ಕೊಡ್ಬೇಕು.
Deposits of at least 50%.
Absolutely. Well, I will not come into it. The reason is I am submitting that they are entitled to some amount.
No, that is okay, but we'll consider all those things.
ಅದೇ ಇದಕ್ಕೆ ನನಗೆ ತಾವು ಇಷ್ಟ ಹೇಳ್ಬೋದು. All these things will be decided there ಅಂತ ಹೇಳ್ಬಿಟ್ಟು 50% ಡಿಪಾಸಿಟ್ ಮಾಡು ಅಂತ ಹೇಳಿ ನಾವು ಮಾಡ್ತೀವಿ. I will do it.
50% ಡೆಪಾಸಿಟ್ ಮಾಡಿ ಪರ್ಮಿಟ್ ಟು ವಿಡ್ರಾ.
Yeah, let the appellate court decide whether it should be permitted to be withdrawn or not.
2000
The appellate court decided.
ಅಲ್ಲ ಕ್ಲೈಮ್ ಅಮೌಂಟ್ ಬಿಗಿನಿಂಗ್ ರಿಸೀವ್ ಮಾಡಿದೀವಿ.
Yeah, I can't decide whether your 18th petition is maintainable or not. That is pending consideration before the appellate court. But now, if I were to hold that 18 is not maintainable, then it will affect your interest.
Frustrated.
So therefore, we'll direct deposit of 50% of the award amount.
Please, my lord.
Let the trial court dispose of the appeals.
Within such and such a period.
ಅಷ್ಟೇ ಹೇಳಿದವರು.
ಮುಂಚಿನ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
ನೋಡಿ ಎಷ್ಟು ಟೈಮ್ ವೇಸ್ಟ್ ಆಯ್ತು ನೋಡಿ. ಬರ್ಕೊಳ್ರಿ. The JDR number 2 in EP number 49, 49 and 50.
Execution number
49 and 50 of 2023 before the second additional civil judge, senior division Mysore, is before this court challenging the order dated 5/4/2023 issuing attachment of movables of the JDR number number 2 and to stay the execution of the awards dated 15/9/2012 in LACs 379, 381, 382 of 1998 on the file of the second additional civil judge senior division Mysore. Next para. The facts in brief are that the petitioner herein was the beneficiary of acquisition of various extents of land in Satgalli village. Full stop. Insofar as the present petition is concerned, the land bearing survey number 21/1 and 21/2, na?
More ಇದೆ.
20,
21/1, 21/2.
20, 21/1 and 21/2 of Satgalli were acquired.
May make, without going to the merit, my lord.
I'm not going into the merits. I'm only narrating the facts were acquired. Full stop. The name of one Mr. MP Dasappa was shown as the occupant of the land, which ultimately culminated in the passing of an award in the name of Mr. MP Dasappa. Full stop. In the meanwhile, the respondents herein claimed that Dasappa was a mortgagee of the aforesaid land and that he was and challenged the revenue entries in the name of Mr. Dasappa before the revenue authorities. The revenue authorities, in terms of an order dated 9/12/1991, directed restoration of the name of the respondents herein as the owners of the land bearing serial number 20, 21/1 and 21/2. Full stop. The respondents then filed a petition for enhancement of the compensation,
Sought reference under 18.
sought reference under section 8 and sought reference under section 18
Yes.
of the Land Acquisition Act. And LAC numbers? Number is, what are the LAC numbers?
My lord, 381, 382, 379.
379, 381, 382 of
379, 381 and 382 of
1998.
1998 were registered.
Yes.
Full stop.
We were not made parties.
The petitioner herein was not arrayed as party in the said reference proceedings. The petitioner therefore challenged the proceedings initiated in the aforesaid reference cases, which ultimately came to be decided by a division bench of this court in writ appeal 2089-91 of 2011. Full stop. It was held by the division bench of this court the division bench of this court set aside the awards passed in LAC 379, 381 and 382 of 1998 and directed the reference court to reconsider the case in accordance with law. Full stop. The petitioner herein was directed to appear before the reference court and the reference court was directed to permit the petitioner to come on record in the reference petitions. Full stop. Later, the reference court passed an award on 15/9/2012, enhancing the compensation payable. Full stop. This apparently was challenged by the petitioner herein before this court in WP number
2012 ಹೇಳ್ತೀನಿ ಕೊಟ್ಟು ಇಲ್ಲೇ ಕೊಡ್ತೀನಿ
ಎಲ್ಲ ಕೊಟ್ರಲ್ಲ in WP number
ಸಪ್ಲೈ ಮಾಡ್ತೀನಿ ತಾವು ಮುಂದೆ ಹೋಗಿ ಇಲ್ಲೇ ಕೊಡ್ತೀನಿ.
25480.
Next will be page 29, madam.
47033 of 2012. Page 29.
47033 of 2012. However, the said writ petition was withdrawn with liberty to file an appeal under section 54 bracket small Roman 2 of the Karnataka of the Land Acquisition Act 1894. Full stop. Similarly, the claimants had also filed appeals seeking enhancement of the compensation determined by the reference court. In the meanwhile, the respondents initiated execution proceedings to recover the amount of compensation as enhanced by the reference court in LAC 49 and 50, na?
ಇಲ್ಲ ಅದು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಕೇಸು LAC number
Sorry,
379.
in execution case 49/23, 50/23 and 51/23. Full
In
stop.
LAC number 379, 81, 82.
Full stop. The executing court had issued an attachment of movables of the petitioner herein, and therefore the petitioner is before this court, challenging the order issuing a warrant of attachment of movables, as well as the proceedings in EP number 49, 50 and 51. Next, for the learned senior counsel for the petitioner submitted that the issue whether the respondents are entitled to claim compensation or not is still at large in the appeals filed before the district court under section 54(2). He contends that before the said issue is answered by the appellate court, the respondents are trying to execute the order passed by the reference court in LAC 379, 382, and 381 of 1998. Therefore, he contends that the petitioner be put on terms so that the respondents do not walk away with the compensation even before the appeal before the appellate court is decided. Per contra, the learned counsel for the respondents contend that though the award was passed in the name of the mortgagee, yet the petitioners were, the respondents were the ones who received the compensation, and they were entitled to seek for enhancement of the compensation under section 18. He contends that the reference court has entertained the request under section 18 and has enhanced the compensation, which is challenged not only by the respondents but also the petitioner in appropriate appeals filed under section 54(2) of the Land Acquisition Act. He therefore contends that there is no order of stay granted by the appellate court, and hence the respondents are entitled to execute the order passed in LAC 379, 381, and 382 of 1998. Therefore, he contends that no indulgence can be shown to stay the warrant of attachment of movables issued against the petitioner. Anything else? Ashtena, please.
The identity of the mortgagors and the present claimant is in doubt.
In view of the peculiar facts and circumstances of this case, the question whether the respondents are entitled to claim compensation, which according to the petitioner was already released to the mortgagee, and whether the petitioner respondents are entitled to seek reference beyond the time permitted, are all questions which are to be considered by the appellate court. Also, in the meanwhile, if the amount as determined by the reference court is recovered through execution, that may cause some inconvenience and discomfort to the petitioner. Therefore, without going into the aforesaid questions, it is only appropriate to direct the petitioner to deposit 50% of the compensation enhanced by the reference court in LAC 379 of 1998, 381 of 1998, and 382 of 1998 before the reference court within a period of 4 weeks. Full stop. The amount after deposit shall be kept in a fixed deposit, interest earning fixed deposit, and the same shall be released after the adjudication of the appeals filed against the award passed in LAC 379 of 98, 380 of 81 of 98, and 382 of 1998.
And the appeals filed by us.
As well as the appeals filed by the petitioners against the aforesaid awards. Since the acquisition is of the year 1990, it is appropriate to direct the appellate court to dispose of numbers ಹೇಳಿ
number
dispose of ಕೊಡಿ ನಿಮ್ದು appeals ಕೊಡಿ
number
dispose of MA 64 of 24, 65 of 24, 66 of 24, and MA
ನಿಮ್ಮ appeal
provide mail. So and so within 6 months from the date of receipt of a copy of this order. But simple ಆಗಿರೋದು you.
All contentions are left open.
It is needless to mention that all contentions are left open to be adjudicated upon and decided by the appellate court.
Let's put it up.
Yes.
48. Serial number 48, Revana Ballari.
Appeal for respondent number 1 to 5. In this case, I challenged the impugned order of rejection of the application filed by the objector. That he claims the ownership over the property and restraining the delivery of the possession of the properties. The respondent number 6 is the tenant, my lord.
Respondent number 6 is the tenant.
Tenant, my lord.
Ah.
He is tenant under me. And the only the person, the petitioner has executed the mortgage deed in favor of the KSFC Davangere to borrow the loan, my lord. There are other 13 children also there to the Gafur Saab, my lord. The Gafur Saab has purchased the property, who is the father of the petitioner, that after the death of the Gafur Saab, the remaining children also have the legal rights for the property, my lord. Therefore, the KSFC taking the mortgage deed only from the present petitioner had lent the loan and without being knowledge to the petitioner had auctioned the property for the lesser value of rupees 20 lakhs, meager sum of rupees 20 lakhs, because the property is worth more 2 crores.
What is challenged here?
Yes, ma'am. I challenged the impugned order at Annex J, ma'am. The order is passed by the learned trial court, rejecting the application under Order 21, Rule 59 and 47 of CPC, without being appreciating the proviso of the Section 47 of CPC to adjudicate all the rights involved to the applicant and objector, ma'am. And I am permitted to take this honorable court at page 65, para 34, my lord, where the trial court has been pleased to be ordered in para 34 of the impugned order.
Page 65.
Page 65. Impugned order, page 17. Impugned order, page 17. My lord, I am permitted to read para 34. It is apparent that the DHRs have purchased the application scheduled property. DHRs have also got decree for eviction against the present JDR. There is no doubt remains in the mind of the court that the DHRs are the absolute owner over the application scheduled property. JDR is a tenant under the DHRs. There is no landlord and tenant landship between the objector and the JDR. Since the objector is not the owner of the application scheduled property, the contention of the objector that the DHR is causing interference over the application scheduled property does not hold water. The contention of the objector that the possession shall not be handed over to the DHR does not hold waters. So this is the order passed by the trial court, my lord. Without being
wrong with this order?
Pardon?
What is wrong with this order?
My lord, the respondent, the JD number 6 is a tenant under me. And in the suit of 2010, my lord, filed by the JD number 1 to 5.
Who are you? Who are you?
I am the original owner of the property, my lord.
But you are not a party in the proceedings.
I am not party to the proceedings of the OS 283/2010, my lord. Without making me as a party, the suit is filed by the purchaser.
What is 283 of 2010?
Suit for eviction, man.
Suit for eviction.
Suit for eviction, man.
Filed by whom?
Filed by the purchasers of the suit property, man.
Yar.
JD number 1 to 5, man.
1 to 5.
1 to 5. They are very much interested in purchasing the property of the litigant property because the property is worth more 2 crores, my lord.
Sir, I am not getting the facts.
My lord, the JD number, the applicant is the original owner of the property, my lord. And his father, Gafur Saab, has purchased the property, my lord. And thereafter, the property has been constructed from the Gafur Saab only, my lord. And thereafter, the 14 children to Gafur Saab are the legal heirs to the property, my lord. But only the person, Gafur Saab, Abdul Jabbar Saab, has executed the mortgage deed in favor of the KSFC to borrow the loan, my lord. And he has not repaid the loan amount. And the loan and debt remains, my lord. Therefore, the present petition, the petitioner has filed the suit in below court in OS number 423/2009, my lord, for redemption of the mortgage deed, my lord, before filing the suit by the purchasers of the suit property against the KSFC and as well as the JD number 1 to 5, my lord.
Yeah, the suit enaithu.
That suit is still pending, my lord, because on the giving the evidence from the
Till now, you were sitting there, you heard what I told Mr. Lingaraj.
Please.
Again, you are doing the same thing.
on giving the evidence from the petitioner who is the plaintiff in the OS 423/2009, my lord. There he had given the evidence, and in the cross examination, the other side KSFC has been elicited that two properties worth more 2 crores, my lord. Therefore, the trial court, the junior division court, has ordered to return the plaint. Because I challenged the same in MA, my lord. Because I have filed this suit for redemption of the mortgage for a sum of rupees 3 lakhs only. Though the property is worth more, either the 20 lakhs as per the purchaser or the market value of the 2 crores, my lord.
Yes.
Under these circumstances, the MA is came to be dismissed, my lord. Thereupon it is come before this honorable court.
Who executed the mortgage?
The one is Jabbar Sahab, the petitioner has been executed the mortgage.
Petitioner has executed the mortgage.
Yes, my lord.
Now petitioners, section 31 proceedings are initiated.
Yes, my lord.
Property is brought to sale.
Brought to sale, my lord.
This response 1 to 4, 5 are purchased.
But before purchase, my lord, the notice has not been served on the petitioner, my lord.
That is a different thing.
Yes.
That,
I
then you have to
do
challenge-
agree, my lord, because the KSFC has executed the sale deed in favor of the JD number 125.
you should challenge the sale, mister.
Yes, my lord, I challenged it in the OS 423/09, my lord,
Yes.
for setting aside the sale made from the KSFC in favor of the JD number 125, my lord. That suit is still pending, my lord. And now the petitioner has represented the same in the senior division court, my lord. In OS number 129/2024.
Mr. Ballari,
Yes,
if you want a mango,
yes,
you should climb a mango tree. If you
Yes.
want a mango, you should
Yes.
climb a mango tree.
yes, ma'am.
Now you have to challenge the order passed by the, what you call the sale of this property. Where should you challenge it?
I challenged it in OS 423/09.
Can you challenge it is what I am asking you.
Yes, my lord, I challenged it, my lord.
Yes.
And that suit is still pending, my lord.
Hmm.
Because the applicants, the plaintiffs in the court below in OS 423/10 subsequently filed in 2010. In that suit, my lord, I the landlord has not made as a party, my lord.
Yes. You continue that suit that you have filed.
But
Let
thereupon, my lord,
tenant,
if at all
whoever
the
is-
position goes away, my lord, I could not, I am unable
No,
to
the
be.
tenant will continue to pay the rent.
Yes, ma'am. I'm ready to pay the rent, madam.
Ramesh Yaro,
Ramesh, my tenant, my lord.
let Ramesh come and say that.
That the other side.
Let
the tenant-
Ramesh come and say that I will henceforth pay the rent to
Still,
these people.
The tenant council has informed me, my lord.
What
but
is the order passed now?
Pardon?
What is the order passed?
Order passed in rejecting the application filed by the objector for seeking the declaring the petitioner is the owner over the property and restraining the handing over the delivery of the possession of this property, my lord.
Yes. How can you obstruct is what I am asking.
And my lord, I am another application under section 97 and 21 rule 97 of CPC is still pending in the same court, my lord.
Yes.
That application is not being disposed of by the.
Yes, sir. You are the mortgagor,
Yes, ma'am.
correct? You are the mortgagor.
Yes, too, ma'am.
Section 31 is initiated against you.
Yes, ma'am.
You are notified about the sale.
Yes, ma'am.
Property is sold.
Yes, ma'am.
You cannot object to the decree because you are the mortgagee or mortgagor. You are notified of the proceedings. How can you again obstruct the decree is what I am asking you.
But the tenant has been preferred the appeal, my lord. There he has not succeeded.
Sir, you cannot object.
I filed application, my lord.
You cannot object is what I am trying to tell you.
Because, my lord, the property is sold to the undervalue.
ನೀವು ಅದಕ್ಕೆ ಹೇಳಿದ್ದು ಮಾವಿನ ಮರ ಹತ್ಬೇಕು ನೀವು ನೀಲಗಿರಿ ಮರ ಹತ್ಬಿಟ್ಟಿದ್ದೀರಾ.
ಇಲ್ಲ, I filed that suit for redemption of mortgage, my lord.
Climb the Nilgiri tree.
Yes, I true, my lord.
You should have climbed the mango tree.
I filed a separate suit, my lord, in OS 423/09, and that was renumbered as OS 129/2024.
Doesn't matter, mister. You cannot obstruct the execution is what I am trying to tell you.
But the
third party can come and obstruct. The judgment debtor himself cannot obstruct.
I am not the judgment debtor, my lord.
What else are you?
I am the objector. I am the true owner of the properties.
Sir, you might be the true owner. You are the mortgagor.
Yes, my lord.
How can you become the
Because
obstructor?
without serving notice of the cause putting up the property into auction, and it is the error on the part of the KSFC, my lord.
Then you should challenge it in the proper
That
manner.
the same was challenged in the suit, my lord. That suit is still pending, my lord.
ನೀವು ಸೂಟ್ ನಡೆಸ್ಕೊಳ್ಳಿ, ಸೂಟ್
ಅಲ್ಲ
ಗೆದ್ಕೊಂಡು
ಹಂಗಂತಂದ್ರೆ there are so
recover
many
possession.
there are so many instruments and heavy instruments are available in the premises, my lord.
Yes.
Thereupon
Yes.
the even the
My lord,
the
my
petitioner.
lord, I appear for respondent number 1 to 5. The case is actually between respondent number 1 to 5 and respondent number 6. The petitioner is a stranger to subject properties. The subject properties were the Karnataka State Financial Corporation executed sale deed of subject properties, both the properties, on 21st April 2008. And we have issued notice to our tenants. JDR number, this respondent number 5, respondent number 6 and 6 in both the cases. And there was adjournment of tenancy from 1/7/2009. Learned counsel for the petitioner made a wrong submission that the OS number 423 of 2009 is still pending before the Honorable Additional City Civil Judge Davangere. It is not pending. The suit plaint was returned to the plaintiff under the this with observation that it was not sufficient, court fee was not sufficiently paid. That's one thing. After sale of the subject property, the plaintiff cannot redeem the property. His right for redemption is extinguished like that. The Honorable Trial Court has observed. On that basis, returned. It is not renumbered as OS number 129 of 2004 as submitted by the learned counsel for the petition. It is a separate suit. This is with regard to the OS filed by the petitioner. Your lordship may kindly see my statement of objections. I have also filed synopsis in this case, in both the cases. Your lordship may kindly see the annexure C, page number 2122 of the statement of objection.
Yes.
The property was sold in public auction by the Karnataka State Financial Corporation for 18 lakh rupees. After persuasion in sale proceedings meeting, the auction purchaser, we were the auction purchasers. We ultimately, the KSFC was succeeded in enhancing the consideration of the property for 20 lakh rupees. We agreed for that. So ultimately, under the KSFC executed sale deed in our favor on 21st April 2008. Your lordship may kindly see the legal opinion given by the learned counsel for the Karnataka State Financial Corporation.
Not bothered about that. Next year.
And this was challenged by the petitioner before this honorable court in the writ petition number 6049 of 2017.
6049 of 2000?
6049 of 2007.
17 or 7?
7.
This was auction sale.
No, auction sale. He challenged the auction sale.
What happened?
This honorable court granted interim order of stay for 3 months. Not to execute sale deed like that. Interim order was granted. Thereafter, in the next date of hearing, the court made observation to deposit 20 lakh rupees. 20 lakh rupees. That was a settlement amount like that. The petitioner did not remit the amount before the KSFC also. And they also made a representation of the KSFC for one-time settlement. The KSFC fixed 15.13 lakh as one-time settlement. There was no unity among the partners of the petitioner firm. So it was they reverted back. It was not settled. So in the meanwhile, before this honorable court, the interim order was not continued. Interim order was not continued, and the petitioner also failed to remit 20 lakh rupees before the KSFC branch Davangere. So the learned counsel for the appearing for the KSFC gave a legal opinion that the honorable court has not continued the interim order, and the petitioner also failed to deposit 20 lakh rupees before the court. So there is no impediment on the part of the KSFC to execute sale deed. So accordingly, the KSFC executed sale deed on 21st April 2008 in our favor. Since then, we are the absolute owners of the property. Till today, Kata and property taxes we are paying, and Kata also stands in our favor. And respondent number 6, in both the writ petitions, they are our tenants.
As I submitted early, there was adjournment of tenancy from 1/7/2009. And learned counsel for the petition submitted that they are tenants under them. They are not tenants under them. They are not paying rent to us. They are not paying rent them also. And whatever the property, their plant and machinery in the subject property, they all belong to us. We are the auction purchase. We purchased both plant and machinery as well as the landed property for 20 lakh rupees. That was the sale consideration. The learned counsel for the petition submitted that the OAS number 423. He has, I have brought the copy also. He has made pleadings in his plaint that the property, the subject property costs more than 2 crore rupees. But he has not paid court fee for 2 crore rupees.
ಇವಾಗ ರಮೇಶ್ ಅನ್ನೋರ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ what is the relief that you sought against Ramesh in the execution petition?
The execution in our suits are OAS number 283 of 2014 of 2010 and OAS 285 of 2010. Both the suits were declared in our favor.
What was the suit for?
Ejectment suit, eviction suit.
Of Ramesh.
Ramesh and Somcheckar. There are two tenants.
Yes, Mr.
And eviction suit it was decreed, but learned the petitioner also filed impleading application in both the suits, and those impleading applications were also dismissed by the honorable trial court.
Yes, Mr.
And this issue, my lord, one small submission, this OAS 423 of 2009, learned counsel, he has filed the suit after sale of the property, after execution of the property, sale deed of the property. And that has been decided by this honorable court in OAS writ petition number 49713 of 2018. Your honor may kindly see, your lordship may kindly see page number
71, annexure.
Annexure, page number 71 to 78, annexure H, my lord.
What is challenged here?
It was decided on 10/1/2024 by this honorable court.
ಇದಾದ್ಮೇಲೆ ಏನಾಯ್ತು?
There the proper plaint has been returned back and issued back and represented the same in the senior division court, my lord.
Yes.
And that suit is still pending, my lord. We may kindly be looked into.
Correct, but you work out your remedy in the suit. You work out your remedy in the suit.
What the learned friend is saying that the both instruments and as well as the property has been auctioned and received according to the sale and auction, your honor, my lord. There the property, the machinery has not been shown in the auction and sale.
That is not the
How
issue.
can the other side is saying that they all the machineries have?
Machineries is not the subject matter of the petition. It is the machineries is not the subject matter of the execution petition. It is a tenancy which is the subject matter of the execution petition.
But I am not mad as a party, my lord, because before filing the suit,
ನೀವು ದಾರಿ ತಪ್ಪಿದ ಮಗನ್ ತರ ನೀವು ಎಲ್ಲೆಲ್ಲೋ ಹೋಗ್ತಾ ಇದ್ದೀರಿ.
ಅಲ್ಲಲ್ಲ ಎಲ್ಲೆಲ್ಲಿ ಹೋಗ್ತಾ ಇಲ್ಲ
ಎಲ್ಲೆಲ್ಲೋ ಹೋಗ್ತಾ ಇದ್ದೀರಿ.
ಅಲ್ಲ
ಯು ಲೈಕ್ ಎ ಬ್ಲೈಂಡ್ ಫೋಲ್ಡೆಡ್ ಮ್ಯಾನ್. ಯು ಆರ್ ಸಿಂಪ್ಲಿ ಗೋಯಿಂಗ್.
ಇಲ್ಲ ಯಾಕಂತ ಹೇಳಿದ್ರೆ when they are admitting that I am the owner to the property in the cross examination,
Yes.
I also produced the deposition of the evidence of the executing court, my lord.
You allowed much water to flow. We cannot now undo all those things that have happened. Our sale deed work out, we can't undo it. Correct?
But it was challenged in the court, my lord.
Have you obtained any order from the court?
My lord,
Have you obtained any order in OS number 423? ತಗೊಂಡಿದ್ದೀರಾ?
ಅಲ್ಲ, there the suit is pending for the consideration, my lord.
Have you obtained any interim order?
No, my lord.
Then
because of the
why should the stone stop rolling? ಒಂದ್ಸತಿ ಗುಂಡು ಉರುಳಕ್ ಶುರು ಆದ್ರೆ you have to stop it. If you don't stop it, the consequences will follow.
Why we have not obtained the interim order, my lord? Because the trial court below has been pleased to order for return the plaint under order 7/10 of CPC.
Yes.
Thereafter, it is challenged in the MA case, my lord.
Yes.
And now it is come before this honorable court writ petition.
Sorry.
And there the honorable court has sustained the orders. And thereafter, my lord, I have received back the plaint and represented the same. It may kindly be looked into. When the plaint has been
ನಿಧಾನಕ್ಕೆ ಓಡಿಸ್ಕೊಂಡ್ಬನ್ನಿ, ನಿಧಾನಕ್ಕೆ ಮಾಡಿ ಕೇಸ್ನ.
ಅಲ್ಲ, there because my lord, the court fee is more. ಇಲ್ಲಿ ನಾ ರಿಡೆಂಪ್ಷನ್ ಕೇಳಿದೀನಿ. ರಿಡಂಪ್ಷನ್ ಅಮೌಂಟ್ ನಾ ಕೋರ್ಟ್ ಫೀ ಕಟ್ಟಿದೀನಿ.
ಸರ್ ನೋಡಿ,
ಅವ್ರೇನ್ ಹೇಳ್ತಾರೆ, ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಆಫ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಕೋರ್ಟ್ ಫೀ ಕಟ್ರಿ ಅಂತ ಹೇಳ್ತಾರೆ.
the consequence cannot stop till you get the suit decided.
ಅಲ್ಲ, ಸೆಕ್ಷನ್ 6 ಆಫ್ ದಿ ಕೋರ್ಟ್ ಫೀ ಅಂಡ್ ಸೂಟ್ ಪ್ಲೇಸ್ ಟ್ಯಾಂಕ್ ಮೇಲೆ
What do?
ನಾವು ಅಲ್ಲಿ ಕೇಳಿರೋದು ಎಷ್ಟು, ಇದು ನಾವು ಕೊಟ್ಟಿರೋದು ಎಷ್ಟು, ನಾವು ರಿಡಂಪ್ಷನ್ ಕೇಳಿರೋದು 3 ಲಕ್ಷ ಚಿಲ್ಲರ ಅಮೌಂಟ್.
ಬರ್ಕೊಳ್ಳಿ.
3 ಲಕ್ಷ ಅಮೌಂಟ್ ನಾವು ಕೋರ್ಟ್ ಫೀ ಕಟ್ಟಿದೀವಿ.
ಕೊಡಿ, ಸೂಟ್ ನಂಬರ್ ಕೊಡಿ.
OS ನಂಬರ್
ಕೊಡಿ.
129/24.
The obstructor in EP number 6/2014 on the file of the civil judge and JMFC Davangere.
My lord, there are two execution cases.
In EP number 6/2014 and
EP number 7 of 2014.
7/2014 is before this court challenging the rejection of an application filed by him under Order 21 Rule 58, read with Section 47 of CPC. Next part. The facts in brief are that the petitioner had mortgaged a factory, industrial unit.
ಇದು sawmill.
The petitioner had mortgaged a sawmill with the Karnataka State Financial Corporation for financial assistance. Full stop. Due to default in payment of the loan, the property mortgage was brought for sale under provisions of Section 31 of the SFC Act.
31 subsection 1 clause A of the
1 bracket A
double A
of the SFC Act. Full stop. The respondents 1 to 5 were the successful bidders whose bid was accepted. Full stop. The auction sale of the property was questioned by the petitioner herein in WP number 6049 of 2007. Though an interim order was granted by this court in the writ petition, the petitioner failed to comply with the terms mentioned in the interim order.
He withdrew the petition.
And later, the said writ petition was withdrawn. In the meanwhile, the petitioner also filed a suit in OS number 423, 423 of 2009 for redemption of the mortgage and for other consequential reliefs. The said suit was returned for representation before the appropriate court, which was challenged before this court in WP number
49713 of 2018.
49713 of 2018. Full stop. The order returning the plaint was affirmed by this court, consequent to which the petitioner represented the file before the appropriate court, and OS number 129 of 2024 is registered.
Sorry, my lord, that is that petition number 49713 of 2019.
423 of 2019.
49713.
2019.
2019 WP number 9. OS number 129 of 2024. In the meanwhile, the sale in favor of the respondents 1 to 5 was confirmed, and a sale certificate and a sale deed. And the sale deed was executed by the financial corporation. Full stop. The respondents 1 to 5 then initiated eviction proceedings against the respondent number 6 in OS number
283 of
283 of
2014.
2010 and
2010 and 285 of 2010.
285 of 2010. The said eviction petitions were allowed, and the respondents 1 to 5 initiated execution petition 6/2014 and 7/2014 for eviction of the tenants. Full stop. In that execution petition, the petitioner filed an application under Section 21 Order 21 Rule 58 of CPC read with Section 47 to obstruct the execution of the decree. The said application came to be rejected in terms of the impugned order. Full stop. Being agreed by the said order, the petitioner has filed these two writ petitions. Next, for the learned counsel for the petitioner contends that the property which was worth more than 2 crores was sold for a pittance of rupees 2 lakhs, is to 20 lakhs.
20 lakhs.
20 lakhs.
Sold for a pittance, that is rupees 20 lakhs. He submits that the property was purchased by the father of the petitioner,
House.
father of the petitioner, who had 14 sons,
14 sons.
sons
14
or children,
14 children.
14
ಅದ್ರಾಗ
children.
ಹೆಣ್ಮಕ್ಳು ಇದಾರೆ.
And that it is a petitioner alone who had executed a mortgage. He contends that no information was given to the petitioner before the property was brought for sale. Consequently, the petitioner was entitled to seek for redemption of the mortgage as well as the consequent sale in favor of the respondents 1 to 5. He submits that the suit filed by him is presently pending consideration in OS number 129 of 2024. And in the meanwhile, the respondents 1 to 5 have taken steps to evict the tenant. Full stop. He therefore contends that the petitioner has some locus standi to obstruct the execution of the decree. Full stop. Per contrast, the learned counsel for the response 1 to 5 submitted that despite grant of enough opportunities to the petitioner, he did not pay up the money payable to the financial corporation under the one-time settlement scheme or in terms of the order passed by this court in WP number 6049 of 2007. He contends that the financial corporation, having realized that there was no impediment for execution of a sale deed, had conveyed the property sold to the respondents 1 to 5. Consequent to which the respondents 1 to 5 initiated eviction proceedings again to evict the tenant occupying the property that was purchased by them. He contends that the eviction proceedings were decreed, and what is sought to be executed is the decree so passed in the eviction petitions. Thus, he contends that the petitioner has no locus standi to obstruct the execution of the decree, as he was a party to the proceedings initiated under Section 31(1)(AA) of the SFC Act 1951. Full stop. Next, I have considered submissions made by the learned counsel for the
Other legal heirs
and the learned
other
counsel
legal
for the-
heirs have also rights, my lord. Other legal heirs have also rights.
Respondents 1 to 5. Next para. The perusal of the impugned order shows that the petitioner was aware of the proceedings initiated against him by the financial corporation under Section 31(1)(AA) of the SFC Act 1951. He was also aware of the auction sale of the property in question to the respondents 1 to 5. So the petitioner had challenged the auction sale before this court in WP number 6049 of 2007, but later withdrew it. Full stop. Therefore, the petitioner has given up his challenge to the auction sale of the property in question. Full stop. The petitioner has no doubt filed a suit for redemption of the mortgage in favor of the State Financial Corporation. However, the question whether such a suit is maintainable or not, that too after the mortgagee has exercised its statutory right of foreclosure, is something that has to be decided by the civil court in the pending suit. Insofar as the present proceedings are concerned, the petitioner had obstructed the execution of a decree obtained by the respondents 1 to 5 against the respondent number 6, who purportedly was a tenant occupying the property purchased by the respondents 1 to 6 at the auction.
1 to 5.
1 to 5 at the auction. Full stop. The petitioner, therefore, being the person who was being a party to the proceedings resulting in the execution of a sale deed, has no locus standi to challenge the execution of the decree, and therefore the executing court has rightly refused to entertain the application filed by the petitioner under order of 21 Rule 58 of CPC read with section 47. Hence, there is no merit in this writ petition, and there is no merit in these writ petitions, and the same are dismissed. It is, however, open for the petitioner to work out any remedy available to him in the pending suit.
And
In
expedite
accordance with
and can you direct the trial court to expedite the matters.
ಈ 2024ನೇ ಸೂಟ್ ಫೈಲ್ ಮಾಡಿ ಎಕ್ಸ್ಪಿಡೇಟ್ ಅಂತ ಹೇಳಿದ್ರೆ ಹೆಂಗಾಗುತ್ತೆ?
There the pendency are there.
24
There are more pendency in the case.
My lord, the plaint was written.
2024 ಅಲ್ಲಿ ನೀವು ಫೈಲ್ ಮಾಡ್ಬಿಟ್ಟು ಎಕ್ಸ್ಪಿಡೇಟ್ ಅಂದ್ರೆ ಹೆಂಗೆ?
ಅಲ್ಲ, plaint was written.
Redemption of mortgage na amount court fee ಕಟ್ಟಿದ್ವಿ ಅಂತ ಹೇಳಿ that was challenged in the impugned orders in the writ
Anyway.
petitions.
My lord, serial
We
number.
come before this court.
Plaint was,
ಕರೆಕ್ಟ್ ಆಗಿ ಬಂದಿದ್ರಿ ಹೈಕೋರ್ಟ್ಗೆ. WP ನಂಬರ್ ಎಂತದು 6049, that was the correct step that you took, but you abandoned it. 6049 ಏನ್ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ರು ಅದನ್ನ ಪರ್ಸ್ಯೂ ಮಾಡ್ಬೇಕಾಗಿತ್ತು. ದಟ್ ಇಸ್ ಎ ಮಿಸ್ಟೇಕ್ ಯು ಡಿಡ್. ಒಂದ್ಸತಿ ಆಕ್ಷನ್ ಬಿಟ್ಟ ಮೇಲೆ ವಿಡ್ರಾ ಮಾಡಿದ್ಮೇಲೆ ಹೌ ಕೆನ್ ಯು ಗೋ ಅಂಡ್ ಫೈಲ್ ಎ ಸೂಟ್ ಫಾರ್ ರಿಡಂಪ್ಷನ್? Mortgage has already exercised his right. Where is a question of redemption? ಯೋಚನೆ ಮಾಡಿ, ಸುಮ್ಮನೆ ಗಾಳಿ ಗುದ್ದಿ ಮೈ ನೋಸ್ಕೋಬೇಡಿ ಅಷ್ಟೇ.
May I make one request, my lords? Serial number 111, my lords.
Serial number
111. I am for the
not even reach, Mr.
may be kindly adjourned
Adjourn
someday.
ಅಲ್ಲಿ
Serial number 24 ನೋಡಿ interim order extend ಮಾಡಿ. Yes.
My lord, serial number 29.
Serial number?
Lord, serial number 29. Interim
I will not hear you because you can't wait. You don't have patience. When that lady is mentioning, why do you shout? Yes.
ಯಾವಾಗ ಸರ್?
application. Application.
ಸರ್ ಮಧ್ಯಾಹ್ನ ಬೆಂಚ್ ಯಾವ್ದಾದ್ರು ಇದನ್ನ ಇದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ ಸರ್? ಸರ್ ಇದು ಎಲ್ಲೇ ಕೋರ್ಟ್ ಆಫೀಸ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್ ಮಧ್ಯಾಹ್ನ ಬೆಂಚ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಸರ್? ಯಾವ್ದು ಬೆಂಚ್
ಆಗುತ್ತೆ ಸರ್. ಸಿಗ್ನೇಚರ್ ಮಾಡ್ಬೇಕಲ್ಲ ಅಲ್ಲಿ ಅದಕ್ಕೆ ಹೋಗ್ತೀನಿ.
statement wherein the said application came to be dismissed, my lords. Both orders are challenged by the petitioners, my
This is a
lords.
commercial suit.
Please, my lords.
Yes. After how many days did you file the statement?
After 120 days, my lords. My lords, suit was filed on 15/5/2018, my lords. Defendant has appeared on 13/7/2018, my lords. My lords, written statement was taken as nil on 13/2/2019, my lords. My lords, IF for permission to file written statement was dismissed on 13/9/2019, my lords.
Was this a transferred suit or what?
Yes.
Transferred suit. My lords, after the lapse of, my lords, 4 years, they have filed the writ petition, my lords.
Whether case management hearings were done or not?
It wasn't done, my lords.
I have taken opinion that if case management hearings are not done, then an opportunity has to be given. I have taken a view.
Please, my lords.
Yen madudu?
Lords,
For hearing on IM, my lord, I request it may be listed after vacation.
Mr. I am allowing your petition.
lords, kindly see, my lords, initially they had filed application for rejection of plaint, my lords,
Anyway, if it is
which came to be
transferred-
dismissed, my lords, for non-prosecution. Thereafterwards, they have filed application under Order 7, Rule 10 of CPC, my lords, for returning the plaint to be presented before NCLT.
What is the suit for?
Suit for rendition of account, recovery of money, and for compensation, my lords.
Now, if case management hearings are not done,
Please,
I have taken a view that opportunity has to be granted.
please, my lords.
Allow this petition. Is the cost is, how much cost?
Any reasonable cost may be imposed.
Lords, there is a delay of considerable delay of 4 years, my lords. Even
Oh,
commercial
yes,
appeal was also filed, my lords, challenging the order.
When was the suit transferred? What is the
Lords,
date of transfer?
please, my lords. My lords, it was filed before vacation court, my lords, and transferred,
Date of transfer.
my lords, 10/1/2019, my lords.
10/1/2019 is the date of transfer.
Please, my lords.
When did they file the statement?
On 13/9.
On 13/9/2019, my lords.
13/9.
Yes,
Please, my lords. My lords, from vacation court, my lords, the matter was transferred to court hall number, CCH number 39, my lords.
So when was it transferred or returned for representation before the commercial court?
My lord, on 14/12/2018.
Huh?
On 14/12/2018.
14/12.
Yes.
It was called before, my lords, it was called before CCH 39 on 37/2018, my lords.
When was it returned?
My lord, in the.
My lords, 2/7/2018, my lords.
You have given 4 dates.
I'm sorry, my lords. My lords, on 2/7/2018, the matter was transferred to court hall number 39, my lords, CCH 39.
39 is it the commercial court?
It was designated as a commercial court by then, my lords.
2/7/2018.
2/7/2018, my lords.
When was the statement filed?
Statement was filed on, my lords, 13/9/2019, my lords.
Yes, Mr.
My lord, if may, at page number 36, my lord, it is transferred on 14/12/2018. In the order sheet.
Page number 32 may kindly be seen, my lords.
Till then, it was treated as a regular civil suit itself.
My lords, page number 32, my lords, submitted as per orders passed by principal civil judge and sessions judge dated 28/5/2018. Vacation court files are reallocated to regular court CCH 39.
Regular court. It's not a commercial.
I'm asking a
36,
simple question.
Please, ma'am.
Pancham.
Please, ma'am.
When did it go from the civil court to the commercial?
Please.
Simple question, you're taking 10 minutes.
I'm sorry, my lords. I'm sorry, my lords. My lords, 10/1/2019, my lords, from CCH 19, it was transferred to, my lords, CCH 83, my lords.
Where do I get it?
My lords,
This case has been transferred to 83 as per the notification dated so and so. Call on 18/1/2019.
page number 36, my lords.
It is 10/1/2019.
Please, my lords.
As per notification dated 10/1/19.
So
Yes,
the
ma'am.
case is already withdrawn and transferred on 10/1/2019. ನೋಡಿ ಎಷ್ಟು ಡೇಟ್ ಹೋಯ್ತು 1, 2, 3, 4, 5 ಡೇಟ್ ಕೊಟ್ಟಿದೆ. So it is transferred on 10/1/2019. Statement was filed when? 18?
13/9/2019. Lords, the order of the honorable court below at page number 48 may kindly be seen. my lords.
Cost.
Last para.
Cost. How much? 25,000?
Lord.
50,000?
I'll leave to your lordships, my lords.
Petition is allowed. The impugned order passed by the trial court is set aside. The application filed by the defendants to seeking permission to file written statement is allowed, subject to payment of cost of rupees 25,000 payable by the petitioners to the respondents before the trial court on the next date of hearing.
Lord, may I request some reduction in the cost?
No, Mr. I can only enhance. It is made clear that if the cost is not paid and if the written statement is not, statement is already filed.
It's already filed.
Cost is not paid, the trial court shall proceed in accordance with law and dispose of the suit in accordance with law.
Grateful.
Seal number 50, Prasanna Kumar RS.
Petitioners in this.
First respondent.
Application for early hearing.
What is this early hearing?
Not short point, my lord. Whether a screenshot taken by way of a copy can be received in evidence. That is a short question, my lord. The Honorable Trial Court said that such a copy is impermissible in law because it does not satisfy the requirement of Section 63 of the Evidence Act.
Screenshot of what?
Screenshot, my lord, what happened was the it is in fact an election petition, my lord, filed by me, questioning his election in the panchayat election. My lord, ultimately, my lord, the evidence there was complete by both the sides. When the matter was posted for arguments on merits, my lord, this application, 4 applications came to be filed. One is to reopen, recall, permission to file additional documents, and then to they produce the documents. This is my contention was that the from the conduct of the respondent, Lord, it is only a dilatory tactics, only to see that now only 1 year is remained to get that term over. So therefore, it is only a dilatory tactics. And he could have obtained the acknowledgement copy or the certified copy from the Election Commission. And the learned judge said that I will permit you to produce, you go and apply.
Download it, mister. Why don't you download from the Election Commission website?
We have taken screenshot of the acknowledgement, my lords.
What acknowledgement?
My lords, their allegation is that the petitioner herein is having his name in voter list at two places. We have filed application to remove from one place, my lords. And also that's the document we are going to produce, my lords.
Why you don't have physical copy?
No, my lords.
Everything is online.
Yes, my lords.
No, he has not, my lord. Sorry for the interruption. It is only the manually prepared application for deleting his name from the voter list was filed. How can you get an online acknowledgement for that, my lord?
No. See, if the voters, the names are found in 2 places.
Yes.
All that you have to do is send an SMS or an application online to delete from one place.
But that he has not done. Online application was not submitted because that application.
In the application.
That application is before your lordship, not by ink page 141. It is a handwritten application. Immediately after the voters list. Lord.
Where is that application?
Application, my lord, page number 141, annexure H.
Annexure?
H.
Yes.
My lord, may kindly see there, it is a handwritten, my lord.
Sir, this is a downloaded form. This is a downloaded
Form, printed form is a downloaded, my lord.
Can be uploaded this way only. Form tondo, you can upload it this form on the website of the
Lord,
Election Commission.
There is in fact no seal or no signatures.
ನೀವು ಸೀಲು
ಅಲ್ಲಲ್ಲ ಇಲ್ಲಿ ಇದ್ರನ್ನೆಲ್ಲ ಹಾಕಿದ್ದಾರೆ ಅವರು.
ಸರ್ ಆನ್ಲೈನ್ ಗೆ ಸೀಲು ಸಿಗ್ನೇಚರ್ ಬರಲ್ಲ.
ಅಲ್ಲ that time that time, because this application appears as if it is because there are three modes of submission, my lord. One is by way of submitting to the office by hand, registered post and online. There are three methods, my lord. So therefore, Lord, I have got a guidelines, my lord, as to how he has to do it. Thereafter, my lord, after the submission, the election.
Yes, if he has taken a photo of the desktop and if he wants to produce it, how do you say that 65 is not attractive?
No, my lord, if it is a copy from this desktop, my lord, then somebody should, according to the requirement of section 63, it is to be compared and then it is to be submitted.
That's a relevant piece of evidence. Why should it be withheld?
So that's what section 63 of the Evidence Act says.
Oh, he will take a printout from the website. He will produce it with a certificate.
He has not taken the printout, my lord. That is what I am submitting. He has taken a copy on this one and submitted.
Permit him to take a
Let him download and my lord, at least.
Can you download it? Just check it.
4 minutes. Can you have it on Monday, my lord? I'll check it.
I have my own apprehension that whether such an application is submitted. That is the thing.
Let him download it.
Yes, yes.
You can also verify the authenticity
Yes,
of
yes,
the document.
Yes, I can verify it from the Election Commission.
This on Monday.
Great.
Till number 51.
Syed,
Plus I applied for respondent number 3. My lords, I have filed an application for extension of the suit proceedings. My lords, by
24 is filed for extension of time for disposal of OS number
1809 of 2022.
commercial OS number 1809 of 2022. Next para, this court in terms of the order dated
My lords, order dated 14/2/2024.
14/2/2024 had directed the disposal of commercial OS 1809.
My lords, in another writ petition, my lords. The writ petition is different.
Which is that writ petition?
Please, my lords, annexure A, my lords, 16342 of 2023. Writ petition 16342.
Where do I get it? This court in WP number so and so directed the disposal of OS, commercial OS 1809 of 2022. Full stop. What is this petition about?
Your lordship, I am for the petitioner. Your lord. This petition was filed for withdrawal of the amount deposited with the different number 3 before the commercial court. Your lordship. 1/3 rent has to be deposit ಮಾಡಿದ್ದಾರೆ. Then withdraw EWP active.
This petition is disposed of or pending?
Pending, my lords. This writ petition is pending.
Then why do you seek for a direction for disposal of?
My lords, in an earlier writ petition, there was a direction to the trial court to dispose of the suit before 20 December 2024. There are few applications that are pending, my lords, which may require some consideration and time. And therefore, it may not conclude before December 20.
Why are you filing this application, this writ petition, mister?
My lords,
You should have filed an application, that writ petition.
my lords, the underlying suit is the same, my lords.
Doesn't matter. This court has not granted any order in this writ petition.
Not,
In
my
some
lords.
other writ petition, some direction is issued. And
My
you
lords, the
want that
under,
direction to be extended in this writ petition.
my lords, the underlying suit is one and the
Very
same.
incongruent.
My lords,
Yes. Purple, learn, IA 1/24 is filed for extension of time to dispose commercial OS number so and so. It is stated that this court in WP number
16342 of 23 minutes.
had directed the disposal of commercial OS number so and so within so and so time. Full stop. The petition, the respondent number 3, instead of filing the application, that petition has filed the application, this petition, which is not maintainable. Hence, IA 1/24 is rejected. Liberty is reserved to the petitioner to file an appropriate application in WP number so and so.
My lord, the roster judge is, my lords, in another, the roster judge is not in Bangalore, my lords. That is the reason.
VC. Yes, next.
Number 52, Syed Kamruddin.
Syed Kamruddin.
But I filed the application for early.
What is this IA 1/24?
For early hearing, my lord.
Who has filed this?
I have filed it.
What is the petition about?
My lord, I am the judgment debtor, my lord. Order of arrest is issued against me in the execution proceedings. my
You
lord.
are the judgment debtor.
Yes, my lord.
Ah.
I'm judgment number, certain number 2, my lord. I challenged it in 4 grounds, my lord. The grounds I've taken, my lord, the application that they have filed.
Please use the mic.
My lord, the application, my lord, that is filed before the court is for removing obstruction for attachment of movables. On the said application, my lord, an order of arrest is passed. One, my lord, that ground that no prayer is sought. These said two grounds, my lord, 2 other grounds is, my lord, before an order of arrest is issued, the court, there is a mandatory requirement for an inquiry under order 21.
Recovery of money.
Please, my lord, recovery of money. The inquiry ought to have been conducted, my lord, at least to satisfy whether the petitioner, that is the judgment debtor, has means and deliberately and willfully did not satisfy the decretal amount. No such, my lord, and even averment is made, nor an inquiry is conducted, my lord. Straight away an order of arrest comes to be passed. My lord, I've also filed, my lord, in proceedings, insolvency proceedings before the same court. Now, I'm saying, my lord, that I have no means. They are at liberty, my lord, to proceed against me, attach my properties, even warrant of arrest, my lord. Let them satisfy that I have the means and I'm deliberately not making the payment. That is all my submission, my lord. So a mandatory inquiry is contemplated, my lord, under order 21 rule 40.
What about the house where you are residing?
My lord, I'm no longer residing. It was a tenanted premises, my lord. I've been evicted for non-payment of rents, even from that premises.
No, my lord. So the thing is, the amount, my lord, which was due is in excess of 2 crores, my lord, from 2011 suit. Now, what has happened, my lord, is he was awaiting the summons, my lord, for 2022 petition. Finally, my lord, because his address, he kept changing his address, my lord, he was not able to execute the warrant. Now, my lord, the address warrant was issued initially, my lord, if your lordship kindly sees page 17 of the writ petition. I had filed an application under order 21 rule 37, my lord, seeking issue the arrest warrant.
Yes.
Page 17, my lord. The order sheet of the trial court is there.
Page 7.
17, my lord. The left side, my lord, on order dated 29/22. That is the order that my learned friend is challenging, my lord. Now, my lord, thereafter, my lord, it was pointed out to the learned magistrate, learned trial judge that there's under order 21 rule 37, there's a requirement of issuing an arrest notice prior to issuance of the arrest warrant, my lord. So the arrest notice came to be issued, my lord, subsequently on.
So what is the status of your insolvency proceedings?
My lord, it is pending before the same court, my lord. All the respondents are served, but one respondent who I've deleted now, my lord, from the insolvency proceedings, my lord. And now maybe they filed objections and they have in fact filed an application for rejection of my insolvency proceedings on the ground that I should have filed it before the DRTA. But it may not be so, my lord. I filed my objection stating that the petition is maintainable before the district court, city civil court, Bangalore, my lord.
No, my lord.
Insolvency proceedings are pending.
No, my lord, he has just filed that, my lord. He's not prosecuting that. For the last two years, the notice is at the notice stage, my lord. So he cannot take any, there's no order passed there for any stay, my lord. Notwithstanding that, my money is held up, my lord, from 2009 proceedings, which was sued in 2011, was decreed in 2022, my lord.
Jolly Joyce Varghese and Avittal.
Lord, I have got those judgments, my lord. In fact, our Honorable High Court, my lord.
Judgment, Jolly Joyce Varghese.
Yes, my lord.
1984, isn't it?
Yes, my lord.
No, if an inquiry has to be conducted, my lord, it may be sent back on inquiry, my lord. Let there be a time-bound inquiry, my lord, and thereafter an order may be passed, my lord. I'll concede to that effect, my lord.
Right. Which is the order which is challenged?
He's challenged the order.
My lord, I filed a review petition also, my lord, against the said order
So I have challenged the
Which is the
original order.
original order? Where is the original?
2022, my lord. It is at page
Page 17, my lord.
17.
17.
Please, my lord.
17, my lord, 17.
Thereafter, my lord, arrest notice was issued, my lord, on 22/12/23, my lord, page 22.
Judgment letters 1 and 2 in EP number 2522/2022 on the file of the 74th Additional City Civil and Sessions Judge, Mayal, Bangalore. I have filed this petition challenging an order dated 20th of September 2022. Issuing an arrest warrant against the JDR number 1, JDR number 2. Full stop. Next para. The respondents filed OS number 26757/2011 and 26758/2011 against the petitioners for recovery. The said suits were decreed and a sum of rupees 70,70,188 was ordered to be paid. Full stop. The respondent number 1 filed EP number 2522/2022. Full stop. The petitioners entered appearance in the execution petition on 27/7/2022. Full stop. And a warrant for attachment of movables of the JDR of the petitioners was issued on 1/9/2022. Full stop. The respondent number 1, unable to execute the warrant, then filed an application under Order 21 Rule 37 of CPC as 21 Rule 37 of CPC. He was already arrested earlier.
That is a
But
check bounce
in a
case, my lord. He was
separate
serving a
proceedings,
sentence of
yes.
conviction, my lord.
Well, they say you were imprisoned from 9/2/23 to 9/8.
Yes, my lord.
8/11/23.
That was
the
in a
check bounce?
138 proceeding.
On separate proceeding, not in this proceedings.
Order 21 Rule 37 to arrest the petitioners. Full stop. In the meanwhile, the petitioner was arrested and put in prison in view of an order of conviction in a proceeding under Section 138 of the Negotiable Instruments Act. Full stop. After his release, he approached. After his release, he filed 2 applications, one under Section 5 of the Limitation Act and another under Section 114, read with order 47 Rule 1 of CPC to review the order dated 23/2/2024.
Lord, I'm sorry, order dated 29/2022, my lord. It's a
Should
mistake.
be
29/2022, order of
29/2022. Full stop. The said applications were rejected.
Rejected.
Were rejected by the executing court. The petitioner contends that he had initiated insolvency proceedings in IC number 25002/2023, which was pending consideration. Full stop. Later, the executing court, in terms of the order dated 7/8/2024, rejected the applications filed by the petitioners and proceeded to pass the impugned order, issuing an arrest warrant against the petitioners. So being agreed by the same, sorry, rejected by rejected the application filed by the petitioners. Full stop. The petitioners are therefore before this court challenging the order dated 20th of September 2022 passed on the application filed by the respondent number 1 under order 21 rule 37 of CPC. Next paragraph. The learned counsel for the petitioner contends that the executing court ought to have conducted an inquiry to ascertain whether the petitioners had no means to pay the decretal amount before issuing an order of arrest. Full stop. He contends that the impugned order does not show whether any such inquiry was conducted, and therefore the impugned order is liable to be set at naught. Full stop. Besides this, he contends that insolvency proceedings are underway, and therefore, the executing court ought to have awaited the outcome of the proceedings in insolvency case number so and so. Next, the learned counsel for the respondent number 1 on the other hand contends that the petitioners are due
In excess
more
of
than
rupees
rupees
2 crores.
and the petitioners have been avoiding the process of the court by shifting their residence
Please.
from time to time. Full stop. He also contends that the respondent number 1 is trying to avoid the execution of the decree, though he possesses substantial assets and is able to pay the decretal amount.
Also, there is no stay in the insolvency
So
process.
he also contends that there is no stay against the execution of the judgment and decree passed in OS number so and so, so and so. So next paragraph. Order 21 rule 37 of CPC, mandates
Issuance of arrest notice.
mandates issuing a notice calling upon the judgmentar to show cause why he should not be committed to civil prison. Therefore, it was incumbent upon the executing court
May make one submission. No, the notice was issued, my lord. After the notice was issued, when he appears, an inquiry is to be convened. So the notice was issued. His grievance is that no inquiry was convened. Notice was issued on 2/12/2013, man. 2/23.
So the executing court in the present case had issued a
Notice on 2/12/23, arrest notice, man.
2/12/2023.
Subsequent to which he appeared. Then inquiry was convened and
Inquiry was not conducted.
please, my lord. In terms of
Determine whether the petitioner had means to pay the decretal amount. Full stop. The apex court in the case of Jolly Joyce Varghese versus Union Bank of India, Bank of Baroda, Bank of Cochin, while considering proceedings, while considering the manner of proceedings to be held under order 21 rule 37, held as follows. Para 13. Therefore, the executing court. Therefore, the impugned order passed by the executing court deserves to be set aside on this short ground alone. Consequently, this writ petition is allowed in part, and the impugned order passed by the trial court is set aside, executing court is set aside, and the case is remitted back to the executing court, which shall conduct an inquiry to determine whether the petitioner has means to pay the decretal amount or not, and then to proceed in accordance with law.
My only request is a time-bound inquiry, my lord.
Executing court shall comply with the above within a period of 6 months from the date of receipt of a copy of this order.
Please, oblige.
Number 53, Kritika Rama.
My lord, I appear for the petition. It may kindly be passed over, my lord.
No.
My lord, we engage senior counsel, Mr. K. N. Panindra, who's on his legs in Court Hall 1.
Madam,
A short pass over, my lord.
today is Friday. It's already 3 o'clock. The matter is, the list is still not exhausted. Passover means you want an adjournment.
Oh, my lord, I'm seeking for a short pass over.
Yes, you can go on.
Please, minutes. Lords, the plaintiff's claim is at page number 33, my lords, in the writ petition.
Page number
33. That is the prayer sought for.
33.
Yes.
Yavadu petition number?
Writ petition number 26432 of 24.
Page number 33 ಬೇರೆ ಏನೋ ಇದೆಯಲ್ಲ ಇದು?
ಹೌದಾ, ಅವ್ರು ನನಗೆ ಕೊಟ್ಟಿರೋದ್ರಲ್ಲ 33 ಅಂತಾನೆ ಇದೆ.
33.
Plaint copy, plaint the prayer portion.
Prayer portion.
Yes.
Yes.
Decree for a specific performance of the settlement agreement dated 28/10/2020. Pass a judgment of specific performance of the escrow agreement dated 16/2/22, directing the defendants to withdraw the CC number so on. So this is the only relief sought for. Sum and substance is only prayer B, that there are some criminal proceedings which is required to be withdrawn by us and which has not been withdrawn. That's all their grievance.
Some judgment and decree for specific performance of the settlement agreement dates also directing the defendants
To withdraw the CC number so on. So prayer B no adane.
Yes.
Lords, in this, they seek for an order of injunction, which your lords will find at page number 299. 291, I presume they are not pressing because that's not the order which is sought for. Page 299. That we should not create any third-party rights. Lords, now in the entire contents of the plaint, it is not stated as to how it is related. The withdrawal of the criminal cases, how it is related. Lords, transaction takes place like this. The petitioner was the developer. We had entrusted the joint development to him. We are the owners. He stopped the project in between. He had already taken a lot of money from the buyers. Then it was in the cold storage for almost 4 to 5 years. Nothing happened. All his projects for that matter. Then there was a settlement which we entered into by saying that we are going to give him 14 crore rupees. Whatever agreements he has executed and entered into, the money being kept by him, those agreements will be entrusted to us. We will complete the project and execute sale deeds in favor of the persons in whose favor he had already committed to sell the apartments. And there is a...
You had agreed to pay him 14 crores.
Yes, that is paid. 20 crores totally. That entire amount is paid. 20 crores is already paid. He has stated, my lords, fortunately for us, he has admitted.
It's towards the investment made.
Yes, that is towards, my lords, that's towards the handshake is what I can say. Because there was more liability than what he had actually spent. He had already raised more money than what was actually invested there. So we had to get a quietus, my lords, to exit from this because it was stuck and hanging for almost like 4 years, where nothing had happened. After that, this settlement agreement came into existence. Settlement agreement, it's clearly spelled out that what all interest he had created as on the date of settlement, those interest is given to us, which is reflected in a schedule. So far as the commercial is concerned, there is a very specific mention that he has not created any encumbrance or any third-party rights over this property. If your lords were to take my statement of objections, my lords, page 116 is the settlement agreement.
One
28/10/2020 settlement agreement. Lords, at page 119. Lords, clause J. Petitioner NEL declares that it has so far, out of the sale of the apartments allotted to its share, received certain amounts from the allottees in the project and the balance receivables from the allottees towards the balance consideration of the project is 15 crores 9 lakhs so on. So further represents that it has not encumbered any portion of the commercial building to any third party. This subject matter for us to withhold those criminal proceedings is only this. NEL further represents that it has not created any charge on any portion of the project in any manner whatsoever. Statement certifying the balance receivables as on the date and the certificate is appended to this agreement as Annexure B. That's whatever agreements which you had entered into with reference to any portion of the project is referred to, Milords, in this annexure at page number 138, Annexure B.
So these are the agreements.
These are the agreements. Now, till here, there is no difficulty. But what he does, the missive start says, Milords, I'll just take one more clause, Milords, because he is seeking for specific performance. Lords, may kindly take page 131 for a minute, Milords. 131. Clause 17. The suit itself could not have been filed by them. Any dispute under or in relation to this agreement shall initially be resolved by mutual discussions, deliberations. On failure of such amicable discussions, dispute shall be submitted to the arbitration by sole arbitrator, so on and so forth. They could not have filed a suit at all. There is a clause for arbitration. Notes, and then there is also an indemnity clause, Milords, which I will not trouble your lordships. Page 156 is the cancellation of joint development agreement.
Yes.
Lord, the joint development agreement under which they were claiming is cancelled. The reason is he would not have any subsisting interest after the cancellation of the joint development agreement. He's taken his entire money. Lord, this was put into an escrow saying that only after pay that 50 lakh rupees, which was the balance amount, this has to be registered, is registered. They have admitted this in the objections in their affidavit. Lords, now the page number 200, your lordships may kindly take. Lords, this is where this person creates a mischief. Lease deed on 1/6/2017. Date is 1/6/2017. Let's kindly have it turn over to the next page. This is presented for registration on 3/8/2018. After 1 year, 2 months.
Yes.
Let's Ramanath Shetty, represented by authorized signatory so-and-so lessor number 1. There he signed, Milords, as a power of attorney holder. He doesn't reflect himself as a power of attorney holder there. Then Nitesh Estates so-and-so. Then he has signed for both. In the bottom, your lordships will find 2 signatures represented by GPA holder so-and-so. Notice he executes in favor of Orange Storage Private Limited. Now your lordships may kindly turn to page number 291 for a minute, Milords. What is this Orange Storage? It's 200 and I'm sorry, 285 Milords. I'm sorry. 285. I'm sorry, Milords. This is shareholding. 99% to Nitesh Shetty, 10% to Ganapati Joshi. Petitioners shareholding, Milords, they have themselves produced at page number 46 of their writ petition.
Come again, petitioners?
Petitioners Satchmo ಅಂತ ಏನಿದೆ ಈಗ ನಿತೇಶ್ ಎಸ್ಟೇಟ್ಸ್ ಇತ್ತಲ್ಲ, that name is changed as Satchmo. ಅವ್ರದ್ದು ಶೇರ್ ಹೋಲ್ಡಿಂಗ್ ನ ಪೇಜ್ 46 ನಲ್ಲಿ ಅವರೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
46 of the petition?
Yes, along with the petition.
Hmm.
95% is Nitesh Shetty, 5% is his mother. He wanted to claim through another entity, having taken everything, having said.
Satchmo Holdings is the new entity.
Lords, it is renamed, Milords, that NEL, it is their contention that they have renamed it as Satchmo. NEL has become Satchmo. Now, ಇವರು ಎಡಗೈ ಬಲಗೈ ವ್ಯವಹಾರ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟು ಈ ಕಮರ್ಷಿಯಲ್ ಪ್ರಾಪರ್ಟಿನಲ್ಲಿ ನಮ್ಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಇದೆ ಅಂತ ಹಾಕ್ತಾರೆ. ಇಷ್ಟಕ್ಕೆ ನಿಂತಿದ್ರೆ ಪರವಾಗಿರ್ಲಿಲ್ಲ.
What was the settlement?
No, settlement is, kindly have a look at the settlement at page 116. They are exited from the project.
116.
Yes, page 116.
Here.
Let's add page 120. The terms and conditions is provided for, my lords. ಅಲ್ಲಿ clause 5 settlement.
Yes.
ಅದರಲ್ಲಿ clause 4. The first party landowners and the association hereby agree to take over the project on as is various condition, complete the project as may be deemed fit by them in accordance with the building bylaws and in compliance with the RERA. Next 5, settlement amount of rupees 4 crores. The settlement amount shall be paid by the third party developer in the following manner explained herein. That is 125 to be paid by the landowner, 1 crore rupees is paid by NEL with the original documents, and balance 175 should be paid like this. That is also execution of the definitive agreements and documents and cancellation of the JDA and GPA by the parties not later than 20 days from the date of RERA approval. First party landowners and association affirms to complete the balance construction of the project in the following manner we have undertaken. Then obligations of developer NEL on RERA approval, clause 10. The developer third party hereby undertakes to ensure and facilitate the withdrawal and closure of the following cases below pending against the landowners, complete all the compliances of the act and the post registration, file application for extension of registration of the project, simultaneously file an application before the RERA seeking approval of transfer of Nitesh Caesar's Palace Phase 2 to the landowners and association under section 15 by paying necessary fees. Upon extension of the registration, complete the compliances under the act, including the quarterly updates of the quarter with which the project transferred. Then furnish within 15 days the date of this relevant assessment orders, returns, VAT, certificates from the chartered accountant certifying all statutory dues in respect of the project is paid. Furnish within 15 days the date of this agreement, list with all details of allotment, so and so. Then furnish within 15 days the date of this agreement, statement of account certifying by the chartered accountant with respect to advance maintenance charges collected by the allottees in the project. And then furnish within 15 days from this date is agreement, the statement of account showing the total corpus fund collected by the allottees. Deliver upon execution of the agreement, the landowners, all title deeds, records handed over to the JDA, so and so, so and so. Then after that, obligations of the landowners is there. In that clause 10.3, there is a requirement that we are required to withdraw certain cases. Milords, the settlement is very simple, milords, that I'll take over the project. Whatever cases are there will have to be closed. And whatever money he wants to get, he will get that money. That money is paid, there is no dispute, because the Escrow agreement itself said last tranche payable was about 50 lakh rupees. Once that 50 lakhs is paid, they had executed a special power of attorney in favor of the Escrow. Escrow will register the cancellation of the joint development agreement and the GPA, which has already taken place. Now, only situation is regarding the withdrawal of these two criminal cases. Now, so far as withdrawal of these two criminal cases is concerned, what is it got to do with the alienation of the property? Because that is the interim order which they are seeking at the hands of this honorable court in this writ petition. This is the only question, milords. Now I have demonstrated, milords, that they executed this agreement in the month of in June 2018 to June 2017, present it for registration. It's an antedated document. Then they don't stop it at that. In that, there is no arbitration clause.
The date of the settlement?
Milords, the date of settlement is 28/10/2020.
28/10/2020.
Lords, this settlement deed, your lords may consider it in the teeth of the revocation of the GPA, which was effected by a paper publication at page 105. Now GPA revoke madbitvi. Lords, this revocation was done on 20th March 2018. So 20th March 2018 ನಾವು ರಿವೋಕ್ ಮಾಡಿದ ಮೇಲೆ ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಅವರು ಆಗಸ್ಟ್ 2018 ಅಲ್ಲಿ ನಾವು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿದೀವಿ ಅಂತ ರಿಜಿಸ್ಟ್ರೇಷನ್ ತಗೊಂಡೋಗಿ ಕೊಟ್ಟಿರೋದು. ದೆನ್ ಹಿ ಡಸಂಟ್ ಸ್ಟಾಪ್ ದೇರ್. ಆ ಲೀಸ್ ಡೀಡ್ ಒಂದು ಮಾಡ್ತಾರೆ. ಲೀಸ್ ಡೀಡ್ ಮಾಡಿ ಸುಮ್ಮನೆ ಬಿಡೋದಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಏನ್ ಮಾಡ್ತಾರೆ? ಕೈಂಡ್ಲಿ ಹ್ಯಾವ್ ಲುಕ್ ಅಟ್ ದ ನೆಕ್ಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್. 16/6/2020 ದೇ ಪ್ರಿಪೇರ್ ಒನ್ ಮೋರ್ ಡಾಕ್ಯುಮೆಂಟ್ ಕಾಲ್ಡ್ ಆಸ್ ಸಪ್ಲಿಮೆಂಟರಿ ಲೀಸ್ ಡೀಡ್. Notarized copy.
Where do I get that?
Lords, that your lords will find at page number 226. ಇದರಲ್ಲಿ ಸೇಮ್ ಇದರಲ್ಲೂ ಅವರೇ ಸೈನ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ 16th June 2020 ಸೈನ್ ಮಾಡಿಕೊಂಡು ಇದರಲ್ಲಿ ದ ಲೀಸ್ ಪೀರಿಯಡ್ ಇಟ್ ವಿಲ್ ಕಮೆನ್ಸ್ ಫ್ರಮ್ ಎ ಪರ್ಟಿಕ್ಯುಲರ್ ಡೇಟ್ ಅಂತ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಮಾಡ್ಕೊಂಡ್ರು. ಅದಕ್ಕೊಂದು ಫಿಟ್ ಔಟ್ ಪೀರಿಯಡ್ ಅಂತ ಹಾಕೊಂಡ್ರು. ಇದಾದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಅಡೆಂಡಮ್ ಅಂತ ಇನ್ನೊಂದು ಮಾಡ್ಕೋತಾರೆ 27/8/2020 ಇವೆಲ್ಲ ಆಂಟಿಡೇಟೆಡ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ಈ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಬರೋದೇ ಈ ಸೆಟಲ್ಮೆಂಟ್ ಡೀಡ್ ಆದ್ಮೇಲೆ. ಆಂಟಿಡೇಟೆಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ಇದ್ರೊಳಗೆ ಏನ್ ಬರೀತಾರೆ, ಆರೆಂಜ್ ಇದು ಬಹಳ Ramanath Shetty 28/7/2020 page 231 Ramanath Shetty NEL Holdings and Orange Self Storage represented by Ganapati Mala Joshi. A 1% shareholding ಅವ್ರದ್ದು. ನೆಕ್ಸ್ಟ್ ಇದರೊಳಗೆ ಪೇಜ್ 233 ಆರ್ಬಿಟ್ರೇಷನ್ ಕ್ಲಾಸ್ ಕ್ರಿಯೇಟ್ ಮಾಡ್ತಾರೆ. ಮಾಡ್ಬಿಟ್ಟು ಇದೆಲ್ಲ ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿ ನಾವು 50 ಲಕ್ಷ ಕೊಟ್ಟು 50 ಲಕ್ಷ ಆದ್ಮೇಲೆ JDA GPA ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಗಿ ನಾವು ಪ್ರಾಜೆಕ್ಟ್ ಟೇಕ್ ಓವರ್ ಮಾಡಿ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತಿದ್ದಂಗೆ this Nitesh goes and files a case in the name of Orange Properties, arbitration proceedings, and wants to take over this commercial portion of the property. This is where he starts the dispute. We have never entered into any dispute. So he starts the dispute. Then even now I said, if this is what you are doing left hand, right hand, please take back that mischief which you are doing in respect of this. Don't do any arm twisting tactics. I am not willing to hold on to any of these bad experiences which I have had with this developer. We already had enough bad experiences. I don't want to have any more. You withdraw those cases, I'll withdraw those criminal complaints. That's essentially what we have told them. But what they want to do is, they want to now arm twist me into some other form of settlement, which I cannot express. What is the manner in which they are arm twisting us?
What is this petition all about? Why is the petition filed?
Lords, this writ petition is filed against the non-granting of an ex parte order.
Yeah, what was the suit filed then?
Suit is for specific performance to enforce that agreement, only to withdraw the criminal complaints. Lords, that's the reason why I said, Lords, neither in the agreement nor in general law they can trace any rights. ಒಂದೇ ಇನ್ನೊಂದು ಅಷ್ಟಕ್ಕೆ ನಿಲ್ಸಲ್ಲ ಅವ್ರು. ಇನ್ನೊಂದು ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ, ಅಗ್ರಿಮೆಂಟ್ ಟು ಸೆಲ್ ಪೇಜ್ 241 ಈ ಕಮರ್ಷಿಯಲ್ ಸ್ಪೇಸ್ ನ ಅಗ್ರಿಮೆಂಟ್ ಟು ಸೆಲ್ ಮಾಡಿದೀನಿ ಅಂತ. ದಟ್ಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ಪೇಜ್ 241.
Here's the order passed by the trial court refusing ex parte order.
Lords, that your lords will find at page 22.
Yes.
ಅವರು ಇದನ್ನ ಹಾಕಿದ್ದಾರೆ, ಆರ್ಡರ್ ಶೀಟ್ ಹಾಕಿಲ್ಲ ಅಂತ ಕಾಣುತ್ತೆ ಅವರು.
ಅಲ್ಲ ಏನು IAL ಇದೆ?
ವೆಬ್ಸೈಟ್ ಇಂದ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ತೆಗೆದು ಹಾಕಿದ್ದಾರೆ. ಆರ್ಡರ್ ಶೀಟ್ ಹಾಕಿಲ್ವಾ? ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ.
Where is the copy of the IA? Page number?
Page number 295 at 294.
294.
Lords, 294 is the first IA. I'm sorry, my lords. 299. 299.
ಏನಂತ ಕೇಳಿದ್ದಾರೆ?
I should not create any third party rights interests in respect of this project. ಈಗ ನಾನು ಯಾರ್ಯಾರಿಗೆ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಸೇಲ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಅವ್ರು ಯಾರ್ಯಾರು ಅಗ್ರಿಮೆಂಟ್ ಆ ಬಿ ಶೆಡ್ಯೂಲ್ ಹಾಕಿದ್ದಾರೆ ಅವ್ರದೇ ಉಳ್ಕೊಂಡಿರೋದು.
Yes, Mr. Panindra.
Lords, we have filed one memo, if your lordship sees, I'll. Memo, my lords.
ಯಾವುದು?
ನಾವು ಒಂದು ಮೆಮೊ ಹಾಕಿದೀವಿ last time. The same issue is in mediation and we are fighting here. If parties do not incline to settle the matter in mediation. ಇದು ಯಾವುದು ಡೇಟು? No, not this. Order sheet.
This is the
My lords,
9th of December.
9th December, sorry, 9th December. Lords, in that, please come to that order sheet in the criminal matter, my lords, which is challenged in a writ. In that, please come to page. Lords, one nimsha. I want that order which here. My lords, running page 4, other last serial number 13 order, 17/8/2013, it had come up before lordships. The same matter which your lordships were hearing, then my lords, sorry, page 5. 4/8/23 ಅಂತ order ಇದೆ.
Yes.
All these issues were raised there about Orange Towers, commercial thing. All this was considered. Now, my lords, that if your lordship now come to 24/10/2024, page 2. Both it's the same parties. I can understand if somebody else, it's the same dispute, same parties are referred to mediation.
Yes, please.
And the mediation, now, my lords, this mediation was ordered on 24/10/2020.
What was this writ petition about?
My lords, that criminal case, under the memorandum, my lords, they had filed a criminal case against us. So we had challenged that. In part of the memorandum of settlement, they had agreed to, my lords, withdraw or assist us in getting the criminal case quashed. Your lordship may kindly come to the affidavit, my lords, which is enclosed.
No, now they're willing to quash the criminal, close the criminal case, provided you hand over that commercial space.
That is a separate dispute. That's what we want to say. They are now 1 minute. I did not interfere with them. That is a separate dispute which they now bring about. The entire settlement, my lord, settlement and the escrow agreement was in respect of residential apartment. Now, my lords, they have also received money under the lease deed.
Yes.
They have received the money. Even if that is so, my lord, the parties can now resolve. Why are we fighting here? If the mediation is going on, now I give up all my rights. My lords, if that was the issue, I gave up all my rights.
Yes.
When the criminal case and the arbitration process.
Settlement agreement also did relate to the commercial space.
Lords, I read it, they did very specifically, Lords. Kindly have a look at it.
Yeah,
I read that I read that portion.
but
Page
if your
number
lordship just
119.
let me-
Page 119, my lords.
Page 119.
Yes. Clause J.
What is he showing now? Which one?
In the statement of objections, my lords.
Yes.
NEL declares that it has so far, out of the sale of the apartments allotted to its share, received certain amounts from the allottees in the project, and balance receivables from the allottees towards the balance consideration in the project are 15 crores so and so. NEL further represents that it has not encumbered any portion of the commercial building to any third party. NEL further represents it has not created any charge on any portion of the project in any manner whatsoever. The statement certifying the balance receivables as on the date is appended as agreement annexure B. Annexure B, whatever is produced, my lords, it doesn't contain anything pertaining to this commercial. And they have made a very specific statement so far as commercial is concerned, they have not created any encumbrance. Lords, it's a fact they had not created.
Yes, Mr.
No, my lords, please see the mediation also is going on. That's what I want to impress, my lords. If mediation is going on, it's the same issue.
Yeah, but anyway, if they want to convey the residential flats.
My lords,
how does it come in the?
I'll tell your lordships. I had a JDA where I had a right. The RERA approval was taken by me. Agreements were entered into by me. Now, my lords, there were disputes, several disputes between us. They had filed cases, I had filed cases. Ultimately, my lords, under the memorandum of agreement, we said, let's close all these things. I go to RERA and one of the clauses was, because RERA had given approval to me, I had to get an approval to in their name.
Yes.
I got that. I withdraw all my cases. I withdraw every other case. They keep quiet. Now, my lords, under the escrow also, the escrow, we had executed all documents. The escrow agent was in hold of it. The only authority to him was, after all this criminal case, everything is withdrawn. That can be, he can present it for registration and that can be done. Now, even before the criminal case is withdrawn, lords, he goes and gets it registered and they get the right. I have given up all my rights today. And my lords, if they are going to sell and I am in a fix, because my lord, now to.
You got your money.
My lords,
you got back your money.
My lords, I have also got back, it was only 5 crores which they paid. They also got back what I had constructed. I had also, my lords, it's not that, my lords, it's like this.
So whatever, see, as per the agreement.
As per the agreement,
whether it was commensurate with whatever money that you spent, we do not know.
That's, my lords, parties with open eyes entered into that agreement.
There is some settlement, you got your money.
Lords, your lordships are only pointing out money I got. They got the constructed area.
It is right. It could be some premium attached to that. On the whatever money that you spend, you got something more or maybe less. We do not know.
We do not know. Lords, both of us with open eyes, we went.
Yes.
Now, my lords, he had to withdraw the criminal case or assist me. Now, please see the affidavit which they had also executed at page 237 in my writ.
237.
200 and, my lords, in my writ petition, my lords. In the writ petition, running page 237.
Yes.
237 only. no?
Madam, you should wait for your turn. He's arguing the matter. Wait for your turn.
My lords, please see, in terms of that memorandum, they executed
This is some affidavit.
affidavit in that writ petition, which is now referred to, my lords, the mediation. Please see para 1, my lords. We are the respondents, your lordship should get.
Just a moment.
And
Let her know.
lords, in that they record about the settlement. Then, my lords, at para 4, para 3, they say that. Then please come to para 5 and 7.
Yes, please read.
Lords, para 5, we hereby submit. That's at page 238. We hereby submit that as per the memorandum of settlement and other related documents and understanding between the parties are required to comply the following 3 conditions. On receipt of demand draft of rupees 50 lakhs from landowners in favor of NEL Holdings South Limited. On withdrawal of a memo in respect of case number 351 of 2017 filed by Vishwanath Shankar and 237 and others against NEL before NCDRC. And on filing of necessary affidavits, applications for withdrawal of CC number 5840 of 2018 registered with Talgatpura Police Station in WP number 2272-2275 of 2018 pending before the High Court of Karnataka.
Yes.
We submit that the petitioners have already filed memo and affidavit before the Honorable High Court to bring the LRs of late Ramanath Shetty, Mr. Abhay Raj Shetty, Mr. Miss, it should be Mrs. or Bharti Shetty, Jyoti Shetty and Sanjay Shetty on record. Hence, we LRs and the landowners are swearing. We submit that we had agreed to extend and cooperate to quash the said complaint FIR charge sheet in WP number so and so court. And further, we shall not contest the above complaint CC number so and so as to enable the petitioner to have the benefit of the judgment of acquittal in the said WP.
Yes.
We submit that this affidavit may be treated as an unconditional consent to quash the complaint initiated against the petitioners in CC number 5840 of 2018, which is pending before the High Court. Now, this is what was to be done by them also. Now, it is recorded along with the thing. They don't do that. That is when, my lords, this honorable court, in that particular writ petition, referred both of us to the mediation center. Now, in the mediation, if parties are before a mediator,
That is right, but how can you
prevent, my lords,
no, how can you lease out this commercial space?
my lords, please come to my rejoinder.
Number one, anyway, as I have understood, there was a settlement.
Yes.
At the time of settlement, you had not leased it out to anybody.
No, I think, my lords,
It's not leased
sub-
it out.
my lords, it
The
is,
documents show that it was registered only in the month of August 2018. So it was not leased out. You made a statement that it is not leased out to anybody, no encumbrance. It could not have been leased out after the settlement.
no, my lords, if your lordship kindly come to my rejoinder, I've just narrated, and it's a separate entity. I am not that entity.
It's all right.
My lords, I am now, my lords, if your lordship sees the petitioner is a listed company, it is not the same entity. In my rejoinder, I've just mentioned the pleadings which were there in that writ petition.
So both the companies are held by you.
But registered later. My lords, if your lordship kindly see the lease deed is dated of 2017.
Registered on 18.
Lords, yes, in my rejoinder, my lords, I have produced the extract of the pleadings made by Orange, my lords, in the arbitration application, if your lordship gets that, my lords.
Exhibit R32. R32.
My lords, rejoinder. Rejoinder document in Akilla.
ಅಲ್ಲ, ಇದಾಕಿ CMP ಹಾಕಿದ್ದಾರೆ 41.
ಅದಲ್ಲ ಆರೆಂಜ್ ಇದ್ರಲ್ಲಿ
CMP ನಾ?
CM ಕಮರ್ಷಿಯಲ್ ಆರ್ಬಿಟ್ರೇಷನ್ A ಅಂತ ನಾವು ರೆಫರ್ ಮಾಡಿದೀವಿ ನಮ್ದ್ರಲ್ಲಿ ರಿಜಾಯಿಂಡ್ರಲ್ಲಿ ವಿ ಹ್ಯಾವ್ ಜಸ್ಟ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟೆಡ್ ದ ಪ್ಲೀಡಿಂಗ್. ಅವರು ಹಾಕಿದ್ದಾರೆ ಅನ್ಸುತ್ತೆ.
Yes, yes. Yes, please.
ಅದರಲ್ಲಿ clause D, my lords, it is page. There's no page number, ma. And to third page, my lords, clause D, if your lordship kindly come, my lords.
Yes.
ಅದರಲ್ಲಿ clause 7 ಅಂತ extract ಮಾಡಿದ್ದಾರೆ. In which, my lords, demand draft also is given towards the lease to Ramnath Shetty. He has received 10 lakhs. It's not as if he was not aware of it. So even he was aware that it had been done. I'm only saying, my lords, if the parties are at settlement and if he has received and today to say he is not aware of it.
Where is the order sheet of the trial court?
Lords,
Refusing
that's
it.
what they have produced it.
My lords, it's only notice was issued.
They should have produced the entire order sheet. They have not produced it. At least we should have produced it.
We do not know whether reasons were mentioned in the order or not.
Illa. My lords, my instructions are there were no reasons, only a notice was issued.
Now, where is the order sheet?
Lords, the point boils down to this, my lords. Now all these submissions are made. Where is that right? Because what they are preventing me is
Not
Let me
going to that,
conclude.
whether the court has
Lords,
applied its mind or not. If the court has applied its mind, why should we break our heads here?
idea copy. And the mediation now is fixed on 7th and both the parties are appearing. I do not know, my lord, my learned friend keeps saying, no, no, no. If,
Then you work out your remedy in the civil court. See, the court has applied its mind before.
my lords,
refusing to
issuing
grant-
summons, that is, lords, I am only saying now, if both the parties, if your lordship sees,
Look at this. You have produced a whole bunch of documents before the trial court. Trial court has gone through that. There's some settlement, there's so many contradictions, there's so many proceedings. Court said, let notice go. How can you
my lords, I am
challenge
only
that?
saying this.
You
since-
work out your remedy before the trial court.
Now, my lords, I am only saying this. If this court has already sent both, it's the same parties, same issue is now under mediation. And if the other side says participating in the mediation, I'm producing records
You
to
can say
show.
the same thing before the trial court now. Same thing you can mention
My
before.
lords, they are going to alienate. Now, after I having given up all my rights, my lords, and the escrow agent presenting it without even the criminal case being closed.
Mr. Senior Counsel, this writ petition is under 227.
Absolutely, I'm.
Only thing that I have to see is whether there is application of
Lords,
mind.
that does not even show application of mind. It only says issue suit summons.
Doesn't mean to say that the court has to extract the entire document and say, this is the reason why I am refusing. That is expecting too much
Lords,
from the trial.
Issue suit summons andre or apply mind andre.
Summons alla, the court says.
First,
on
issue
page-
suit summons and emergent notice on IA1
the
and 2 to
court
the
says-
dependents.
Court says on perusal of the plaintiffs and documents, the plaintiff has furnished copy of the memorandum of articles of the plaintiff, copy of the JDA, copy of GPA, copy of the certificate of incorporation, photographs and other documents. Plaintiff has not made out a prima facie case. Thus, before passing any order, it is just and proper to hear, so and so. So therefore, let the court decide now. Now that they've entered appearance, let the court decide.
Well, my lords, I'll leave it at that.
Barkul.
Then, my lords, your lordship may fix a date on which it will be heard, at least the IA will be heard.
When is the matter listed before the court? When is the next date?
Because again, it will go on. Now there they will come and say mediation ನಡೀತಿದೆ ಅಂತ. ಇಲ್ಲಿ mediation ನಡೀತಾ ಇದೆ. Both the parties are in mediation.
Then Kandita na
He'll tell that they can't take shelter under the mediation.
Yes.
The case be decided.
Courts may even observe
The
that.
application be decided on merits.
Very well.
Whatever. Barkul.
That's that time frame at least to decide our IA. Otherwise, my lords, it will go on for years together now.
The plaintiff in OS number so and so.
Posted on 13-1, my lords.
Has filed this
Please,
petition. Challenging an order dated so and so by which the trial court refused to grant an ex parte order of injunction to restrain the defendant
My lord,
slash
may I just
respondent
leave, my lords.
from alienating, encumbering or transferring the flats constructed. Stop. Next para. The suit in OS number 1642 of 2024 was filed for the following reliefs. Page 33. The writ petition. Next part. An application was filed for interim injunction. An application was filed for interim injunction to restrain the defendants from creating, from alienating, creating third-party interest or otherwise disposing of the scheduled property in whole or in part. Full stop. Next para. The sum and substance of the arguments of the plaint was that the plaintiff was a developer who had undertaken to develop the property bearing survey number 17/2 and 17/3 of Raghuvanahalli, Chittralli Hobli, Bengaluru South Taluk. Full stop. The plaintiff appears to have developed the property partially and fell in litigation with the owners, which resulted in a settlement on 28/10/2020. Correct, huh?
Please.
28/10/2020. Full stop. In terms of the settlement, comma, the plaintiff had agreed to walk out of the project against receipt of certain money and also money, and the developers, sorry, and the owners were required to withdraw certain cases filed against him, against the petitioner. Full stop. It is a case of the petitioner that despite the petitioner complying with the terms of the cancellation, the owners had not withdrawn certain criminal cases, but in the meanwhile were attempting to dispose of the flats that were constructed on the property in question. Therefore, the petitioner sought for the reliefs mentioned above. He also sought for an injunction as stated above. Full stop. The trial court, after perusing the material on record, felt that the plaintiff had not made out, that the petitioner had not made out a prima facie case for grant of injunction. The grant of ex parte injunction to restrain the defendants from alienating, encumbering or transferring the portions of the property constructed on the land bearing number so and so. Being agreed with the said order, the petitioner is before this court. Next para. This court, in terms of the order dated so and so, order dated 27/9/2024, had directed the defendants in the suit not to alienate or create or any third party interest in respect of the suit shall property till the next date of hearing. The said order is extended from time to time. Next para. The respondents have entered appearance and have filed a detailed statement of objections contending inter-alia that the petitioner, after having entered into a settlement, has brought about certain unconscionable agreements resulting in further litigation. Full stop. It is also contended that the petitioner has, it is also contended that certain other litigations have ensued between the petitioner and another entity to which the petitioner had leased out a portion of the commercial space constructed on the aforesaid property, which has resulted in a deadlock. Full stop. Next para. After perusing the impugned order passed by the trial court, comma, full stop, next para. The learned senior counsel representing the petitioner contended that the trial court has absolutely not applied its mind before holding that the petitioner has not made out a prima facie case for grant of ex parte order of injunction. The learned senior counsel took the court through the impugned order and submitted that the court has referred to the documents produced along with the plaint and has blindly held that the petitioner has not made out a prima facie case. Thus, he contends that the court did not apply its mind before refusing to grant an ex parte order. He contends that the respondents are now attempting to encumber and transfer the the flats constructed over the property, and this would affect the interests of the petitioner seriously. He therefore contends that without disturbing the order passed by this court on so and so, the trial court be directed to consider the application on merits. So, per contra, the learned senior counsel representing the respondents contended that the trial court was cognizant of the fact that the disputes between the petitioner and the respondents arose out of a joint development agreement, which was later settled between the parties, and that certain issues were outstanding. Therefore, he contends that the trial court had visualized the situation and had held that there was no prima facie case for grant of ex parte order of injunction. He submitted that the trial court did not conduct a roving inquiry to find out whether the plaintiff petitioner had made out a prima facie case for grant of ex parte injunction. Stop. Therefore, he submits that the impugned order passed by the trial court is just and proper in the facts and circumstances of this case, and the order passed by this court dated so and so deserves to be modified, and the petitioner is liable to be relegated back to the trial court. Full stop. Next, I consider submissions of the learned counsel so and so. Next part. As stated above, the dispute between the petitioner and the respondents did arise out of certain agreements relating to joint development of a property. Full stop. The dispute seems to have been settled between the parties, as a result of which, the petitioner was entitled to certain benefits, while the owners of the property were all entitled to corresponding benefits. Full stop. The dispute now appears to be regarding the refusal on the part of the respondents to withdraw certain criminal case filed against the petitioner. Full stop. The relief sought for in the suit also indicates the same. Therefore, the trial court was not expected to scour the entire record to find out whether there was a prima facie case for grant of injunction. If the court was of the opinion that the material placed before it made it doubtful whether the plaintiff was entitled to an order of injunction, the court was justified in issuing emergent notice to the defendants and in not granting an ex parte order of injunction. Full stop. Having regard to the complexity of the issues between the petitioner and the respondent, This court is of the opinion that the trial court was justified in not granting an ex parte order of injunction. Full stop. Therefore, this writ petition deserves to be disposed of on the following terms. Number one, the impugned order, the order of injunction granted by this court on so and so is recalled. Number two, the trial court shall consider the application of the petitioner on merits and in accordance with law within a period of 2 months
Very well.
from the date of receipt of a copy of the order. What about alienation? Until disposal of the IA, don't alienate.
ಅವ್ರು ಯಾರ್ಯಾರಿಗೆ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಅವ್ರಿಗೆ ನಾವು ಕೊಡ್ತಾ ಇರೋದು. ಅವ್ರಿಗೆ ಏನು ರೈಟ್ಸೇ ಇಲ್ಲ, ಅವ್ರಿಗೆ ಸುಮ್ನೆ ಅವ್ರು ತರಲೆ ಮಾಡ್ಬೇಕು ಅಂತ
ಬಟ್ ಏನ್ 2 ತಿಂಗಳು ಮಾಡ್ಬೇಡಿ.
ಸಬ್ಜೆಕ್ಟ್ ಟು ಔಟ್ಕಮ್ ಆಫ್ ದ ಸೂಟ್ ಅಂತ ತಾವು.
2 ತಿಂಗಳ ತನಕ ಮಾಡ್ಬೇಡಿ.
ಇಲ್ಲ, ಈಗ ಏನಾಗಿದೆ, ಪ್ರಾಜೆಕ್ಟ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ, ಎಲ್ಲರೂ ಪೂರ್ತಿ ದುಡ್ಡು ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಅವ್ರಿಗೆಲ್ಲ ಬರ್ಕೊಡ್ಲ ಅಂತ ತುಂಬಾ ತೊಂದರೆ ಆಗುತ್ತೆ.
2 months ತನಕ ಏನ್ ಮಾಡ್ಬೇಡಿ.
ಬೇಡ ಅಂತ ಅದಕ್ಕೋಸ್ಕರನೇ ಅರ್ಜೆನ್ಸಿ ಇದ್ದಿತ್ತು. ಇಲ್ಲ ಈಗ ನಾ ಹೇಳ್ತಾನೆ, ಅವ್ರು ಬರೀ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ವಿತ್ಡ್ರಾಲ್ ಅಷ್ಟೇ ಅವ್ರು.
Any alienation made shall be subject to the outcome of the suit before the civil court.
Please.
Or any other proceedings pending before any other court.
Yes. Grateful.
Number 54, Anirudh.
Idont ಮಾಡಿ. Mr. Ravi Shankar, the respondents shall not take shelter of any proceedings before the mediation center post the grant of interim injunction by the trial court. Mediation is on the
My lords, it's listed on the 7th. I have record of the proceedings.
Don't take shelter of the mediation.
Mediation center fail ಆಯ್ತು and it.
Don't take shelter under the mediation. Yes.
Grateful.
54, Anirudh.
That's the petitioner.
Anirudh. Yes.
My lord, in this case, my lord, a suit is filed in February 2023. And my lord, they received the summons on 27th February 2023. For more than 1 year, they don't file the written statement. I amend, this is a trademark infringement suit. So what happens during the pendency of the suit, I get my trademark registration. So after I get the trademark registered, because earlier it was unregistered trademark, I only applied for registration. But afterwards I get the registration, so I seek leave of the court to amend my claim. And I amend the claim only 4 paragraphs, where I say earlier I say it was pending registration, now I say I've got the registration. That is the only amendment. I just make amendment has to add and just written the application number that it is registered. These are the only amendments. Now, my lord, after this, the trial court passes an order asking him to file an additional WS, my lord. I can show the order at page 81 onwards, my lord. The page 81.
Suppose if he doesn't want to, when you file the suit, maybe he did not want to file the written statement. But when you amended the plaint, maybe he wanted to file the written statement. Does he get it right?
When he's filing the, after amend the plaint, his additional WS should be sticking to the only of the paragraphs of which are amended, my lord, to which I have judgments, my lord. So this order also from 81, my lord, from the order sheet, lordship has the 81, the entire order sheet I have placed. The top portion of the order, it says to furnish the amended plaint because the IA was allowed. Below that, my lordship say advocate for plaintiff is present and furnished amended plaint in suit sets along with documents. Now, my lord, the order is for cost and await additional written statement to the amended plaint. This I agree, my lord, they can find an additional written statement to the amended plaint. So everywhere there on, my lord, next 2-3 orders, it says amended plaint for, additional WS for the amended plaint.
How can you file a
My lords,
exhaustive written statement?
please. In response to suit summons, my lords, I made an appearance on 27/2/2023.
27?
27/2/2023.
When were
I
you
was
served?
supposed to file the written statement on or before 26/6/2023. That is 120 days from the date of suit of summons.
So when were you served with the summons?
My lords, service of summons was done in the month of February, my lords. The date was fixed on 27th of February
When were
2023.
you served with summons?
My lords, 27/2/2023.
That is the day when you entered appearance.
Please.
When were you served with the summons?
My lords,
Another interesting point to just add.
My lords, 23rd of February, my lords. 27/2, I made an appearance in response to suit summons. I was supposed to file the written statement on 26/6/2023. My lords, in meantime, on 6/6/2023, the plaintiff makes an amendment application.
Object, my lord, amendment to
Sir, one
December.
nimsha, sir.
False
The order
December.
sheet would,
Wait,
Yes.
every lawyer has to be told, is it?
Oblige, my lord. False.
my lords, page number 77 be looked into, my lords. 6/6/2023 at the bottom, my lords. The plaintiff counsel file IA number 8 under order 6 rule 17 with documents copy furnished into the court. Let's for the objections, if any, it was adjourned. My lord, said application came to be allowed on 13/12/2023.
Yes.
My lords, if my lords could take in this aspect, my lords, from the date of allow of the amendment application, the written statement could be filed. That is, on 10/4/2024 was the last date to file the written statement.
Yes.
My lords, thereafter, I made an application for recalling the order and permission to seek produce the written statement on record. Said application came to be allowed on 1/8/2024. My lords, the learned trial court had imposed certain cost on me, had also paid, and the counsel for the plaintiff has also received it. My lords, thereby he has agreed with the order.
Doesn't make,
My lords,
can't hold it against him, mister.
my lords, in case of
Just
Arvind
because
Patil,
cost is received.
my lords,
it doesn't-
para
you
number
can't
7,
hold
my
it
lords. Sir,
You can't hold it against him just because he receives the cost.
please, my lords, the order which is impugned is on 1/8/2023.
Yes.
The current petition is filed in the month of October 2021. Sorry, 21st of October 2024. My lords, there is a lapse of 2 months in preferring the writ petition. My lords, I agree there is certain lapse on my part that I couldn't file on time. My lords, if at all I was supposed to file the written statement, my lords, it should be filed on 10/4/2024. My lords, due to the ensuing vacations, we could not file, and there was a death in my family. I had narrated in the application which has been filed before the trial court. My lords, after hearing the parties, my lords, the learned trial court had ordered to take the written statement on record.
Lord, this case of continuation of delay is not on the original written statement. We had to file a written statement as for the plaint which was filed in February, which was served on him on February 2023. But he has filed the IA. I'll just show the IA, my lord.
So when did you file the application for amendment?
My application for amendment, my lord, was filed in December 2023, my lord, which was allowed in 16th December
You
2023.
did not file any application seeking for extension of time.
No, my lords.
Then-
My lords, 39 rule 1 and 2 came to be dismissed.
39, 1 and 2, mister, after,
My lords,
after exhaustion of 30 days, did you file any application for
my
extension?
lords,
of
there was a
time?
death in my family. I couldn't go
Sir,
contact
that-
the
you should
counsel on
have
record
quoted
to.
that- You should have quoted that and sought for extension of time. Did you seek?
No, my lords.
Then
My lords, there was my lords had held in one
the
matter.
silent bystander, mister, when in a
My lords,
litigation.
one matter, my lord has held that from the date of amendment, the service of summons required to be hold.
What is the suit for?
My
The
lords,
suit is for trademark
Trade-
infringement.
Yes, how much cost will you pay?
my lords, I already paid 10,000 before the trial court. my
1,000,
lords.
it's a commercial court.
My lord, it's a
My lords,
question of law involved,
another
my lord.
10,000 or 5,000 could be imposed, my lords.
Question of law involved, my lord, not with respect to the cost, my lord. I have filed the Supreme Court judgment on page 146, which I will relate before the trial.
What is the
court.
question of law?
The question of law is, when I'm amending the plaint, the other party who's filing an additional WS, he should stick to only the amendments made by the opposite party. He can't just file an additional WS.
I
to
would
the entire
accept
plaint.
it, I would accept it if you had filed the application beyond 120 days. You did not file the application for amendment after the trial court took his written statement as not filed.
Sir, I
When
have-
did the trial court take the written statement as not filed?
My lord, the trial court has already not taken it. It is not filed, but however.
therefore-
amendment application 8 months. It is
So
filed
the-
8 months after the plaint, my lord.
So therefore, since you filed the application for amendment of the plaint before 120th day, he had reason to believe,
Yes.
that if the application for amendment is allowed, he has to file an exhaustive written statement.
Yes, my lord. My lord, but again, one correction is that when summons was served in February, but my amendment application was filed in December, my lord. It is, there is a gap of 11 months.
It was filed on
December is
June, my lords.
June 6th.
No, my lord, that is a wrong submission. That's why I interrupted.
The order
back then,
should
my lord.
speak, my lords. Why would I
amendment application is there in record,
misguide
my
or
lord.
something, my lords?
My lordship has the order.
They have only produced the document, my lords, page number 77. It says on 6th of June 2023, they have made an application for amendment.
IA number 8 is filed on 6/6, mister.
My lord,
IA number 8 is filed
Page
on
number
6/6.
77.
yes, my lord, but however, the same was allowed
So
only. in
yes,
December.
my lord ಅಂತ ಹೇಳ್ಬೇಕು.
It was allowed in December. I'm just saying that my
You
amendment.
said you filed it in December. Don't mislead the court, mister. You said you filed it in December, not allowed in December.
So I'll withdraw that submission, my lord, but however, my lord.
Then you lose the cost also.
Carried out only on 16 December, my lord, because the amendment was allowed on 13 December.
Barcode. Now you lose the cost also.
But 13 December I had, the amendment was allowed.
Cool.
So his right to file additional WS will happen only after I've amended my plaint, my lord, not.
If
just
in
because I filed
commercial
an
OS
amendment
one
application.
84 of 2023 on the file of so and so is before this court challenging the correctness of an order dated so and so by which the court granted permission to the defendant to file an additional written statement. Next para. The suit in OS number so and so was filed for so and so. A relief copy of it. The summons in the suit was served on the defendant on 23/2/2023.
My lord, one submission if I may. One
And he
if I may.
entered appearance on 27/2/2023.
Submission if I may. My lord, the IA which they have filed seeking for continuing the delay and to get the written statement on record, they are only seeking for continuation of delay from the time I have filed my amended plaint. They are not seeking continuation of delay from the date I have filed the plaint, my lord.
Yes, purple. Yeah, to 27/2/2023. Full stop. The trial court (27/2/2023) alva?
Please.
On the said day, the plaintiff filed an application and filed a bunch of applications, including an application under Order 39 Rule 2A to direct the police inspector of Kodigelli Police to shut down the business operations of the defendant. Full stop. The trial court did not fix any date for the defendant to file the written statement. On the contrary, it heard the applications filed by the plaintiffs and posted the case for orders on the applications by 15th of March 2023. The case was then again posted on 20th of April 2023, on which day it rejected the application filed by the plaintiff, bracket IA number 2. Then too, the trial court did not fix the date for the defendant to file the written statement. Full stop. The case was thereafter listed on 6/6/2023, on which day an application was filed by the plaintiff to amend the plaint. And the case was adjourned for objections to that application. Even on that day too, the trial court did not consider the written statement of the defendant as not filed. Stop. From then on, the suit was taken up for consideration of the applications filed by the plaintiffs until the application for amendment of the plaint was allowed on 13/12/2023. Full stop. For the first time, the trial court permitted the defendant to file an additional written statement to the amended plaint, oblivious of the fact that the defendant had not filed his written statement in the first instance. Full stop. This went on till 9th of February 2024. Sorry, 23rd of February 2024, on which day the defendant filed an application permission to file the written statement. Full stop. The trial court, in terms of the impugned order, allowed the application and held that the suit was amended on 16/12/2023 and that the written statement was filed well within 60 days. Full stop. Being agreed with the said order, the plaintiff is before this court. Next, for the learned counsel for the plaintiff contends that the defendant was under an obligation to file the written statement within 30 days from the date of service of notice. And it was for him to file appropriate application seeking extension of time as provided under Order 8 Rule 1. He contends that the defendant, having not filed the written statement, would not have filed an extensive written statement after the suit was amended. Not only to the plaint that was originally filed, but also to the plaint that was amended. Therefore, he contends that the trial court committed an error in permitting the defendant to file a belated written statement. In support of his contention, he relied upon the judgment of the apex court in the case of
page number 146, my lord. Case of Gurudal Singh and others, also Rajkumar and others. Page number 146, my lord.
In the case of Gurudal Singh, you have got all old cases, Mr.
No, this has been further substantiated by few high court
So
judges.
the Commercial Courts Act, where is the judgment?
Yes, ma'am. So based on CPC only, they were saying when the plaint is amended.
Under the Commercial Courts Act, the Supreme Court has said that Order 8 Rule 1 is mandatory.
Yes.
Timeline has to be followed. Where is the judgment?
So to that, they gave a exception.
Where is
recently,
the
my lord.
judgment, Mister?
That judgment is not placed on record, my lord.
Ah.
However, they gave an exception to that saying in
So
exceptional
you
circumstances-
come here to argue a point of law, you don't get the proper judgments. You said you have some point of law.
Law. They-
In the case of so and so, and contends that the timeline fixed under Order 8 Rule 1 is mandatory and there is no escape, particularly when the matter is filed, when the suit is filed before the commercial court. Full stop. Per contra, the learned counsel for the defendant contends that the trial court did not hold what is the act put? Act put.
Answer.
The trial court did not PPC. The trial court did not hold case management hearings after the suit was filed. And therefore, the defendant was not put on notice as to when the written statement had to be filed. He submits that throughout the proceedings, the trial court did not did not consider the written statement of the defendant as not filed. On the contrary, he contends that the defendant was entitled to file the written statement within 120 days from the date of service of summons. However, the plaintiff amended the plaint. However, the plaintiff filed an application to amend the plaint on 6/6/2023, and therefore the defendant was under the bona fide impression that he could file an written statement after the plaint was amended. He contends that the written statement was filed within 60 days from the date of the amendment of the suit. At any rate, he contends that allowing the defendant to file a belated written statement did not prejudice the plaintiff in any manner. Full stop. Next para. I have considered submissions of the learned counsel for the petitioner and the learned counsel for the respondent. Next para. The defendant was under an obligation, under a duty to file the written statement within 90 days, within 30 days after service of summons. Full stop. It was incumbent upon him to file a necessary application seeking extension of time to file a written statement. Full stop. However, the entire order sheet does not disclose that the defendant had taken any steps in that regard. The trial court too lost track of the suit in not putting on notice the defendant that he should file the written statement within time. It also did not pass any orders holding that the written statement is not filed even after 90 days from the date of service of notice on the petitioner, on the defendant. Full stop. Therefore, full stop. The plaintiff in the meanwhile had filed the application to amend the plaint on 6/6/2023. Therefore, it is quite possible that the defendant felt that it is appropriate to file a written statement after the plaint was amended. Full stop. No doubt, there is no doubt, once the proceeding is initiated before the commercial court, there is no escape from the fact that the defendant has to file the written statement within the time prescribed. But since the plaintiff had amended the plaint and the defendant had filed the written statement within 60 days from the date of filing the amended plaint, the mistake on the part of the defendant could be pardoned by placing, could be glossed over by placing the defendant on terms so as to ensure that the defendant does not further procrastinate the matter or delay the suit in any manner whatsoever. In that way of the matter, comma, this petition, in that view of the matter, no interference is warranted with the impugned order. Consequently, the petition is dismissed. However, having regard to the conduct of the defendant in sitting over the fence, comma, this court considers it appropriate to enhance the cost from rupees. How much was imposed? 10,000?
10,000 was imposed.
From rupees 10,000 to
5,000.
25,000.
Well, that would be.
Oh, Mr. Commercial court, which is payable by the defendant before the trial court on the next date of hearing. It is made clear.
Maybe a bit reduced, my lords.
I can only enhance it, not increase it. It is made clear that if the cost is not paid on
Inclusive of the
next date
cost
hearing,
paid with the trial court.
including, obviously, it is not paid on the next date of hearing, comma, the trial court shall purge the written statement already filed and proceed in accordance with law.
Here, my lords, earlier it was recorded, they filed the written statement within 60 days. It was filed on 14 June. Filed the written statement also 1 year after I filed my amended.
1 year.
It is after 1 year.
It is not that, my lords.
14 June is when the file is, my lord. The date only can be recorded, my lord.
A wrong submission.
When was the application allowed? December 2023.
16th of December
They
2020.
filed their IA to recall along with the written statement on 14 June.
When was the, when,
13 was filed on 14 June 2024, my lord. 1 year after I filed my amended claim.
is that a fact?
Yes, no, IA 13, I show the IA 13 is on record, my lord.
Yavat file ಮಾಡಿದ application. Then the cost will also go up.
It's a wrong submission, probably. my lords.
The court says within 60 days he has filed. That is also wrong, is it?
Let me just come.
That is also wrong.
Let's have page 94, my lord, the order sheet, which says counsel for defendant files IA number 13, which is the impugned order before lordships, page 94. Files IA number 13 under section 151 of CPC with written statement in 2 sets. That is in 14/6/24, my lord. This is what I'm trying to say, my lord.
When did you file the amended plaint, mister? When did you file the amended plaint?
Lord, as the lordship rightly pointed out, June 23, my lord. June 23, my lord, just there in page 77 as they pointed out. It is filed in 6th June 23, my lord. Page 77.
To furnish amended plaint by 16/12 antide. When did you file the amended plaint? In
Lord,
2
amended
sets,
plaint
16/12.
was- The application for amendment was filed on 6th June, my lord. It was allowed on 13 June, 13 December, my lord.
You know, you please come to page 83.
Yes, my lord.
He has filed IA number 12 and order so and so, no, this is not so and so, in my view, it is not necessary considered that even if it is defendant filed, it was not without having filed it. Amended plaint was not till date, you are additional date is not filed, no. For the petitioner, objections. Yes, mister, when did you file the?
Lord, just 2 pages. One is page 77, if my lordships may have, which they rightly pointed out.
My lords, on 14/6/2024, the application was filed, my lords.
That is
My
after
lords,
120 days again.
please, on 13/12/2023, the order was passed. Within 120 days from the date of order, they have to supposed to be filed. That is on 10/4/2023. We had an ensuing vacation on the month, in the month of May 2024. On 14/6, I've made an application, my lords.
Yes.
Even then it goes beyond 120 days.
Exactly, my lord.
My lords, what I would say, my lords, is
You will also increase the cost then. It will go.
after lapse of 2 months, he has preferred the writ petition.
How much cost? ಇದು statement ತೆಗೆದಾಕ್ಬೇಕಂಗಿದ್ರೆ.
Lords, the cost has already been paid.
50,000, no? I'll recall the order.
It could be enhanced to another 5,000, my lords, I would
50,000.
pay. My lords,
50,000.
it would be
yes.
exorbitant, my lords.
No. Then I'll recall this order.
Please, inclusive of the amount which has been paid before the
50,000,
trial
yes.
court.
Next. Rakesh Kini. Oh, mister, don't plead ಮಾಡಬೇಡಿ. You got an order of injunction, please argue the matter. No, I'll dismiss it right away.
Serial number 55, I'm appearing.
Yes. Yes, sir. Yes,
Serial
Mr.
number 55. I am appearing, my lord. My lord, I have filed a rejoinder that may kindly be accepted, my lord. And in that rejoinder,
Yes, Cody.
kindly see, my lord, what happened to the facts of the case is that, my lord, the election officer has declared unopposed, my lord, for 2 candidates. That was
No, but please tell us who has filed this suit.
my lord, the unsuccessful candidate and also successful candidate both have filed the suits.
Yaro.
And the civil court has granted ex parte injunction, interim mandamus, without hearing the defendants, my lord. Now the question is only in respect of third respondent who has sought for
Please tell
vacating
us.
stay. My
The writ
vacating
petition
stay
filed, this writ petition is filed by whom?
by the district committee, my lord. District committee.
Then an election officer antide.
And also election officer. My lord, the facts you lost me kindly. I will brief it, my lord, for 2 minutes. My lord, the ex parte, the unopposed candidates, 2 candidates have been declared as elected. Declared as elected, my lord. Now the third respondent. Third respondent has been disqualified as per Annexure D. May kindly be seen, my lord. Annexure D.
ನೀವು ಒಂದ್ ಕಡೆ ಕೂತ್ಕೊಳ್ಳಿ ಶ್ರೀಧರ್ ಅವರೇ.
My lord.
ಒಂದ್ ಕಡೆ ಕೂತ್ಕೊಳ್ಳಿ ಹಿಂದೆ.
Annexure D. 1 minute, you lost me kindly see Annexure D.
ಅಲ್ಲ, you are running around. Please sit in one place ಅಂತ ಕೇಳ್ತಿದ್ದೀನಿ.
My lord, I am on a journey. I have come on it, my lord. My lord. Sorry, my lord. Annexure D, page number 48, you lost me kindly see, my lord. 48. Third respondent in respect of. This is the order passed by the state election, the state association. He has been suspended on 12/5/24, the third respondent. Therefore, he was not eligible to be nominated or contested for election. This order is even now in force. Therefore, remaining 2 candidates have been declared as unopposed.
No, please wait.
Then, my lord, they went to civil court to obtain an interim mandamus.
Please wait, Mr. Sridhar. Please wait.
My lord.
Please wait. This suit is filed for what?
Suit is filed for challenging the interim mandamus issued by the civil court, directing the considering the case of the third respondent and also
Suit is filed for declaration that the remark endorsement that is preventing the plaintiff from voting and contesting the election made in the voters list pertaining to judicial department employees prepared for election.
Constituency number 47.
Null and void.
My lord, the first respondent and the third respondent, among them, my lord, the first respondent has declared unopposed. I do not know why she has gone to court. And so far as third respondent is concerned, his nomination was not accepted because of Annexure D.
See, the suit is filed by somebody
Then
called
he went to
Prakash
the
Naik.
then he went to the civil court
May I submit,
by
my lord?
suppressing.
Two suits are there.
suppressing
May I
Annexure
submit, my lord, for a moment?
2 suits are filed.
Suits are there, my lord. May I submit for a moment, my lord, on facts? My lord,
Yeah, one nimsha tali Sridhar, please wait.
my lord,
Perhaps you don't have the file with you.
my lord, Annexure F, calendar of events was published, my lord.
Annexure
F, my lord, page 51. There, my lord, for election of the, my lord, executive members of the district, my lord, state government employees association was scheduled on 7/11/24. Then, my lord, election, my lord, to be concluded on 16/11/24. My lord, in the meantime, my lord, the nomination, my lord, last date was 11/11/24, my lord. Then, my lord, the 5 persons have filed nominations, my lord, for this post. My lord, one among them was the third respondent herein, my lord. Initially, my lord, that is where, my lord, lordships get the one suit, where, my lord, in the voter list,
it was noted that, my lord, this Prakash Nayak was not entitled to vote. Then he files Annexure B suit, my lord, 1229 of 24. There, my lord, seeking for a declaration that, my lord, he is entitled to vote and contest. In that suit, my lord, an application for a mandatory injunction permitting him to contest and vote was filed. That was considered by the trial court, and permission was granted for him to, my lord, contest and vote. Annexure C, my lord, page 28 is the order. May I take, my lord, into operative portions, my lord? By a speaking order, after hearing all the parties to the suit, my lord, this order has been passed, my lord. My lord, pursuant to this Annexure C order, my lord, Prakash Nayak, who is the respondent number 3 herein, files nominations, and, my lord, he also contests for the post, and he seeks for, my lord, casting his vote. My lord, the election officer, my lord, surprisingly, after contesting the order in the OS number 1229 of 24, does not challenge this order, but again, my lord, he rejects the nomination filed by the Prakash Nayak and declares that, my lord, out of 5 persons, 1 person's nomination is rejected, 2 persons have withdrawn their nominations, and 2 persons were declared as elected is the order passed by the returning officer, my lord. My lord, ignoring this order of the trial court, my lord, in giving mandatory injunction. Then, my lord, Prakash Nayak, third respondent herein, files a miscellaneous case before the court, my lord, along with my application for vacating stay Annexure R2 I have produced, my lord.
Yes.
My lord, the executing court, my lord, holds that, my lord, its orders are violated. In spite of their being, my lord, to accept the nomination and, my lord, to permitting the Prakash Nayak to contest the election, returning officers, my lord, rejects his nominations. And therefore, my lord, the executing court passes an order, my lord, directing the returning officer to, my lord, permitting him to contest and vote, my lord. Then, my lord, the returning officer, as per Annexure R1, my lord, may I take, my lord. This is where, my lord, entire issue revolves, my lord. Annexure R1.
Statement.
Vacating stay application jyote ide sir. Annexure R1 ನಲ್ಲಿ page 6 ಅಲ್ಲಿ sir ಆದೇಶ, my lord gets it, my lord. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿದಂತೆ ದಕ್ಷಿಣ JMFC ಮಂಗಳೂರು ಇವರ ಆದೇಶದಂತೆ ಮತ ಸಂಖ್ಯೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ನ್ಯಾಯಾಂಗ ಇಲಾಖೆ ಈಗಾಗಲೇ ಪ್ರಕಟಿಸಿರುವ ಅವಿರೋಧವಾಗಿ ಆಯ್ಕೆಯಾಗಿರುವ ಅಭ್ಯರ್ಥಿಗಳ ಪಟ್ಟಿಯನ್ನು ರದ್ದುಪಡಿಸಿ ಈ ಮತಕ್ಷೇತ್ರ ಸಂಖ್ಯೆ 40 ನ್ಯಾಯಾಂಗ ಇಲಾಖೆಗೆ ದಿನಾಂಕ 16/11/24 ಚುನಾವಣೆ ನಡೆಸಲು ನಿರ್ದೇಶಿಸಲಾಗಿದೆ. My lord, returning officer, my lord, withdraws the order of, my lord, passing order, unanimous election was withdrawn. Then he says, my lord, elections will be conducted on 16/11/2024. My lord, on that day, my lord, elections were not conducted. Then, my lord, present suit was filed by one of the candidate, that is respondent number 1 here in, my lord, seeking a direction, my lord, to conduct the elections, my lord, immediately. For the reason that, my lord, out of these, my lord, elected members, on 27/11, my lord, the president and treasurer has to be elected, my lord. Therefore, my lord, considering that urgency, suit was filed and mandatory injunction was prayed, my lord. On that application, impugned order Annexure A came to be passed. My lord, may I take, my lord, Annexure A?
Yes.
There, my lord, relevant portion directly page, internal page 3 of the order, my lord, may I take, my lord?
Yes.
Para 2 ಅಲ್ಲಿ ಒಂದು ಪ್ಯಾರಾ ಓದ್ಲಾ ಸರ್? ಪ್ಯಾರಾ 2 ಪೇಜ್ 2 ಅಲ್ಲಿ ಸರ್, ಬಾಟಮ್ ಇಂದ. ಅದರಂತೆ ದಿನಾಂಕ 13/11/24 ನ್ಯಾಯಾಂಗ ಇಲಾಖೆಯ ಮತಕ್ಷೇತ್ರ ಸಂಖ್ಯೆ 47ರಲ್ಲಿ ಸ್ಪರ್ಧಿಸಲು ಅರ್ಹ ಅಭ್ಯರ್ಥಿ ಪಟ್ಟಿಯನ್ನು 2ನೇ ಪ್ರತಿವಾದಿ ಸ್ವೀಕರಿಸಿರುತ್ತಾರೆ. ಆದರೆ ದಿನಾಂಕ 16/11/24 ನ್ಯಾಯಾಂಗ ಇಲಾಖೆಯ ಮತಕ್ಷೇತ್ರ ಸಂಖ್ಯೆ 47ಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಚುನಾವಣಾ ಪ್ರಕ್ರಿಯೆ ನಡೆಸಲು ಸ್ಪಷ್ಟೀಕರಣ ಕೋರಿ ರಾಜ್ಯ ಚುನಾವಣಾಧಿಕಾರಿಗಳಿಗೆ ಪತ್ರ ವ್ಯವಹರಿಸಲಾಗಿದೆ ಎನ್ನುವ ಪತ್ರಿಕಾ ಪ್ರಕಟಣೆಯನ್ನು ಹೊರಡಿಸಿ ನ್ಯಾಯಾಂಗ ಇಲಾಖೆಯ ನೌಕರರನ್ನು ಹೊರತುಪಡಿಸಿ ಉಳಿದ 11 ಇಲಾಖೆಯ 14 ಸ್ಥಾನಗಳಿಗೆ ಚುನಾವಣೆಯನ್ನು ನಡೆಸಿರುವುದು ಲಭ್ಯವಿರುವ ದಾಖಲೆಗಳಿಂದ ಕಂಡುಬರುತ್ತದೆ. ಅಲ್ಲದೆ 24-29ನೇ ಸಾಲಿನ ಅವಧಿಯ ಜಿಲ್ಲಾ ಶಾಖೆಯ ಜಿಲ್ಲಾಧ್ಯಕ್ಷರು, ಜಿಲ್ಲಾ ಖಜಾಂಚಿ ಮತ್ತು ರಾಜ್ಯ ಪರಿಷತ್ನ ಸದಸ್ಯರನ್ನು ಚುನಾವಣೆಗೆ ವೇಳಾಪಟ್ಟಿಯನ್ನು ಕೂಡ ಹೊಸದಾಗಿ ನೇಮಕಗೊಂಡಿರುವ 2ನೇ ಪ್ರತಿವಾದಿಯವರು ಪ್ರಕಟಿಸಿರುತ್ತಾರೆ. ಅಲ್ಲದೆ ದಿನಾಂಕ 27/11/24 ಸಂಜೆ 5 ಗಂಟೆಯವರೆಗೆ ನಾಮಪತ್ರಗಳನ್ನು ಸಲ್ಲಿಸಲು ಕೊನೆಯ ದಿನಾಂಕವನ್ನು ಕೂಡ ನಿರ್ಧರಿಸಿರುತ್ತಾರೆ. ಈ ಮೇಲ್ಕಂಡ ಎಲ್ಲ ಪ್ರಕ್ರಿಯೆಗಳಿಂದ ಕಂಡುಬರುವುದೇನೆಂದರೆ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಸರ್ಕಾರಿ ನೌಕರ ಸಂಘದ ಉಪವಿಧಿಗಳು 2022ರ ಉಪವಿಧಿಗೆ ವಿರುದ್ಧವಾಗಿ ಒಂದು ಇಲಾಖೆಯನ್ನು ಹೊರತುಪಡಿಸಿದ ಉಳಿದ ಎಲ್ಲಾ ಇಲಾಖೆಗಳಿಗೆ ಚುನಾವಣೆಯನ್ನು ನಡೆಸುತ್ತಿರುವುದು ಸ್ಪಷ್ಟವಾಗಿ ಇಲಾಖೆಗಳ ನಡುವೆ ತಾರತಮ್ಯವನ್ನು ಉಂಟುಮಾಡುವ ಉದ್ದೇಶವನ್ನು ಹೊಂದಿರುವುದು ಸ್ಪಷ್ಟವಾಗುತ್ತದೆ. ಅಲ್ಲದೆ ನ್ಯಾಯಾಂಗ ಇಲಾಖೆಯ ಪ್ರಾತಿನಿಧ್ಯತ್ವವನ್ನು ತಪ್ಪಿಸಿ ಚುನಾವಣೆ ನಡೆಸುವ ಪ್ರಯತ್ನವಾಗಿರುತ್ತದೆ. ಅಲ್ಲದೆ ಎರಡನೇ ಪ್ರತಿವಾದಿಯು ನ್ಯಾಯಾಂಗ ಇಲಾಖೆಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ನಿಗದಿಯಾಗಿದ್ದ ಚುನಾವಣೆಯನ್ನು ರದ್ದುಗೊಳಿಸಲು ಯಾವುದೇ ನ್ಯಾಯಸಮ್ಮತವಾದ ಮತ್ತು ಸೂಕ್ತ ಕಾರಣಗಳನ್ನು ಹೇಳಿರುವುದಿಲ್ಲ. ಕೇವಲ ನಿರಂಕುಶವಾದ ಆದೇಶವನ್ನು ಮಾಡಿರುವುದು ಮೇಲ್ನೋಟಕ್ಕೆ ಕಂಡುಬರುತ್ತದೆ. ಆದ್ದರಿಂದ ಈ ದಾವೆಯು ಮೇಲ್ನೋಟಕ್ಕೆ ಸಮ್ಮತವಾದ ದಾವೆಯಾಗಿರುತ್ತದೆ. ಈ ದಾವೆಯಲ್ಲಿ ಪ್ರತಿವಾದಿಯವರಿಗೆ ನೋಟಿಸನ್ನು ಹೊರಡಿಸಿದರೆ ಈ ದಾವೆ ಉದ್ದೇಶ ವಿಫಲ ಆಗುವುದು ಮತ್ತು ವಿಳಂಬದಿಂದ ಈ ದಾವೆ ನಿರರ್ಥಕವೆನ್ನುವ ಅಭಿಪ್ರಾಯವನ್ನು ಮುಂದಿನಂತೆ ಆದೇಶ. Then, my lord, the trial court directs, my lord, to conduct the election before 26/11/24. Since, my lord, the post to the election to the post of president and treasurer is scheduled on 27/11/2024. My lord, the returning officer who was well aware of his own order, my lord, annexure R1, withdrawing, my lord, unanimous selection of the candidates, my lord, present this writ petition, my lord, and obtain the interim order of stay.
But who is the other petition number one here?
Association, state association. They have, my lord, both the petitioner have nothing to do. My lord, aggrieved parties would be, my lord, candidates, my lord. Candidate wants the elections, whereas, my lord, state unit as well as the, my lord, election officer does not want to conduct the election. The theory behind that is, my lord, they don't want representation from the judicial department of state, my lord.
Yes.
And they deny their right, my lord, to contest, vote, and, my lord, participate in the further, my lord, the elections that were scheduled on 27/11, and next election to the, my lord, the state unit will be held on 27/12, my lord, out of the person elected in the district unit, my lord. Therefore, my lord, I may respectfully submit the writ petition is misconceived, my lord, and at the hands of election officer and state unit. My lord, my constitutional right is deprived, my lord, by playing this fraud upon the court, my lord, suppressing the order of.
Yes, Mr. Sridhar, really.
My lord, I am rely only on annexure D, my lord.
Annexure?
Annexure D, page number 48. Page number 48. Page number 40. By this order,
Just a moment.
my lord, by this order, the
Just a
third
moment,
respondent has been.
just a moment, Mr. Nimsh.
Yes, my lord.
There's some urgent order to be released. Really? Page number?
My lord, page number 48, annexure D. Kindly see the order, operative portion, my lord. Prakash Naik, third respondent.
Yes.
ಸಿರಿತ ಜಿಲ್ಲಾ ನ್ಯಾಯಾಲಯ ಸೋನ್ಸೋ ಇವರು ಸಂಘ ವಿರೋಧಿ ಚಟುವಟಿಕೆ ತೊಡಗಿರುವುದು ಸಾಬೀತಾದ ರಾಜ್ಯ ಕಾರ್ಯಕಾರಿ ಸಮಿತಿ ನಿರ್ಣಯದಂತೆ ಪ್ರಕಾಶ್ ನಾಯ್ಕ್ ಶಿರಸ್ತದವರು ಜಿಲ್ಲಾ ನ್ಯಾಯಾಲಯ ಮಂಗಳೂರು ಇವರನ್ನು ಸಂಘದ ಬೈಲಾ ನಿಯಮದ ಅವಕಾಶದಂತೆ ವಿಚಾರಣೆಯನ್ನು ಕಾದಿರಿಸಿ ತಕ್ಷಣದ ಜಾರಿಗೆ ಬರುವಂತೆ ಮತ್ತು ಮುಂದಿನ ಆದೇಶವರೆಗೆ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಸರ್ಕಾರಿ ನೌಕರ ಸಂಘದ ಪ್ರಾಥಮಿಕ ಸದಸ್ಯರಿಂದ ಅಮಾನತುಗೊಳಿಸಿ ಆದೇಶಿಸಿದೆ. This order is still in force, my lord. Now, in view of this order, he cannot become a candidate for contesting the election. That is one submission.
What about the order passed on 7th November 2024?
No, my lord, 11/11/24, the election officer declared that unopposed, my lord. After that order, then these people have gone to the civil court and civil court has passed a order without referring to the annexure D. And now you will ask me kindly see annexure L produced along with
Not on that,
the
sir. Not on that. See, this order disqualifying this person from or removing the membership, removing this person from the membership was on 12/5.
ಹೌದು.
The
ಈಗ ಎಲೆಕ್ಷನ್ ಆಗಿದ್ದು ನವೆಂಬರ್ ಅಲ್ಲಿ.
ಆಯ್ತು ಒಂದು ನಿಮಿಷ ತಾಳಿ. Suit in OS number 1229 was filed when?
That is filed.
1229 of 24 was filed on what date?
Annexure B, my lord. Annexure B prakara. That is on 4/11/24.
4/11/24. This order was passed when? 7/11.
711. My lord, this order was considered at Annexure C and order was passed permitting him to contest, my lord.
Yes, yes.
This order, Annexure C order became final. Nobody has challenged it.
Yes. And the order at Annexure R1 was passed on
1311, my lord.
Yes, Mr. Sridhar.
My lord, the 1311 Annexure R1 is the only order passed pursuant to the order of the civil court, my lord, to implement the civil court order. Annexure R1. My lord, kindly see Annexure L produced along with rejoinder statement, my lord. Now,
Yes.
this issue was referred to the state election officer. Kindly see Annexure L, page number 5, filed along with the rejoinder statement.
What is the rejoinder?
Rejoinder statement I filed just now, my lord. Page number 5, Annexure L. विषय के संबंध से कर्नाटक राज्य सरकारी नौकर संघ दक्षिण कन्नड़ जिला के 24-29 ಅವಧಿಯ ಕಾರ್ಯಕಾರಿ ಸಮಿತಿಗೆ ಮತಕ್ಷೇತ್ರ 47 ನ್ಯಾಯಾಂಗ ಇಲಾಖೆ ನಿಗದಿಪಡಿಸಿದ 2 ಸ್ಥಾನಗಳಿಗೆ ಸಬಿತಾ ಸರಾವ ಮತ್ತು ನಾಗಪ್ಪ ಕೊಳದಣ್ಣನವರು ಇವರುಗಳು ಅವಿರೋಧವಾಗಿ ಆಯ್ಕೆಗೊಂಡಿರುವುದಾಗಿ ಹಿಂದಿನ ಜಿಲ್ಲಾ ಚುನಾವಣಾಧಿಕಾರಿಯಾದ ಶಿವಾನಂದ್ ಅವರು ಘೋಷಿಸಿ ದೃಢೀಕರಿಸುವುದನ್ನು ಮೇಲ್ಕಂಡ ಮತಕ್ಷೇತ್ರ ಚುನಾವಣಾ ಕೃತಿ ಕ್ರಮಬದ್ಧವಾಗಿ ನಡೆದಿದೆ ಎಂದು ಪರಿಗಣಿಸಿ ತಿಳಿಸಲಾಗಿದೆ. This is a state election officer has passed this order. On 16
this order is not enforced. It has no legs to stand. This has no legs to stand.
My lord, my only submission is that, my lord, the civil court, without considering Annexure D, has passed order. Therefore, that order, a civil court order, I have challenged. That's my main ground, my lord. In view of Annexure D, he cannot become member or contest the election.
How much cost?
Annexure D, considering Annexure D, he cannot become the member.
This is a mischievous litigation.
Right.
Heavy cost will be imposed. Barcode. The different number 1 and 2 in OS number 1298 of 2024 on the file of the Principal Civil Judge and JMFC, Mangalore. I have filed this writ petition challenging the order dated 22/11/2024 granting ad interim mandatory injunction to conduct election year before 26/11/2024. Spara. The respondent number, the short facts necessary for the purpose of considering this petition are that the respondent number 3, being a member of the petitioner number 1, was aggrieved by an order dated 12/5/2024 unilaterally removing him from the membership of the respondent number, petition number 1. He challenged the same before the Principal Civil Judge Mangalore in OS number 1229 of 2024.
My lord, actual correction. That order was not challenged.
That was not challenged?
My lord, he seeks, my lord, to accept his nomination and, my lord, permit him to.
But what are the main reliefs that were sought in the
Annexure B, my lord, the page, my lord, 26.
Yes.
Was agreed, Madam Anisha, the respondent number 3 was removed at the respondent number 3 was removed by the petitioner number 1 from the membership in terms of an order dated 12/5/2024. The respondent number 3 was prevented from voting and contesting at the elections held to the managing committee for the period 2024 to 29. The respondent number 3 therefore filed OS number 1229 of 2024, challenging the action of the petitioners in preventing him from voting and contesting as illegal, null and void. He also sought for a mandatory injunction to remove and delete mandatory injunction ಏನು ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಏನಿದು?
ಅದು ವೋಟರ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಅವರು ಕಂಟೆಸ್ಟ್ ಮಾಡುವಂಗಿಲ್ಲ ಅಂತ ಒಂದು ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಬರೀತಾರೆ, ಅದನ್ನು ಚಾಲೆಂಜ್ ಮಾಡ್ತಾರೆ.
The endorsement made in the voter list that he was prevented from voting and contesting the election. Full stop. He also sought for an interim mandatory injunction to permit him to vote and contest in the elections to the managing committee of the petition number 1. The said application was allowed in terms of the order dated 7/11/2024. Full stop. By this time, the petitioner number 2 herein had already declared the results of the election.
ನೋ ಮೇಲ್,
ಆಗಿಲ್ವಾ?
ಇಲ್ಲ ಇಲ್ಲ, ನಾಮಿನೇಷನ್ ಅನ್ನು ಆಕ್ಸೆಪ್ಟ್ ಮಾಡಿ ರಿಜೆಕ್ಟ್ ಮಾಡ್ತಾರೆ ಅಗೇನ್.
By this time, the petitioner number 2 had rejected the nomination of the petitioner, which compelled
Nomination of two candidates.
respondent number 3, which compelled the respondent number 3 to file
ಮಿಸ್ಲೇನಿಯಸ್ ಕೇಸ್
miscellaneous case
22 of 24.
2 of 2024. Full stop. The court, in terms of the order dated 11/11/2024, directed the exercise power under section 94E, read with section 151 of CPC, and directed the petitioners to permit the respondent number 3 to vote and contest the elections. Full stop. Following this, the petitioner number 2 passed an order dated 13/11/2024, cancelling the declaration of results of the elected candidates and proceeded to hold fresh elections on 16/11/2024. In that background, the respondent number 1
Please.
filed OS number 1298 of 2024. ಅದೇನಕ್ಕೆ?
ಅದು ಡೈರೆಕ್ಷನ್ ಟು ಕಂಡಕ್ಟ್ ದಿ ಎಲೆಕ್ಷನ್ಸ್ ಮೆಲಾರ್ಡ್ ಬಿಫೋರ್ 26.
For a direction to conduct elections, where do I get the plaint in 1298?
Next page 54. Prayer ಮೆಲಾರ್ಡ್ gets it at page 50. Internal page 6 ಅದೆಷ್ಟು?
Page 60. Page
59.
For mandatory injunction to conduct election from the constituency number 47 on or before 26/11/2024. We also sought for an interim ex parte order of mandatory injunction to direct the petitioners herein to conduct the elections. The trial court, after being satisfied was granted an order, passed the impugned order dated 22/11/2024, directing the petitioners to conduct elections from constituency number 47, bracket judicial department, bracket close, by or before 26/11/2024. Full stop. Being agreed by the said order, the petitioners are before this court. Full stop. The learned counsel for the petitioners contended that the respondent number 3 was removed from the membership of the petition number 1. And the court in OS number 1229 of 2024, without noticing the said fact, had passed an order permitting him to vote and contest in the elections. Full stop. He therefore contends that the impugned order was predicated on the order dated 7/11/2024, passed in OS number 1229 of 2024. Thus, he contends that the trial court could not have passed an ex parte order of ad interim mandatory injunction directing the petitioners to conduct elections by or before 26/11/2024. Per contra, the learned counsel for the respondent number 1 and respondent number 3 contends that the court in OS number 1229 of 2024 had taken into consideration the order dated 12/5/2024. ಮಾಡಿದ್ರಾ ಇಲ್ವಾ?
ಮಾಡಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ ಅದು?
Annexure D, page number 48.
ಅಲ್ಲ 12/5/2024 ಕನ್ಸಿಡರ್ ಮಾಡೋದು ಎಲ್ಲಿದೆ?
ಪೇಜ್ 37 ಅಲ್ಲಿ ಸರ್.
ಎಲ್ಲಿದೆ?
ಪೇಜ್ 37. ಈ ಮೇಲ್ಕಂಡ ನಿಯಮದ ಪ್ರಕಾರ, after referring to the rules, my lord, it was held by the trial court that, my lord, mere suspension will not debar from contesting the election.
ಅಲ್ಲ, but whether there was a reference to this particular order?
Yes, my lord.
Have they seen this order?
Yes, my lord.
12/5/24. 12/5/24 ಎಲ್ಲಿದೆ?
ಇಲ್ಲಿ ಪೇಜ್ 39 ಅಲ್ಲಿ ಇದೆ ಸರ್.
ಓದಿ.
ಆದರೆ ಸೆಕೆಂಡ್ ಪ್ಯಾರ ಅದನ್ನು ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿ ಹೇಳ್ತಾರೆ. ಆದರೆ ಅಂತ ಒಂದು ಉಚ್ಚಾಟನೆ ಕ್ರಮವನ್ನು ತೆಗೆದುಕೊಳ್ಳುವ ಮೊದಲು ಆಡಳಿತ ಮತ್ತು ಶಿಸ್ತು ಸಮಿತಿಯ ಮುಂದೆ ಅಂತ ಆರೋಪಿಯ ವ್ಯಕ್ತಿಯ ವಿಚಾರಣೆಯನ್ನು ನಡೆಸಿ ಸದರಿ ವಿಚಾರಣೆಯಲ್ಲಿ ಆತನ ವಿರುದ್ಧ ಆರೋಪಿಸಿರುವ ಆರೋಪಗಳು ಸಾಬೀತಾದ ಸಂದರ್ಭದಲ್ಲಿ ಮತ್ತು ಆಡಳಿತ ಮತ್ತು ಶಿಸ್ತು ಸಮಿತಿಯ ಶಿಫಾರಸುಗಳೊಂದಿಗೆ ಅಂತಹ ಸದಸ್ಯನ ವಿರುದ್ಧ ಶಿಸ್ತು ಕ್ರಮ ಕೈಗೊಳ್ಳುವ ಅಧಿಕಾರ ರಾಜ್ಯಾಧ್ಯಕ್ಷರಿಗೆ ಇರುತ್ತದೆ. None of the ಇದೆ
12/5/2024 and had passed an ad interim mandatory injunction directing the petitioners to permit the respondent number 3 to vote and contest the elections from constituency number 47. He contends that the respondent petition number 1, after being directed in OS number in miscellaneous number 22/2024, had passed an order cancelling the elections, cancelling the declaration of result void order dated 13/11/2024 and had proceeded to hold elections afresh on 16/11/24. Therefore, he contends that the petitioner number 2 cannot challenge the order passed by the trial court in OS number so and so, OS number 1298, 1298 of 2024, directing the elections to be conducted by or before 26/11/2024. He further contends that the trial court has applied its mind before granting the ad interim mandatory injunction, since elections to the post of president
president and treasurer, my
and
lord.
treasurer is to be held.
Lordship may say office bearers of
Office bearers,
district.
office
government.
bearers of the district association
Please, my lord.
is to be held on
27/11, my lord.
27/11.
Yes,
11 or 12?
11 ಗೆ. ಅದಕ್ಕೆ 25 ಹಾಕಿ ಸ್ಟೇ ತಗೊಳ್ತಾರೆ.
On 27/11/2024. He submits that the petitioners have obliquely approached this court and have obtained an order of stay of the order passed by the trial court. Next para. I will consider the submissions of the learned counsel for the petitioner and the learned counsel for the petitioners and the learned counsel for the respondents. Next para. The petitioner number 1 had issued a calendar of events proposing to conduct elections.
Page 51, my lord.
Proposing to conduct elections.
Annexure F, page 51.
From Dakshina Kannada district. Which is as follows, copy of Annexure F. The petitioner number 2, having once fallen in line with the order passed by the Principal Civil Judge Mangalore in miscellaneous 22 of 24, and having cancelled the elections held to the district, elections held from the Dakshina Kannada district, and proposing to hold elections by or before 16/11/2024, was bound in law to conduct the elections. Full stop. The failure of the petitioner number 2 in holding elections had compelled the respondent number 1 to file a suit seeking for conduct of elections from the district from
Constituency. What is it?
Dakshina Kannada district, as the elections to the office bearers was scheduled on 27/11/2024. Full stop. The trial court has therefore methodically considered each and every fact and had passed the impugned order directing the petitioners herein to conduct elections by or before 26/11/2024. Full stop. The petitioners were not immediately affected by the impugned order, and therefore they are not entitled to challenge the impugned order. Nonetheless, they have challenged the impugned order and have ensured that the elections that were required to be held by 26/11/2024 is not held, and thereby have deprived an opportunity to the respondent number 1 and 3 from staking their claim to become the staking their claim to the post of Yaudu.
That is, my lord, office bearer of district association.
Office bearers of the district association as well as the state association.
Next state association, my lord, on 27/12, my lord.
On which is scheduled to be held on 27/12/2000.
That, my lord, if they conduct the elections, my lord.
Stop. Under the circumstances, the writ petition filed by the petitioners is wholly mischievous and is a clear attempt to undermine the democratic process and to deprive lawful members of the petitioner number 1 from contesting. Full stop. In that way of the matter, this writ petition is dismissed, upholding the order passed by the trial court. Full stop. The petition, since the petitioners have filed this, have mischievously filed this petition, they are bound to be visited with exemplary costs. Consequently, the petitioners are directed to pay cost of rupees 5 lakhs payable to ಯಾರಿಗೆ? ಯಾರಿಗೆ ಕೊಡ್ಬೇಕು?
ಎಷ್ಟು ಸ್ವಾಮಿ ಎಷ್ಟಾಯ್ತು?
Leave to my
ಸ್ವಾಮಿ
lord.
ನನಗ್ ಬೇಡ, ಬೇರೆ ಯಾರು ಕೊಡ್ಬೇಕು ಹೇಳಿ?
ಇಲ್ಲ ಅಸೋಸಿಯೇಷನ್ ಯಾವ್ದು
Payable to whom? ಮಂಗಳೂರಲ್ಲಿ ಯಾವ್ದು ಆರ್ಫನೇಜ್ ಏನೋ ಇದೆಯಾ?
ಮಿಲಾಟ್, one submission I would like to make, Milord. Kindly see page number 40. ಅದನ್ನ ನೋಡಿದ್ರೆ ತಾವು ಕಾಸ್ಟ್ ಹಾಕ್ಲಿಕ್ಕಿಲ್ಲ ಅನ್ಸುತ್ತೆ ನನಗೆ.
ಓದಿ.
Page number 40 ನೋಡಿ sir. ಅವರ ಫಸ್ಟ್ ಲೈನ್ ಮೇಲೆ ಆರ್ಡರ್ ಸುಸ್ತು ಮುಂದೆ ಹಾಜರು ದಿನಾಂಕ 5/1/24 ನೋಟಿಸ್ ಹೊರಡಿಸಲಾಗಿದೆ. ಸದರಿ ನೋಟಿಸ್ ವಾದಿ ಸ್ವೀಕರಿಸಿ ಕೂಡ ವಾದಿಯು ಹಾಜರಾಗಿರುವುದಿಲ್ಲ. ಅದಾದ್ಮೇಲೆ ಲಾಸ್ಟಿಗೆ ಅದೇ ಪೇಜ್ ನಲ್ಲಿ ಲಾಸ್ಟಿಗೆ ಆರೋಪಿ ಸಂಬಂಧ ಆತನಿಗೆ ಸದರಿ ಆರೋಪಗಳಿಗೆ ಪ್ರತಿರಕ್ಷಣೆ ತೆಗೆದುಕೊಳ್ಳಲು ಆತನ ಹೇಳಿಕೆಯನ್ನು ಸಲ್ಲಿಸಲು ಸೂಕ್ತ ಅವಕಾಶವನ್ನು ನೀಡದೆ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. ನೋಟಿಸ್ ಕೊಡಬಹುದು ಅಷ್ಟೇ ಹೊರತು ನಾವು ಕೊನೆಗೆ ಅವರು ಬರದೇ ಇದ್ರೆ ಅಂಡ್ ದಟ್ ಆರ್ಡರ್ ಇಸ್ ಫೈನಲ್.
ಎಸ್, ಎಲ್ಲಿ ಕೊಡ್ಬೇಕು ಹೇಳಿ ಕಾಸ್ಟ್?
ನಾಮಿನಲ್ ಹಾಕಿ ಸ್ವಾಮಿ.
ಅಯ್ಯ, ನಾಮಿನಲ್ ಇದು ನಿಮ್ದೆಲ್ಲ ಸ್ಟೇಟ್ ವೈಡ್ ಎಲೆಕ್ಷನ್ ತಾನೆ. ನಾಮಿನಲ್
ಅಲ್ಲ, ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಲೆವೆಲ್ ಅದು.
ಆಯ್ತು, 5 ಲಕ್ಷ ಯಾರು ಕೊಡ್ಬೇಕು ಹೇಳಿ? ಅದ್ಯಾವ್ದೋ ಒಂದು ಝೂ ಇದೆಯಲ್ಲ, ಮಂಗಳೂರು ಝೂ ಇದೆಯಲ್ಲ, ಪಿಳುಕುಳ, ಅದಕ್ಕೆ ಕೊಡ್ರಿ. ಪೇಬಲ್ ಟು ಪಿಳುಕುಳ ಝೂ, ಮ್ಯಾಂಗ್ಳೂರ್, within 4 weeks from today. Full stop.
ಹೊಸ ಬೆಳಕು ಚೆನ್ನಾಗಿದೆ.
View of
ಹೊಸ ಕಾರ್ಕಳದಲ್ಲಿದೆ ಅಂತೆ.
ಅದು ಯಾವ್ದು? ಹೊಸ ಬೆಳಕು ಓಲ್ಡ್ ಏಜ್ ಹೋಮ್. ಓಲ್ಡ್ ಏಜ್ ಹೋಮ್ ಆರ್ಫನೇಜ್? ಕೊಡಿಯೋದು
ಕಾರ್ಕಳ
within 4 weeks from today. Stop. In view of the stay of the impugned order being vacated, comma, the petitioners are directed to hold elections. ಎಷ್ಟು ದಿನದಲ್ಲಿ? Before 27/12,
Before
27/12/2024, and report complaints to this court.
Please. Great.
Please wait, I am still sitting, mister. Yeah, the 230, Jagdish DC.
DC Jagdish.
DC Jagdish. DC Jagdish. Yeah, what is the decree for? Sir, you should give me the full facts, sir. Correct facts ಹೇಳಿದ್ರೆ ಮಾತ್ರ stay ಕೊಡೋದು. No, what is the decree? Possession. What is your claim? The suit is filed when 116 of 2000. ಯಾರು ಫೈಲ್ ಮಾಡಿದ್ದು? ನೀವ್ ಯಾರು ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದ್ದು? ಎಸ್. ನಾಗರಾಜ್ಗೂ ನಿಮ್ಗೆ ಏನ್ ಸಂಬಂಧ? Issue emergent notice. Issue emergent notice in addition on account for the petition directed to serve the counsel for the respondent before the executing court till the next date of hearing, comma, the further proceed, to the next state of hearing, comma. The executing court shall not issue delivery warrant. List on yavat. Stay of further proceedings in EP number so and so on the file of so and so. List on date could immediately after vacation.
Serial number 62.
Mister, if all of you should wait one by one, ಹೇಳಿದ್ರೆ ಕೇಳ್ತೀನಿ ಇಲ್ಲ ನಾನು ಎದ್ದು ಹೋಗ್ತೀನಿ. ಆಯ್ತು, yes. Serial number 68. It will come on Monday. Yes. Yes, madam. Serial number 70. 70. What do you want? What do you want? You want to argue? No, I can't hear. So it will come some other day, Monday, Tuesday, yes. Serial number 95.
Your Lordship.
I told you, you should wait. My time is over. I'll get out. You should be patient, mister. 57. Monday ಆಗುತ್ತೇನ್ರಿ? ತುಂಬಾ ಇದೆಯಾ? Tuesday, Wednesday ತಗೊಳ್ಳಿ ಬೇರೆ Wednesday. 66 Wednesday.
Serial number 85, my lord.
He is saying something, please wait. Monday, yes, Monday list along with WP number
32913.
so and so, so and so. Yes, mister. Should it come next week or after vacation? Why, what's the urgency? Mister, what is the urgency? It can come after vacation also. We are also facing hardship, only 4 days left, just after vacation.
62 may be posted on Tuesday because the main matter is posted for arguments and this repetition is likely to become infructuous. So Tuesday, I request.
Tuesday, yes.
62.
Serial number 69 my lord. Have it on Monday. ಅದು ಇವತ್ತಿಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಹಾಕೊಂಡಿದ್ರೆ ನಿನ್ನೆಯಿಂದ ಆಲ್ರೆಡಿ ಜಜ್ಮೆಂಟ್ ಫಸ್ಟ್ ಟೈಮ್.
Yes.
Serial number 37.
Serial number 59. ನೋಡಿ ಅದು ಆಗಲ್ಲ, ರೀಚ್ ಆಗಲ್ಲ, ಸುಮ್ಮನೆ ಕಾಯ್ಬೇಕಾಗತ್ತೆ. Tuesday, yes. ಆಯ್ತು.
Serial number 37. That was passed on. Office objection complaint ಮಾಡಿದ್ದೀನಿ.
ಆಯ್ತು, ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ.
Type copy legible ಇಲ್ಲ.
ಏನ್ ಮಾಡ್ಬೇಕಿದ್ರಲ್ಲಿ? Learned counsel for the petitioner submits that she has complied the office objections. Office is directed to check and verify. Interim order granted release extend to the next day. Let it come after vacation. Urgency ಏನಿದೆ ಸುಮ್ಮನೆ ಕೇಳ್ಬೇಡ್ರಪ್ಪ. ಅರ್ಜೆನ್ಸಿ ಏನಿದ್ರೆ ಹೇಳಿ ತಗೊಳ್ತೀನಿ. ಎಸ್, ಯಾವತ್ ಬೇಕು ಹೇಳಿ. ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ? ಆಯ್ತು.
Serial number 82 my lord. Serial number 82 my lord.
What's your name? ನಿಮ್ಮ ಹೆಸರೇನು?
ಅನಿಕೇತನ.
Huh?
ಅನಿಕೇತನ.
ಅನಿಕೇತ.
ಅನಿಕೇತನ.
ನಿಕೇತ.
ಅನಿಕೇತನ.
ಅನಿಕೇತನ.
Serial number 82 my lord. Kindly extend entry ಮಾಡೋಣ. ಅದು ಲಾಸ್ಟ್ ವೀಕ್
ಬಂದ ನಂಬರ್
82.
82 ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಬೇಡಿ. ಹಂಗೆ ಇಟ್ಕೊ. ವೆಕೇಶನ್ ಬರ್ಲಿ ನಾನು. ಆಯ್ತು, ವೆಕೇಶನ್ ಡೇಟ್ ಕೊಡೋಣ. ಆಯ್ತು ಕೊಡಿ. ಯಾವತ್ತು ಬೇಕು? ಯಾವತ್ತು ಬೇಕು ತಗೊಳ್ಳಿ. ಬುಧವಾರ, ಗುರುವಾರ. ಗುರುವಾರ. ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಡೇಟ್ ಅಂತ ಕೊಡ್ರಿ.
Wednesday, my lord.
ಏನಕ್ಕೆ urgency ಏನು?
Urgency is, my lords, supplementary agreement has been imported. Now, my lords, yesterday it has been referred to the. for
ಏನಾಗುತ್ತೆ?
adjudication.
ಏನಾಗುತ್ತೆ?
So,
What will
sir,
happen?
start development now it has been posted for dependent evidence. my lord.
ಆಯ್ತು, what will happen? Impound ಆದ್ರೆ ಏನಾಗುತ್ತೆ? Court can always say, don't collect after vacation.
The direction to the.
After vacation, but ಆಯ್ತು, ಒಂದು date.
102, man. After
Ah.
vacation, 7.
ಆಯ್ತು, take whatever date.
My lord,
ಆಯ್ತನ?
please.
You are young, you are energetic, but you should hold your energy for some other purpose.
Please.
ಇಲ್ಲಿ ಬಂದು ಕೂಗಿದ್ರೆ ಇಲ್ಲ. They are all waiting. They are all seniors.
Apology.
Seniors ಕಾಯ್ತಿದ್ದಾರೆ. ನೀನ್ ಹೆಂಗೆ you're jumping like a jack, taka 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 ಅಂತ.
Apology.
Don't do this, mister. ಏನು, what is that you want?
Serial number 82, my lord. ಅದು last week ಬಂದಿತ್ತು ಅದು. Entry ಮಾಡಿ extend ಆಗಿಲ್ಲ, my lord. Kindly extend entry.
ಆಯ್ತು, interim order extended.
My lord, interim order action.
All interim orders will be extended.
Much. Please. Sir, madam, hand delivery.
ಇನ್ನೊಂದ ಕರ್ಕೊಂಡು ಹೋಗ್ಬಿಡ್ರಿ.
Sir, 15 and Tuesday. Mention ಮಾಡಿದ್ದೀನಿ.
Sir, sir, 85.
There is a. Hand delivery.
ಬರೀತೀರಾ sir? ಹೇಗ್ ಮಾಡ್ತೀರಾ sir?
Sir, 15 and Tuesday
Sir.
mention ಮಾಡಿದ್ದೆ.
ಕಾಯ್ತಾರೆ.
Wait.
ಹಾಗೆ 115.
ಹೌದಾ? 8.
115.
102.
Sir, 15 and ನಾನು mention ಮಾಡಿದ್ದೆ.
Vacation ಆದ್ಮೇಲೆ 115.
Sir,
115 ನೋಡಿ ಸರ್.
15 and Tuesday ಹಾಕೊಂಡ್ರಾ?
115 ನೋಡಿ.
ಅಲ್ಲ 15 and ನಾನು mention ಮಾಡಿದ್ದೆ.
ಸರ್ 72 ನೋಡಿ. ಬರ್ತಾ ಕಾಯ್ತಾರೆ ಸರ್, ನಿಮಿಷ ಸುಮ್ಮನೆ ಎಲ್ಲ ಕನ್ಫ್ಯೂಸ್.
59 Tuesdayಗೆ.
ಆಯ್ತು.
Tuesday, sir. 59.
6, 17, 12.
ಹಾ, ಹೌದು.
57, 18, 12. 58 ಯಾರು ಇಲ್ವಾ? ಎಲ್ಲ after vacation.
59.
Date ಇಲ್ಲ.
Sir, 59. Tuesday, 59.
60 after vacation. 62 Tuesday. 63 after vacation. 64 Monday.
After vacation date ಕೊಡೋದಿಲ್ಲ.
ಇಲ್ಲ after vacation. 64 Monday. 65 after vacation. 66 Wednesday. 67 after vacation. 68 Monday. 69 Monday. 70, 17, 12. Tuesday. 71 after vacation. 72 after vacation. 73 after vacation. 74 after vacation. 75 after vacation. 76 after vacation. 87, 78, 79 after vacation. 80 after vacation. 81 after vacation. 82 after vacation. 83 after vacation. 84 after 85 into 1. 86, 87 after vacation.
Sir, 87 ಇದೆ entry order ಇದೆ. 87.
87
Interim, 87 entry order.
88 after vacation, 89 after vacation, 90, 81, 25, 91, 92, 93, 94 after vacation, 95, 16, 12.
92 entry order extend ಆಗಿದೆ.
92,
Sir, 81.
ಅದೇ sorry, 86 after vacation, 97, 98, 89, 100. ಯಾವ್ದು? ಅದು
102 submission ಮಾಡಿದ್ರೆ 102 7 ಮಾಡಿ
7
submission ಮಾಡಿ 7 ಮಾಡಿ
103 103 after vacation. 104, 5, 6,
7,
106,
7
order extend ಆಗ್ಬೇಕು.
107, 107, 71.
ಸರ್ 111 ಸರ್ 111 ಒಂದು ಡೇಟ್ ಕೊಡಕ ಆಫ್ಟರ್ ವೆಕೇಶನ್ 111 ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಅವ್ರು 111 ಒಂದು ಅಲ್ಲ ಒಂದು ಡೇಟ್ ಯಾವ ಡೇಟ್ ಹೋಗಿದೆ ಬರ್ದಾಗ 112 after vacation 13 after vacation 115 after vacation 150 115 after vacation 115 after vacation 117 after vacation
117 but 2006 ಅದಕ್ಕೆ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ after vacation 13 1
Court officer.
13 1 118 after
I told you, ma.
81
Court officer.
81 ಅದು highest disposal ಹಾಕಿದ್ದಾರೆ ಅದು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಡೇಟ್ ಬೇಕು ಡಿಸ್ಪೋಸಲ್ 81 ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಡೇಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಡೇಟ್ ಟು ವೆಡ್ನೆಸ್ಡೇ ಥರ್ಸ್ಡೇ ಅದು highest disposal ಹಾಕಿದ್ದಾರೆ ಯಾವ್ದರ ಒಂದು
ಇದು 91 91 ಅದು ಡೇಟ್
91 13 77
Court officer. Court officer.
20 ಬೆಳಿಗ್ಗೆ ಇದಾಗಿದೆ ಅಯ್ಯೋ ಒಂದು ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಬಿಟ್ಟು 29 ಸರ್ ಅದೊಂದು ಮಿಸ್ ಆಗ್ದಂಗೆ ತುಂಬಾ ಇಂಪಾರ್ಟೆಂಟ್ ಮಾಡಿ ಓಕೆ ಓಕೆ
Court officer.
ಸರ್ ಹೇಳಿ
106 ಅಲ್ಲಿ interim order extend ಆಗ್ಬೇಕು.
106
ಹಾ ಸುಮನ ನಾಗನಂದ್.
ಸರ್ ಆಗುತ್ತೆ ಸರ್
ಹಾ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಅಲ್ವಾ?
ಆಫ್ಟರ್ ವೆಕೇಶನ್
ಡೇಟ್ ಇಲ್ಲ.
ಇಲ್ಲ
ಓಕೆ ಥ್ಯಾಂಕ್ ಯು.
ಅದು ಯಾವುದು ಅಡ್ರೆಸ್ ಕೊಡಿ ಮೇಡಮ್ ಮೇಡಮ್ ಅದು ಕೆ ಶ್ರೀಧರ್ ಅಷ್ಟೇ ಬರೀರಿ ರಾಕೇಶ್ ಕಣಿ ಬರಿಬೇಡಿ ಕೆ ಶ್ರೀಧರ್ ಅಡ್ವೊಕೇಟ್ ಫಾರ್ ಪೆಟಿಷನ್ ಅಡ್ವೊಕೇಟ್ ಫಾರ್ ಪೆಟಿಷನ್ ಬ್ರಾಕೆಟ್ ಅಲ್ಲಿ NOC
filed in court along with reason. ಯಾಕಂದ್ರೆ ಮತ್ತೆ ಒಕ್ಕಲಕ್ಕೆ ಹಿಂದೆ ಹುಡುಕ್ಬಾರ್ದು ಅವರೆಲ್ಲ ಲಿಸ್ಟ್ ಅಪ್ಲೋಡ್ ಹಂಗೆ ಡೇಟ್ ಹೇಳ್ಬಿಡು 56 ಡೇಟ್ ಎಷ್ಟು 56 17 ಅಲ್ಲ 47 ಎಷ್ಟು 18 ಅಕೌಂಟ್ ಪರ್ಟಿಕ್ಯುಲರ್ಸ್ ಫೋನ್ ಪೇ ಅವು ಇವು ಎಲ್ಲ
ಕೊಡಿ ಮೇಡಮ್
ಶ್ರೀಧರ್ ಸರ್ ಮತ್ತೆ ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕಾ
ಶ್ರೀಧರ್
ಆರ್ಡರ್ ಬಂದ್ರೆ ಅವರೇ ಹುಡ್ಕೊಳ್ತಾರಲ್ಲ
ಹೇಳ್ಬಿಟ್ಟು ಫೋನ್ ಮಾಡಿ ಹೇಳ್ಬಿಡಿ ಅಷ್ಟೇ
ಅಲ್ವಾ ಹುಡ್ಗ ಗೊತ್ತು ನಂಗೆ ಅವ್ನ ತಂದೆ ಗೊತ್ತು
ಕರೆಕ್ಟಾ ಮೇಡಮ್ ಇದು
ಎಸ್
ಸೇವಾ ಟ್ರಸ್ಟ್ ಕಣಜೂರು ವಿಲೇಜ್ ಬೈಲೂರು ಕಾರ್ಕಳ ತಾಲೂಕ್ ಸೌಂಡ್ಸ್ ಆಯ್ತು ಮೇಡಮ್
ಓಕೆ ಸರ್ ಥ್ಯಾಂಕ್ ಯು ಸರ್ ನನಗೊಂದು ಕೂತ್ಕೊಳಿಸಿದ್ದಕ್ಕೆ ಅಲ್ಲ
ಇದು THM ಇದು ನಾನು ಅವಾಗ್ಲೇ ಇಡುವಂತ ಮೇಡಮ್ ಡಿಸ್ಪೋಸಲ್ ಎಲ್ಲ ಕೊಟ್ಬಿಟ್ರ ಮೇಡಮ್ ಇದು THM ತಂದ್ಕೊಟ್ಟ
ಅದು ಇಂಟ್ರೀಮ್ ಆರ್ಡರ್ ಅವ್ರಿಗೆ ಇಲ್ಲ ಅವ್ರಿಗೆ ಅದೇ 82 ಇಂಟ್ರೀಮ್ ಆರ್ಡರ್ ಅವ್ರಿಗೆ 106
ಇದು PMR
92
ಇದಲ್ಲ ನಂಬರ್ 55 ಗೆ
106 ನೀರಲ್ಲಿ ಮಧ್ಯಾಹ್ನ ಬೆಳಿಗ್ಗೆ ನಿಂತಿರಲ್ಲ ಡೇಟ್ ಇಷ್ಟೇ ಅಲ್ವಾ ಇಲ್ಲಿ ಯಾವ್ದಿಲ್ಲ
ಇವೆರಡು ಫೈಲ್ ಹೊಟ್ಟೈತಲ್ಲ
ಕೇಳ್ಪಟ್ಟಿರ್ತೀನಿ ಟ್ಯೂಸ್ಡೇ ಬರ್ತಾನಂತ ಅಲ್ಲಿಂದ ನನ್ನ ಟ್ಯೂಸ್ಡೇ ಸರ್ ಇದು ಡೇಟ್ ಅವ್ರು ಕೊಟ್ಟಲ್ಲ ಕೊಡ್ತೀರಾ ಅಪ್ಡೇಟ್ ಮಾಡ್ಲಿಕ್ಕೆ
ರಿಪೀಟ್ ಕೊಟ್ಬಿಡ್ಲ ಒಂದ್ ನಿಮಿಷ ರಿಪೀಟ್ ಕೊಟ್ಬಿಡ್ಲ
ನಾನು ಹಾಸ್ಪಿಟಲ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಇತ್ತು ಡೇಟ್ ಹೋಗ್ಬೇಕು
ಬರ್ಕೊಳ್ಳಿ
ಇಲ್ಲಿ 47 ಇಂದ ಉಳಿದಿದೆ
ಏನಪ್ಪ ಓ ಅದು ತೆಗಿಬೇಕು ತೆಗಿತೀರ ಮೇಡಮ್ 56 ಇಂದ
47 ಅಲ್ಲಿಂದ 47 ಇಲ್ಲ ನನ್ನ ನಂಬರ್ ಹೇಳ್ತೀರಿ ಅದನ್ನ ಹೇಳ್ತಾ ಇದ್ದೀನಿ 37 ಅಪ್ಡೇಟ್ ಮಾಡಿದ್ದೀನಿ
ಅಡ್ಜನ್ ಅಷ್ಟೇ
ಮಾಡಿದ್ವಿ ಸರ್ 43 ಡೇಟ್ ಕೊಟ್ಟು ಅದನ್ನು
43 1912 19 12 ಹಾ ನೀವ್ ಯಾವ್ದು ಬರದ್ರಿ ನಾನು ಬರ್ಕೊಂಡಿದ್ದೀನಿ ಕರೆಕ್ಟ್ ಆಗಿ ಸೀರಿಯಲ್ ಆಗಿ ತಂದ್ಕೊಡಿ ಹುಡುಗದ ಹಂಗೆ ಹೇಳ್ತೀನಿ ಹಂಗೆ ಸೀರಿಯಲ್ ಆಗಿ ಹೇಳಿ ನೋಡಿ ಆಯ್ತಾ 19 ಮಾಡಿ ಅದಾದ್ಮೇಲೆ ಯಾವ್ದ ಕೇಳಿದ್ರಲ್ಲ 47 ಅದು ಡಿಸ್ಪೋಸ್ ಆಫ್ ಮಾಡಿಲ್ಲ ನಾನು ಮಾಡ್ತೀನಿ ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್ ಇನ್ಶಿಯಲ್ ಬಂದು THM ಈಗ ಅವಾಗಲೇ ಹೇಳಿದ್ನಲ್ವಾ ಇದು ಯಾವ್ದು ಹೇಳಿ 37 PMR ಇನ್ಶಿಯಲ್ ಹಾಕಿ ಆಮೇಲೆ ಇನ್ನೊಂದು 43 ಅದು PMR ಹಾಕೊಳ್ಳಿ ಇನ್ಶಿಯಲ್ 43 PMR ಇನ್ಶಿಯಲ್ ಹಾಕೊಂಬಿಡಿ ಹೆಂಗಿದೆ ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ 47 ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್ THM 48 ಡಿಸ್ಮಿಸ್ THM ನೆಕ್ಸ್ಟ್ ಯಾವ್ದು ಬೇಕು
ನೆಕ್ಸ್ಟ್ ಸರ್ 56
ಏನಾಯ್ತು
ಬರ್ಕೊಂಡಿದ್ದೀನಿ
ಅಲ್ಲ 56 17 12 PMR 57 18 12 PMR 58 ಆಫ್ಟರ್ ವೆಕೇಶನ್ PMR ಇಲ್ಲ ಇರಿ ಅದಕ್ಕೆ ಇನ್ಶಿಯಲ್ ಗಳು ಯಾವ್ದು ಹಾಕಕ್ ಹೋಗ್ಬೇಡಿ ಸದ್ಯಕ್ಕೆ ಅಲ್ಲ ಯಾವ್ದಕ್ಕೂ ಇನ್ಶಿಯಲ್ ಬಿಟ್ಬಿಡಿ ನಾನು ಹಾಕ್ತೀನಿ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಇನ್ಶಿಯಲ್ ಗಳು ಮಾತ್ರ ಹಾಕಕ್ಕೆ ಹೋಗ್ಬೇಡಿ ಯಾಕಂದ್ರೆ ಕೆಲವು ನಾವೇ ಬರಿತೀವಿ ಅದಕ್ಕೆ ಇನ್ಶಿಯಲ್ ಹಾಕ್ಬಾರ್ದು ಅವ್ರು ಕೊಡೋದಕ್ಕೆ ಮಾತ್ರ ಇನ್ಶಿಯಲ್ ಹಾಕ್ಬೇಕು ನೀವು ಯಾವ್ದಕ್ಕೆ ಇನ್ಶಿಯಲ್ ಹಾಕಕ್ ಹೋಗ್ಬೇಡಿ 58 after vacation ಅಂದ್ರೆ ಅರ್ಜೆಂಟ್ ಅಷ್ಟೇ. 59 17 12 60 after vacation 61 after vacation 52 Tuesday ಅಂದ್ರೆ 17 12 63 after vacation 64 Monday 16 12 65 after vacation 66 Wednesday ಅಂದ್ರೆ 18 12 67 after vacation 68 Monday 16 69 Monday 70 17 12 71 after vacation 72 after vacation 73 after vacation 74 after vacation 75 after vacation 76 after vacation ಅನ್ನೋದಕ್ಕೆಲ್ಲ ಬರೀ ಅರ್ಜೆಂಟ್ ಆಯ್ತು. 77 10 1 25 ಆಯ್ತಾ ಮೇಡಮ್? 76 after vacation 77 10 1 25 78 after vacation 79 after vacation 80 after vacation 81 19 12 ಆಮೇಲೆ 82 after vacation 83 ಎಂಟ್ರಿ ಮಾಡ್ರೆಲ್ಲ ಮಾಡಕ್ ಹೋಗ್ಬೇಡಿ, ಬರೀ ಅರ್ಜೆಂಟ್ ತೋರಿಸಿ. 82 after vacation 83 after vacation 84 after vacation 85 8 1 25 20 25 86 after vacation 87 after vacation 88 after vacation 89 after vacation 90 8 1 2025 91 13 1 2025 92 after vacation 92 93 94 after vacation 95 Monday 96 after vacation 97 98 99 100 after vacation 101 after vacation
ಎಲ್ಲ 103 ವರೆಗೂ after vacation.
ಹೇಳ್ತೀನಿ ನಾನು 101 ವರೆಗೂ 101 ವರೆಗೂ after vacation 102 7 1 25 103 after 103 ಇಂದ 109 ವರೆಗೂ after vacation 110 8 1 2025 ಯಾವ್ದು ಹೇಳಿ 110 111 after vacation 112 after vacation 113 after vacation 14 after vacation 115 8 1 2025 116 after vacation 117 13 1 2025 118 7 1 2025 7 1 2025 ಅಷ್ಟೇ ಮೇಡಮ್. ಇದು ಸೆಕೆಂಡ್ಲಿ 233 ಮ್ಯಾಟ್ರು ಅಪ್ಡೇಟ್ ಮಾಡಿದ್ರಾ? ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಈಗ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಅವರು ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸು 7/1 ಡೇಟ್ 7/1/25.
ಸರ್ 230 DC ಜಗದೀಶ್ ಅದು WP ನಂಬರ್
ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ 34060 34060
ಬರ್ 24 ಅಲ್ಲ ಸರ್?
24
ಸರ್ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಕೊಟ್ವಿ,
ಬರುತ್ತೆ ಸೈನ್ ಹಾಕಿ ಬರ್ಬೇಕಲ್ಲ.
ನಾವು ಬ್ರಾಂಚ್ಗೆ ಹೋಗೋಣ.
ಬ್ರಾಂಚ್ಗೆ ಹೋಗ್ತಾ ಇದ್ದೀವಿ.
ಥ್ಯಾಂಕ್ ಯು ಸರ್. 340
ಅಲ್ಲೇ ಇಟ್ಟಿದೆ
ಸರ್ 34060
ಸರ್ ಎಷ್ಟು ಸರಿ
Sorry, sir.
34060 of 24.
ಥ್ಯಾಂಕ್ ಯು.
82 after vacation 83 after vacation 84 after vacation 85 81 96 ಇಲ್ಲ 97 ಇಲ್ಲ ಆಮೇಲೆ ಬರುತ್ತೆ 102 ವರೆಗೆ 101 ಇಲ್ಲ ಮೇಬಿ ರಿಕಾಲ್ ಇರಬಹುದು 7 1 ಹಂಗೆ ಬರ್ಬೇಕಲ್ಲ ಇಲ್ಲಿ ನೋಡಿ ಜನರು ನಮ್ಮ ವರ್ಷ ತಗೊಳ್ಳಲ್ಲ ಇದೆ ನಾವೇ ಅಪ್ಲೋಡ್ ಮಾಡೋಣ So 103 ಇಂದ 103 application 103 ಇಂದ 109 ವರೆಗೂ application ಇನ್ನೊಂದಷ್ಟು ಬರ್ತದೆ ಸ್ವಲ್ಪ ಫಾಸ್ಟ್ ಇದೆ ಈ ಮೇಡಮ್ ಇದರಲ್ಲಿ ಪೂರ್ಣಿಮಾ ಮೇಡಮ್ ಇದರಲ್ಲಿ ಹೂವಾ ಬಳದೇ ಇಲ್ಲ ಅದು 45 ಸರ್ 45 ಒಂದು ಹೇಳ್ತೀರಾ ಸರ್ ಅದೊಂದು ಉಳ್ಕೊಂಡಿದೆ ನಿಮ್ದ್ರಲ್ಲಿ ಅರ್ಜೆಂಟ್ ಮಾಡಿ
ದಯವಿಟ್ಟು ಇನ್ಶಿಯಲ್ ಮಾತ್ರ ಯಾವ್ದು ಹಾಕ್ಬಿಡಿ ನಾನ್ ಮಾಡ್ತೀನಿ ಇನ್ಶಿಯಲ್ ಹಾಕ್ತೀನಿ ಖಾಲಿ ಬಿಟ್ಬಿಡಿ ಎಲ್ಲ ಅದು ಅರ್ಜೆಂಟ್ ಮಾಡ್ಬಿಡಿ ಪಟ್ಕ
ಕನೆಕ್ಟೆಡ್ ಏನಾದ್ರು ಬೇರೆ ಆಗಿದ್ರೆ ಅದು ಡಿಸ್ಮಿಸ್
ಎರಡು ಡಿಸ್ಮಿಸ್
ಅದನ್ನ ಈಸಿ ತಗೊಂಡಿದ್ದೀವಿ ನಾನು ಅವ್ರಿಗೆಲ್ಲ ಹಗುರವಾಗಿ ಮಾಡಿರ್ತೀನಿ ಇದೆಲ್ಲ ಅರ್ಜೆಂಟ್ ಅಂತ ಅವೆಲ್ಲ ನಮಗೆ ಬಂದಿಲ್ಲ ಆಮೇಲೆ 57 ಮಾಡ್ದಲ್ಲ ಬರುತ್ತಲ್ಲ ಈಗ ಸ್ಲೋ ಆಯ್ತು
ಮೇಡಮ್ ಕಡೆ ನಿಮ್ಮ ಕಡೆ ಫೈಲ್
ಇಲ್ಲ
ಡಿಸ್ಪೋಸಲ್ ಎಲ್ಲ ಕೊಟ್ಬಿಟ್ಟು ಇಲ್ಲೊಂದು
ಎಲ್ಲ ಅಪ್ಡೇಟ್ ಮಾಡಿದ್ವಿ ಒಂದು ಉಳಿದಿಲ್ಲ ನಿಮ್ಗೆ ಅಪ್ಡೇಟ್
ಹೌದಾ ಓಕೆ ಓಕೆ
ನಥಿಂಗ್ ಇಸ್ ದೇರ್ ಇನ್ ಬಾಕ್ಸ್ ಖಾಲಿ ಇದೆ
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್
ಎಲ್ಲ ಮುಗಿದಿದೆ ಡಿಸ್ಪೋಸಲ್ ಲಿಸ್ಟಿಗೆ ಇದು
ಎಷ್ಟು ಬರ್ತಾ ಇದೆ ಎಷ್ಟು ಬರ್ತಾ ಇದೆ 11 ಬರ್ಬೇಕಲ್ಲ
ಅದೇ ಬರುತ್ತೆ ನಮಗೇನೋ ಎರರ್ ಇದೆ
ಹೊಸದು ಓಪನ್ ಮಾಡ್ಕೊಳ್ಳಿ ಪೆರಿಫೆರಿನ ನೀವು ಆರ್ ಟಿ ಎಫ್ ಬರ್ದ್ರಲ್ಲ ಅದೊಂದಕ್ಕೆ ಮಾತ್ರ ಇನ್ಶಿಯಲ್ ಹಾಕಂಗಿಲ್ಲ
ಅದಕ್ಕೆ ಹಾಕಿಲ್ಲ ಸರ್
ಹಾ
ಒಂದು ವೆರಿ ವೆರಿ ಸ್ಲೋ ಇದೆ ಓಪನ್ ಈಗ ಒಂದು 5 ಸ್ಲೋ ಆಗಿದ್ರೆ ಸರ್ವರ್ ಸ್ಲೋ
11 ಅಲ್ವಾ ಮೇಡಮ್ ಡಿಸ್ಪೋಸಲ್
ಅದೇ ಸ್ಲೋ ಇದೆ ಯಾವ್ದು ಸ್ಲೋ ಎಲ್ಲ ನೋಡಿ
ಹೊಸದಾಗಿ ಹಾಕಿದ್ರು ಅದೇನೆ
ಈಗ ನಾ ಬಂದ ತಕ್ಷಣ ಎಷ್ಟಾಗಿದೆ ನೋಡಿ ಸರ್ 47 48 ಇಟ್ಕೊಂಡಿಂದ ಬರ್ತೀನಿ ನಾನು ಇದನ್ನು ಹಿಡ್ಕೋಬೇಕು ಮುಂಚೆ ಎಷ್ಟಾಗಿದೆ ಸರ್
ನೀವು ಬಂದ್ಮೇಲೆ ಎಷ್ಟಾಗಿದೆ
ನಾನ್ ಬಂದ್ಮೇಲೆ 47 48 ಇಟ್ಕೊಂಡು 8 ಆಗಿದೆ ಅಂದ್ರೆ 3 ಆಗಿದೆ
4 5 6 ನೀವು ಬರಕ್ಕೂ ಮೊದಲೇ 6 ಆಗಿದೆ
6 ಇಲ್ಲ ಸರ್ 48 ಗಿಂತ ಮುಂಚೆನಾ
ಅಲ್ಲಲ್ಲ
47 48 ಇಟ್ಕೊಂಡಿದ್ದೀರಾ ಸೀರಿಯಲ್ ನಂಬರ್
ಹಾ
ಇಟ್ಕೊಂಡಿದ್ದೀರಾ ಹಂಗೆ ಅದು ಬಿಟ್ಟು ಕೌಂಟ್ ಮಾಡಿ
49 ಇಂದ ಅಲ್ವಾ ಬಂದಿದ್ದೀನಿ
ಹಾ 49 ಇಲ್ಲ 1 2 3 4 5 ನೋಡಿ ಸರ್ ನಾ ಬರೋಕ್ಕಿಂತ ಮುಂಚೆ 6 ಇದು 5
6 ನೀವು ಬರಕ್ಕೆ ಮೊದಲು 6
ಹಾ ಅದ ನಂತರ 5
11
11 ಅದೊಂದು ಕನೆಕ್ಟೆಡ್ ಇದೆ 12 ಆಗಿದೆ
11
ಕನೆಕ್ಟೆಡ್ ಕೌಂಟ್
ಇರ್ಲಿ ಇನ್ಶಿಯಲ್ ಯಾವ್ದು ಹಾಕಿಲ್ಲ ನಾನು ಹಾಕೊಂತೀನಿ
ಇದಿತ್ತು ಇವಕ್ಕೆಲ್ಲ ಹಾಕೊಂಡ್ ಬಂದಿದ್ದೀನಿ ನಾನು ಮಾಡಿದ್ದಕ್ಕೆಲ್ಲ
ಇನ್ಶಿಯಲ್ ಹಾಕಿದ್ದೀನಿ
ಆಮೇಲೆ ಅವ್ರು ಯಾವ್ಯಾವ್ದು ಒಂದೊಂದು ಇಂಟ್ರಿ ಮಾಡೋ ಎಕ್ಸ್ಟೆಂಡ್ ಅಂದ್ರಲ್ಲ ಅದಕ್ಕೊಂದೊಂದು ಹಾಕಿದ್ದೀನಿ ಫಿಟ್ ಮಾಡಿ
ಹಾಕಿದ್ದೀನಿ
ಉದಿದ್ ನೀರಿ
ನೋಡ್ತೀನಿ ಇದೆಲ್ಲ ಇರುತ್ತೆ ನೋಡಿ
ಅಡ್ವೊಕೇಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 82 ಇಂಟ್ರಿ ಮಾಡೋ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಅಂದ್ರಲ್ಲ ಅದಕ್ಕೆ ಹಾಕಿದ್ದೀನಿ
ಯಾವ್ದು ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಅಂತ ಬರ್ದಿಲ್ಲ ತಾನೆ ನೀವು ಇಲ್ಲಿ ಇಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಅಂತ ತೋರಿಸಿಲ್ಲ ತಾನೆ ಅದು ತೋರಿಸಬಾರ್ದು
ಇಲ್ಲ ತೋರಿಸಲ್ಲ
ಬರೀ ಅರ್ಜೆಂಟ್ ಅಷ್ಟೇ
ಬರಲ್ಲ ಸರ್
ಅವ್ರು ಅದನ್ನ
ಸಾಲಿ ಸರ್ ಬಂದಿದ್ರಲ್ಲ ಯಾಕೆ ತೆಗೆದ್ರು
ಯಾವ
ಇಲ್ಲ ಸರ್ ಇದು ಸರ್ವರ್ ಡೌನ್